Orders of the day, order du jour.
Affaires émanant des députés, considération.
Private members' business, second reading of Bill C-463, Discover Your Canada Act, in the name of Mr. Pachetti.
The Honourable Member for Saint-Léonard-Saint-Michel is not present to move the order as announced in today's notice paper. Accordingly, the motion will be dropped to the bottom of the order of precedence on the order paper. The sitting will be suspended until 12 noon. Okay.
She's just going to ring the bell.
Yes.
Ordre du jour.
Orders of the day. Government orders, government bills, commons.
5. Response to the Supreme Court of Canada decision in R versus Tse Act.
Mr. Nicholson, seconded by Ms. Raitt, moves that Bill C-55, an act to amend the Criminal Code, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Debate, the Honourable Minister of Justice.
Thank you very much, Mr. Speaker. I'm pleased to rise to speak about Bill C-55, which is a response to the Supreme Court of Canada's decision in the RVC case. This important piece of legislation would ensure constitutional compliance with Section 184.4 of the Criminal Code. The bill we debate today is the government's response to the April 2012 Supreme Court of Canada's decision in the matter of Her Majesty the Queen and Say. In this case, the Supreme Court held that Section 184.4 of the Criminal Code is conceptually sound, but that it's constitutionally invalid in its current form because it does not provide for an after-the-fact notification requirement to persons whose private communications were the object of a wiretap interception pursuant to Section 184.4. Now, the Court suspended its finding of constitutional invalidity until April 13, 2013, to provide Parliament with time to remedy the defects of the provision, failing which Section 184.4 of the Criminal Code would no longer be available to law enforcement agents. Now, with the introduction of this bill, I hope that its provision will receive the widespread support of all parliamentarians so that we can move forward with this essential investigative tool. Now, before considering the specific amendments proposed by the bill, I think it would be helpful for members to know the facts of the RVC case because they illustrate just how important Section 184.4 is in practice. And more importantly, they show just how critical it is that the police continue to have access to such an essential power in situations where every minute counts. Now, in the case I refer to, 3 persons were kidnapped one night in 2006. When the daughter of one of the alleged kidnapping victims began receiving calls from her father stating that he was being held for ransom, the police used the power provided to them under Section 184.4 of the Criminal Code to carry out interceptions of the communications without prior judicial authorization. It had become clear to them that the victims were at serious risk of being harmed and that a wiretap was the way to assist in providing critical information about the situation at hand. Now, since lives were at risk, the police could not afford to lose time by following the regular process and preparing all the paperwork required to obtain a regular wiretap judicial authorization beforehand. Neither could they, given the imminent danger involved, obtain an emergency wiretap under Section 188 of the Criminal Code. Now, Section 188, which does allow for a more streamlined process to obtain a temporary judicial authorization to intercept private communications, still requires some paperwork and the availability of a designated peace officer and a specially designated Superior Court judge. In the Say case, the police determined that there was no time to go through either the regular, elaborate wiretap process or the so-called emergency process to obtain the authorization to intercept the private communications. Accordingly, they relied on Section 184.4 of the Criminal Code to perform wiretap interceptions without a judicial authorization. Now, when the case went to trial, the accused argued that Section 184.4 was unconstitutional because it did not offer the usual privacy protections that are provided when a full-blown wiretap authorization is issued by a judge, and which is the mechanism that police usually rely on to intercept private communications. The judge found that, in the circumstances at hand, the use of a wiretap without judicial authorization could be justified. The court also held, however, that more safeguards should be built into Section 184.4 to ensure that this exceptional power was used appropriately. Now, the trial court was particularly concerned about the lack of any requirement for officers to, one, give notice to those persons whose communications has been intercepted, and two, to report their use of 184.4 of the Criminal Code. Now, as a result, the trial judge in British Columbia declared the provision unconstitutional and gave Parliament a deadline to remedy its constitutional shortcomings. Since then, trial-level courts in Quebec and Ontario have made similar rulings. Now, the Crown appealed the declaration of unconstitutionality in RVC directly to the Supreme Court of Canada, which, as I mentioned earlier, confirmed the constitutional invalidity of Section 184.4, but suspended the effect of that declaration until April 13, 2013. Now, the Supreme Court of Canada also provided some helpful direction with respect to privacy safeguards that could be added by Parliament to improve the provision. Therefore, the bill that we have beforehand amends 184.4 of the Criminal Code so that it remains available in life-threatening situations while offering appropriate privacy protections. Mr. Speaker, it's critical for members to also understand that Section 184.4 does not exist in a vacuum. It's part of a broader spectrum of wiretap powers provided for in the Criminal Code. Part 6 of the Criminal Code was created nearly 40 years ago in 1974. Entitled The Invasion of Privacy, Part 6 criminalizes the willful interception of private communications, subject only to a few exceptions. Part 6 contains numerous privacy protections and stringent tests to ensure an appropriate balance between investigative needs in pursuit of criminal justice and the privacy of Canadians. Now, the provisions contained in Part 6 of the Criminal Code have evolved from the two originally enacted types of authorizations, regular and emergency wiretaps, that's 186 and 188 respectively, to the 5 provisions for wiretaps that we have today. These 5 different types of wiretaps form a spectrum of police intercept powers that range from a high level of judicial oversight for the purpose of obtaining evidence of a crime, which could be described as investigative wiretaps, to no judicial oversight when the purpose is to prevent an imminent harm, or what could be described as preventative wiretaps. Now, Section 184.4 of the Criminal Code falls, of course, into that latter category. The preventative wiretap allows peace officers to intercept private communications without any judicial authorization in situations of imminent harm. It is designed to be used in order to prevent an unlawful act which a police officer believes on reasonable grounds would cause serious harm to a person or property. The peace officer also has to believe on reasonable grounds that the person whose communications are to be intercepted is either the person who plans to commit the offense that is likely to cause the harm, or the victim or the intended victim of the harm. Importantly, the peace officer must also rule out the possibility of obtaining any other type of wiretap authorization contained in Part 6. Now, 184 is designed to allow police to prevent serious harm to persons or property and to save lives in the most extreme cases. In high-stakes situations like bomb threats, every minute lost can be a game changer, and gathering evidence of the crime is a secondary consideration. However, this does not mean that this power is without any judicial oversight. As was recognized by the Supreme Court, while this provision, quote, allows for extreme measures in extreme circumstances, end of quote, the police know that their ability to intercept private communications without judicial authorization in exceptional circumstances under this section diminishes, of course, with the passage of time. Now, the court also noted that once they start wiretapping in such circumstances, the speed with which they can obtain the follow-up judicial authorization plays a role in assessing whether this section passes constitutional muster. If the police do not proceed to seek the appropriate authorization when circumstances allow, they risk non-compliance if they continue intercepting under Section 184.4. Thus, even in cases where the situation allows for an intercept under 184.4, given the imminent harm or danger, steps need to be taken to regularize the process, and the police need to start as soon as possible to prepare an application for a judicial authorization under Section 188 if there's still urgency, or through the regular process otherwise. This is exactly what happened in the Say case. 24 hours after having intercepted the private communications in accordance with Section 184.4 of the Criminal Code, the police obtained a judicial authorization to continue those interceptions. Now, given the broad spectrum of wiretap powers and the parameters within which the police operate in urgent situations, I hope that we can all agree that this is absolutely necessary for police to continue to be able to get these communications without judicial authorization in exceptional circumstances to prevent serious harm. But the Supreme Court of Canada has clearly said that in order to retain this essential tool in a way that does not contravene the Constitution, the privacy provisions provided in Section 184.4 of the Criminal Code need to be improved by requiring the police to notify after the fact persons who were the object of the wiretap interception. Now, this bill proposes not only to do this, but also proposes to add other safeguards in Section 184.4 consistent with our objective of ensuring the safety and security of Canadians while also protecting their right to a reasonable expectation of privacy. This critical balance is reflected in the bill. C-55 proposes an amendment that would require that persons whose private communications have been intercepted be notified of that interception once the interception is complete. As is currently the case in the Criminal Code for other wiretap authorities, C-55 would require that such a notification be provided in writing within 90 days of the interception unless an extension is granted by a judge. Notification ensures that those whose private communications have been intercepted will be made aware of that fact so that they can exercise important rights, including their right to a fair trial. Requiring after-the-fact notification for Section 184.4 is clearly what is required by the Say decision to pass constitutional muster. However, our bill goes further by proposing another safeguard to better protect the privacy of Canadians. Section 195 currently requires yearly reports to Parliament on the extent of the use of electronic surveillance. This provision provides a detailed list of information to be included in the annual reports. Now, by adding Section 184.4 to the list of wiretaps that need to be reported on this bill would require the Federal Minister of Public Safety as well as provincial attorneys general that they prepare each year a report on the use of this particular section, consistent with the existing reporting requirements under Section 195 for other types of wiretaps. As spelled out in the bill, the reports would include, for example, information about the number of interceptions, the number of notifications, the methods used, and the number of persons arrested whose identity became known to a police officer as a result of the interception. Now, if Parliament and the public in general know how and how often these powers are used, it will be possible to review their use on an annual basis, thereby assisting to ensure that these powers are only used in appropriate situations. This, in turn, would allow Parliament to make any adjustments if necessary. Another safeguard proposed by C-55 would limit the use of the Criminal Code to specific offences only. Currently, the law permits Section 184.4 to be used in respect of any unlawful act. While the unlawful act has to be one that would cause serious harm to any person or to property, the concept of unlawful act could be made clearer. And this is why the bill proposes to limit the use of 184.4 to the offenses listed in Section 183 of the Criminal Code. This is a limit that already applies to most other wiretap authorizations, and it would create certainty for police so that they could easily determine whether this investigative tool is available in the situation they're dealing with. Finally, the bill proposes to restrict the class of persons who can use this authority to police officers only. Currently, the authority under 184.4 is available to peace officers, which is defined in the Criminal Code to not include not only police officers, but also a wide range of officials, including fishery guardians, mayors, and customs officials. This proposed amendment accepts the Supreme Court of Canada's suggestion in RVC to consider whether the availability of the provision to peace officers generally might be overbroad. Now, the court declined to address this situation in the absence of a proper record, but that is not to say that it could come up in the future. In closing, Mr. Speaker, I believe that this bill will remedy not only the constitutional defect of 184.4 of the Criminal Code, but will enhance the safeguards associated with this provision that allows police to intercept communications without judicial authorization in situations where there is an imminent and serious risk of harm to any person or property. The amendments are specifically intended to reduce privacy concerns and increase accountability and transparency. Now, I hope this bill can be passed quickly in order to meet the April 13th, 2013 deadline imposed by the Supreme Court of Canada. Passing this legislation will ensure that we continue to have the tools necessary to obtain information required to deal with exceptional situations such as kidnapping, for instance, while at the same time respecting the privacy rights of Canadians. Mr. Speaker, I urge all the members of this House to give this bill its full support. Thank you very much.
Questions and comments? The Honourable Member for Gatineau. Thank you, Mr. Speaker. I want to thank the Minister of Justice for rising in the House to explain Bill C-55 to us. We appreciate that. We are all aware, Mr. Speaker, that there is a very tight deadline here. We're talking, obviously, about April 13th, 2013. And we know that the Supreme Court decision is almost a year old, that it had sent the government back to do its work, and now a few days ago, they've come forward with C-55, and this reminds me of when I was a university student, where sometimes we waited until the very last minute, and sometimes the results are good and good things come out at the last minute, but also sometimes you don't have the time to do what we call the checks and balances. And this is the question that I would like to ask the Minister of Justice, Mr. Speaker, and that is this: given the urgency of the matter and the fact that the government has done a 180 by pushing aside C-30, which was to resolve this problem, and the Minister of Justice has taken responsibility for C-55, and it's a perhaps more palatable bill. Has the Minister taken the time to talk to specialists within his department, that is Justice, to find out whether the amendments that are being proposed are consistent and in line with the information given to us by the Supreme Court in R versus C? Minister of Justice.
Mr. Speaker, I'm confident that the analysis that has been done with respect to this bill in fact goes beyond what was required by the Supreme Court of Canada. I indicated in my remarks a couple of minutes ago that we are limiting the application of this procedure to the offences listed in 183 of the Criminal Code. The Supreme Court of Canada actually was very clear on that. They said it doesn't have to be limited to 183 or indeed it could be any provision of the Criminal Code. So we went one step farther, and I think it provides some clarity in that. And again, getting the report to Parliament on a yearly basis, I think, in a sense, enhances and goes beyond what was absolutely required from the government. So the government has addressed the issue that were raised at the court level and particularly by the Supreme Court of Canada, but I think we've taken it one step further, and indeed those additional changes, like clarifying that this provision applies to police officers, which is a more narrow category than what was many times traditionally used in the criminal code and others pieces of legislation at the federal level. They would refer to peace officers. Well, again, even though in many occasions mayors do have responsibility with respect to keeping order in their communities, I think it was appropriate that it be limited to police officers. So we made that change. So I'm confident that we have met all the suggestions by the Supreme Court of Canada and that we've taken it one step further to protect privacy issues.
Questions and comments? The honourable member for Winnipeg North.
Yes, Mr. Speaker, I have a couple of actually relatively quick questions. The first one is in regards to what degree is a minister representing the Government of Canada obligated to ensure prior to introduction of legislation that there is some form of constitutional compliance? Does the government have a check in place to ensure that legislation that they're passing is in fact constitutionally compliant? The second one is related to the previous question, and that is, again, the minister, and we're talking about the bill is being introduced today. And in a very short period of time, only in relatively a few weeks, we're expected to pass this bill straight through the system. Now, the minister has had the opportunity to introduce this bill months ago, and one could accuse him of being negligent in terms of his own responsibilities by not bringing forward this bill in a more timely fashion that would have allowed for due diligence in the passing of this bill. So I'm wondering, why did it take him specifically so long to introduce the bill?
The Honourable Minister of Justice.
Well, Mr. Speaker, with respect to the constitutionality of the legislation that we introduce in Parliament, the procedures have been in place, quite frankly, since the early 1990s when his party formed the government. Again, very careful analysis goes into all pieces of legislation to comply with all aspects of the Constitution, be they the Charter, the Canadian Bill of Rights. And so, again, that's a process that's been in place for quite some time. And again, Mr. Speaker, I'm very confident and very supportive, of course, of all the pieces of legislation that we have brought forward. We've introduced this, Mr. Speaker. We have carved this out. This actually has been before Parliament. This was contained in another bill that was tabled before Parliament. But in the interest of moving this as quickly as possible, this bill has been hived off. It's been very specific. It's very straightforward. Again, and as the honourable members of the House know, there have been many areas, many bills in the justice area that we have pushed. I mean, I'd like to see them all get passed very quickly. Whether it was elder abuse, I wanted that one through in 2 days. I'd like to see that through because these are all very important. So I'm asking the House to have a look at this and give it its support.
Questions and comments? L'honorable député de Saint-Boniface.
Merci, Monsieur.
The honourable member. Thank you, Mr. Speaker.
The justice agenda put forward by this government and this minister in particular has been, bar none, one of the most impressive that I have ever seen. As a former police officer, of course, I look always very closely at these bills to see how they empower the police to do a better job to protect and preserve security in our communities. And I see that he's done it again by putting forward a bill that will give them the tools to, in fact, do a better job. And having said that, I've been approached a number of times by many organizations or individuals who want to be added to the designation of peace officer. In fact, transit bus drivers have approached me saying that they would like some measure of protection by being included. And so I'm quite interested in hearing from the Justice Minister about the importance of ensuring it's police officers who have the ability to use this tool as opposed to the more broad designation of peace officer. Thank you, Mr. Speaker.
The Honourable Minister of Justice.
Thank you. That was a very good question, Mr. Speaker, and very much appreciated. We wanted this bill to be as specific as possible and to be as clear as possible, Mr. Speaker. As I mentioned in answer to a previous question, we said specifically what sections of the criminal code this would apply to. We didn't just leave it as an open-ended any unlawful act, as it presently reads. We said that it must be contained within Section 183. That adds clarification to it. That adds preciseness to it. In addition, changing the definition as to who this power is available to, and indicating that it's to police officers and not peace officers, again, clarifies exactly what it is that we are addressing and the issues that we have at hand. I think that's important. I mean, this is an extraordinary power that is given in emergency situations. We want to be exactly sure who it is that has the ability to do that. That's number one. And as you know, Mr. Speaker, as I indicated, there are a number of safeguards in place after this provision. Here, we balance the rights of an individual, of course, to privacy, but on the other hand, we know that there are situations where there is imminent harm that must be addressed. I believe that this bill strikes that appropriate balance. And again, in answer to the honourable member, we wanted to make the provisions as clear as possible to who and to what this applies to. As I say, we go beyond, Mr. Speaker, the ruling on the Supreme Court of Canada. We've taken it one step further.
Question commentaire. The honourable member.
Questions and comments?
Westminster.
Thank you very much, Mr. Speaker, and listen with great interest to the Minister. I mean, in terms of any sort of justice agenda, when we see the cutbacks to crime prevention programs that this government has done, its refusal to keep its commitment on having additional police officers on the street, its refusal systematically to put in place a public safety officer compensation fund, even though Canadian police officers and firefighters have come to this hill now year after year after year and continue to get the back of the hand from this government. I think it's fair to say we don't take lessons from this government on criminal justice issues. But I think the question that's come up, the member from Gatineau raised it, and another member as well, is why this government is submitting this bill at the last moment. Now, they knew that C-30 was problematic. There was a big pushback from the public, and yet, even though they've had almost a year to bring forward these provisions, they're doing it a few weeks before the deadline expires. It seems to be improvised on the back of a napkin, Mr. Speaker, and I'd just like the Minister to stand up and explain very carefully to the Canadian public why we're getting this last-minute bill for something that the government has known about now for almost a year.
Well, Minister of Justice.
Well, Mr. Speaker, I completely reject the preamble to the honourable member's questions. I mean, Mr. Speaker, no government has done more to support law enforcement agencies across this country than this government, Mr. Speaker. Nobody has made it more of a priority, and I'll give good advice to the honourable member. He should take lessons from the Conservative Party when it comes to justice agenda. They should do that. It's in the best interests of the constituents that they represent. It's in the best interests of law-abiding Canadians, and it certainly is in the best interest of victims. Mr. Speaker, I never introduce a piece of legislation that I don't get asked by some of my colleagues or and members of the public victims group say, how does this affect victims in this country? And Mr. Speaker, and I'm so pleased and so proud of the fact that we have consistently been supportive and making sure that victims' interests are taken into consideration. Mr. Speaker, this bill is before Parliament. I know that we've had a lot of stalling on a lot of government bills before, Mr. Speaker, but I certainly hope this one gets everyone's support. We need it.
Reprise de débat.
Resuming debate. The honourable member for Gatineau. I would tend to say to the Minister of Justice, if you're looking for a favor from someone, be nice to that person, because it's going to take a lot of intellectual gymnastic to ensure that a bill as important as Bill C-55 undergo serious study. I can't believe that the Minister of Justice, Attorney General of Canada, is asking 307 other MPs in this House to have faith, close their eyes, and simply pass the legislation because the Supreme Court said Parliament had to do its homework. The official opposition is going to do its homework, is going to do serious work. Yes, I can tell the Justice Minister that we will support the bill so it goes before the Justice Committee, but that will not prevent us from doing our job on the Justice Committee. The Minister knows that we do our job and we are not systematically opposing legislation. And I don't want to hear this from any Conservative in the next 10 days. The committee needs time to study this bill, and I'm a serious person. if the government wants to respect the deadline set by the Supreme Court of Canada, we're not asking for a favor. The government is asking for a favor. If the government wants this process to go through quickly, and I can't believe it took the brilliant jurists of the Justice Department, I don't believe it took them 11 months to come up with Bill C-55. In reality, from the very start, there was a mistake. They thought that Bill C-30 could solve everything, that it was the silver bullet when it came to wiretapping. But I can't blame the minister because it wasn't his file. It was the security minister's file. Now they had to backtrack, and now a few weeks before the deadline, this is what they came up with. What this means, Mr. Speaker, because the Justice Committee will sit today, we will possibly start study on Wednesday, but maybe not, and so there might be 2 days of study left. So on this side of the House, we promise to study the bill seriously, and we will try to do so within the deadline. But I would ask the government to be open-minded, because they have not shown open-mindedness since the election of 2011. Sometimes the official opposition has really good ideas. We've got good suggestions. And now the government, which has egg on its face, for instance, in another Supreme Court case, R versus Coates, the court has said that there was a problem with that piece of legislation. And the Conservatives may have said, well, this was before they arrived to power. The provision 184.4 has been in existence since 1993, before the Conservative arrived to power. But I'm not here to point fingers. I want this issue to be settled, and the Supreme Court has been very clear. It said where the problem was, where it violated the charter, and gave the government a year to fix the problem. This way, the court gave the government a year to fill a legal void. So sometimes, and this is often why I put the question to the Justice Minister or to his officials, has the government conducted serious, in-depth studies before presenting some of their pieces of legislation? Some of those bills may be well-intentioned, especially if you read the titles of these bills, but because they're often drafted quickly, they create problems which the Conservatives' haste might have overlooked. And these problems may be picked up not within months or even half a year, but at a certain point, these problems will be picked up and will come back to haunt the Conservatives. Mr. Speaker, in my previous life as a lawyer, I tried to anticipate problems. I tried to look at any potential circumstance which might be problematic before I wrote up something. And as a jurist, that's what I did, and lawmakers should do the same. Some Conservative colleagues on the Justice Committee said that the courts will be there to correct our mistakes if we make mistakes. Well, that wasn't bad coming from the mouth of members of Parliament of the Conservative government who did not necessarily show a great deal of respect for the legislative branch. So for the government to say that the courts can fix the problem, well, I don't agree with that. It's not that I don't trust the courts, quite the contrary. I know that sometimes it is difficult to draft a bill, and sometimes it's difficult to do it right the first time, but I think that's something we should try to do. We should try to propose legislation in line with the Constitution and the Charter, and when we do that, we'll have done what we can, and then the tribunals can step in if necessary. So I would encourage all my colleagues in this House, before voting on Bill C-55, to read the bill, not necessarily the 50 pages in English and French, but at the very least to read the summary, because the summary clearly explains what the problem originally was with the provision in question. Because in the criminal code, if you go to the section in question, the violation of privacy. So even in the criminal code, we're talking about a breach of personal information. The Supreme Court of Canada said that some of the provisions related to Bill 184 are problematic and need to be fixed. So to anyone listening to me here, we're not talking about minor infractions. We're talking about serious infractions. We're talking about terrorism, sabotage, the violation of a person's privacy. We're talking about airport security, airline security, explosives, and so on and so forth. So there was a very long list under 183. However, these are very specific cases which fall under this section. That said, it has to be studied through the lens of the Canadian Charter of Rights. We have to make sure that any breaches to a person's privacy are conducted with certain safeguards. The court must find certain authorizations, and the police as well. And that was the problem with the previous section, 184.4, Mr. Speaker. Basically said that a person was authorized to engage in wiretapping, but that the wiretapped person would never know that they had been the subject to wiretapping. The Supreme Court said that was wrong, and it spelled out what had to be done to address the problem. It seems that the Supreme Court often has more respect for the government than vice versa. So the Supreme Court gave the government guidelines, fairly broad guidelines on how to address the matter. This means that we need to clearly think about what we want to pass in Bill C-55. I'm not sure whether Section 3 of Bill C-55 completely addresses the matter raised by the Supreme of Canada. It's not quite clear because the Supreme Court refused to address that matter since it had not been the object of debate before the court itself. So the court is very respectful of its own role. It said it did not have enough elements of information in the file to provide the government with even more detailed guidelines with regard to the definition. So we'll see in committee. We can study these matters more closely. We can ask questions of justice officials. We can ask questions of the minister to ask how the definition was reached, what underpinned the decision. So certainly we will have good discussions in committee. As well, I'd like to draw the attention of my colleagues to a provision, and I'm not talking about 184.4 anymore, but a provision which allows for the renewal of 3-month to 3-year renewals or extensions. Again, we're dealing with with privacy provisions. Is it reasonable to put a 3-year extension provision in the bill? Sometimes these bills seem quite straightforward, but in reality, when you start to look at the details, they are not. The devil is in the details, of course, and therefore, as legislators, we must make sure that we are doing our job, that we are doing it in all seriousness. Otherwise, Mr. Speaker, in 6 months or in a year, the Supreme Court will hand down another ruling which will say that we did not do our job. And then we'll have to go back to the drawing board. There will be debates in the House. There will be discussion on the committee with regard to the intent of lawmakers. Lawmakers, well, that's us. A lawmaker is not a disconnected theoretical being. We are the lawmakers. So when the court wants to know what the intent of the lawmaker was, they will go back to the debate. And there cannot be a full debate if the government introduces legislation at the last minute, especially when it comes to legislation as important as this, which deals with a person's privacy. So, because this is an important matter, we as lawmakers have to do our homework. We are not going to hold up this process, but let me again repeat to my friends across the way, they should have presented this bill much more quickly. Because they did so at the last minute, they will not be able to impose closure, which is something they usually love to do, to close down debate, because we won't have enough time to properly debate this bill in committee. Now the government needs the opposition to help them quickly move this bill through the process. On behalf of the opposition caucus, let me tell you that we do not stand in the way of the legislative process just for the fun of it. It's not the kind of attitude we have. That said, I don't think any of my colleagues will put up with speeches which say that the NDP is against victims. If I hear that again, trust me, I am going to not stop talking on the committee, and for such a long time that all the Supreme Justices will be replaced by the time I'm done. So let's do our homework. Let's do it in all seriousness so that we can tell Canadians that, yes, there is a section in the Criminal Code which deals with privacy rights, and that in light of the Supreme Court's ruling, we have made sure to put in law all of the necessary safeguards which a free and democratic society wants to have, and which will have been included in Section 183.3. So certainly the committee will study these issues. We will ask the right questions. We will solicit the right answers. We are not going to play games.
We're trying to find solutions, and I think that we probably can get out Bill C-55 within the deadline imposed by the Supreme Court. But I repeat, it's the government that waited until the last minute. And when you play around with serious issues like this, well, that's quite shameful, Mr. Speaker. Now, I won't hold it against the Minister of Justice, per se. This was an orientation error. They started in the wrong direction, and it took them a long time to admit that they were headed in the right direction, in the wrong direction with C-30. And now C-30 has been withdrawn. It's like a bad episode of a bad TV program. And when you find out, thank God it's been canceled, everyone's glad that C-30 was taken off the program schedule and replaced by C-55 partially. I don't want people to think that C-55 is a copy of C-30. Absolutely not. It focuses on doing what it was supposed to do, that is, address a specific section of the Criminal Code, 183 and following, to ensure the questions and rulings of the Supreme Court can be respected. I have colleagues who will talk about the various provisions of the bill. I was mentioning Section 184.4, which is being amended through Clause 3. That is probably the most salient section in RVC because it refers directly to the Supreme Court ruling, as well as the clause that talks about the delay in the wiretapping. I think that's Clause 5 of the bill, which talks about authorization and renewal to up to a maximum of 3 years. So you'll see that in Section 6, rather, of this bill. And more specifically, 196.1, an amendment to 196.1 of the Criminal Code, which talks about an initial delay of 90 days and the renewal under paragraphs X, Y, Z, up to and including 3 years. So these are all things that we have to take a look at in this context. The consequences are quite serious. There's also the definition of police officer. That's a little more worrisome because the Supreme Court stated this clearly. Without a sufficient documentation, one has to determine whether 184.4 can be excessive if it's carried out by peace officers other than police officers. The court only answers questions put to it. Since there was no question about the notion of who could wiretap, in this case peace officers, the Supreme Court said we won't make a ruling on something that we are not seized with, and that's to their honor. They're not there to give legal advice except when the government, regardless of the government's political stripes, lacks political courage and goes through the Supreme Court to be told what they can do about civil marriage of same-sex partners or anything else. That's one, or the Senate, or the right of secession of Quebec. That's often the strategy used by governments that don't want to get splattered politically, so they hope that the Supreme Court of Canada will wave its magic wand and solve the country's political problems, which is not often the case because they're very respectful of political power. That is our power to legislate, and that's exactly what the Supreme Court did in this case. So we have to see whether the new definition, which seems to me a little strange in its wording, it doesn't seem to me to be the usual language or wording. It says the police officer is an officer or police or any other person in charge of public peace. Well, the lawyer in me says that any other person is the kind of expression I don't like in any legislation that can affect privacy because it's vague. Could it be a security guard? I have a lot of questions about this. So a bill which, according to the minister, is so uncomplicated can be a little more complicated than it looks at first glance, and that's our job. Especially after the Supreme Court sends us back to the drawing board, I think that we should at least look at this. If we don't want to get an F from the Supreme Court, I think that we have to devote the time necessary to do this. So thank you, Mr. Speaker, and I'm prepared to answer questions. Questions and comments.
The honourable member for Winnipeg North.
Thank you, Mr. Speaker, and I appreciate the comments made by the member. And one of the issues that I've raised in the past and I posed in the form of a question to the minister is in regards to the government does bring in a series of pieces of legislation in which we've called into question in terms of even their constitutionality. Have they looked into it? Is it offensive to our charter and so forth? In particular, the Minister of Immigration, one could ultimately say, has brought in legislation that could easily be challenged in courts. And I'm wondering if she might want to provide a comment in terms of the responsibility of government ministers to do their homework prior to bringing in the legislation to ensure and provide assurances to the House, in fact, that measures that they are putting into law are, in fact, constitutionally compliant. And if she would like to provide comment on that.
Honourable Member for Gatineau. I'm very pleased to see that the Liberal Party is on board here. Last week at the Justice Committee, well, not last week, we were in our ridings, but the week before that, before the parliamentary break, I put a motion at the Justice Committee requesting that we review what's going on about that, because the answers we're getting from the government, especially from the Minister of Justice in my case, because he's the one I address most of the time on government bills or Senate bills, is to find out whether the test of 4.1 on the Department of Justice is being respected. Now, what's going on? The Justice Department experts tell the minister, give them some information on each of these bills. He can't answer that everything's just fine, thank you very much, for the simple reason that we have a lot of tests right now, test cases before the courts, and courts are reversing these decisions. So I don't think these Justice Department lawyers are imbeciles. I think that the government's risk tolerance is very, very high. Even if they think they'll lose 95%, they think that politically it's a good thing. So that's the impression we get that's being improvised, and that's regrettable, and it's certainly contrary to the fundamental principle of the rule of law in Canada.
Question et commentaire. La députée de La Salle.
The Honourable Member for La Salle-Mar. Thank you, Mr. Speaker. First, I'd like to thank my colleague for Gatineau and our justice critic for her exceptional work on this particular file at the Justice Committee. She's truly exceptional. So I'd like to find out from her, we've seen that we have to strike a balance in this kind of bill, balance between exceptional situations and the protection of privacy. So I'd like my colleague to tell us whether this bill achieves that balance, and if not, what would be her recommendations to that effect? The Honourable Member for Gatineau. Well, first of all, I thank her for the compliments. That's always very pleasant to hear. I love justice, Mr. Speaker. That's why I'm in politics, and it seems to me that that's what should guide us all, justice and social justice. But law is a passion for me. It allows us to look at these types of things. Now, how to strike a balance, that's always the question that we're faced with. That's the question that the Supreme Court had to answer in the context of the RVC case. Regardless of the gravity of the offenses, they arrived at the conclusion that there needed to be a way of informing the person who was wiretapped that they had been listened to. And that's what we're lacking under 184.4. I'm reasonably satisfied that that has now been introduced. The minister's right about that. The fact remains that there are a few minor irritants or questions. I shouldn't even say irritants, really. I have questions about the new definitions of who will be allowed to do certain things. We need clear, precise answers to that. That or other person is not precise enough, especially when you're talking about affecting privacy. This is a red flag for the courts. Just that section. As legislators, we cannot allow for any error here. We were warned in R versus C. I don't want us to have to be warned again and told, no, you didn't understand the thing, you didn't do the work we asked you to do. So that is the kind of balance we're seeking. I can't say I find it 100% in here. I hope the Justice Committee can do its job properly.
The Honourable Member for Burnaby New Westminster.
Thank you very much, Mr. Speaker. I know that the member for Gatineau loves law, and I know that she'd be an excellent Justice Minister after the 2015 elections. I'm sure that with her interest and expertise, a lot of things will change, because it has to be said that we're talking about a 20-day deadline. The government tabled this bill. We know that we only have 20 days, 20 sitting days for Parliament, for committees, between the time the government tables a bill that has been due for 10.5 months and just 20 days to do everything, to be sure that now we don't end up in the same situation we had before with a botched bill full of problems that will be rejected by the courts. As the member for Gatineau mentioned earlier, there are Conservative members who think it's normal. It doesn't matter if you table a botched bill. It doesn't matter if it's not checked out. It's up to somebody else to check it. Well, Mr. Speaker, our role and responsibility as members of Parliament is to check bills, to verify that they meet the objectives of the bill. So my question for the member for Gatineau is, why has this government been derelict in its duty? Why did it table this bill 20 days before the deadline? The Honourable Member for Gatineau. Mr. Speaker, I thank my colleague for Burnaby New Westminster. I think the answer to the question is quite simple and yet profound, in the sense that there's a bit of arrogance on the government benches, and I'm being polite by saying a little. There's a lot. They were so sure that they'd solve all the problems in the planet with C-30, they never took the pulse of the public. and they saw in all its splendor what it's like when the people are interested in an issue and when they do something that affects personal rights, privacy rights. I never saw anything like it. I'm very active in social media, Mr. Speaker, whether it's Twitter or Facebook or what have you. It was unbelievable to see the response. Everyone will remember the hashtag #TellVicEverything, and I won't specify the name of a member here, but it was sufficient to raise public ire and influence public opinion, rather than just agree. And, you know, there's nothing wrong with admitting you've made a mistake and do an about-face. That's being human. You have to realize that you'll be forgiven if you admit the mistake. And they tried for months to find a way out of this without admitting they were wrong. It's that lack of humility. That is why we end up with 20 days. It's not up to us. It's up to the government to comply with the Supreme Court decision. No one here in this House, on this side of the House, will be responsible. The horror of not managing to do this in 20 days. They're the ones putting us in this situation, and everyone has to understand that. We will do everything possible in our power to help them solve this, but they will need a little bit of the humility that they lacked over the months and the year that led to this situation. We have time for one very brief question and answer. Questions and comments. The Honourable Member for Pierrefonds-Dollard. Thank you, Mr. Speaker, and I thank my colleague for her passionate speech. I have a brief question. We looked at C-30, which was a disaster, as we said. With C-55, what must we make sure is done? What process has to be in place for C-55 to respect the Charter of Rights and the parameters established by the courts for the protection of privacy? The Honourable Member for Gatineau. Excellent question, Mr. Speaker. I think that the government, the minister, but the government has to allow its Justice Department officials to come before the Justice Committee and, when asked clear, precise questions on exactly that, tell us what their analysis was, what precedent they looked at. Did they look at this aspect or that? Is it balanced? And stop just coming up with the empty words we hear from the government side. Yes, we got the assurance. Well, the assurance of who? What? When? We need content. We need substance this time. This is not just a bill. This is a response to a Supreme Court test. Resuming debate. The Honourable Member for Lac-Saint-Louis.
Mr. Speaker, Bill C-55, the bill we are debating today, needs to be seen against the backdrop of Bill C-30, the government's Internet surveillance bill introduced in February 2012. When Bill C-30 was tabled, it crashed and burned, largely because the government failed to do its homework. Namely, the government didn't charter-proof the bill or listen to telecommunications service providers about the impracticality of some of Bill C-30's key provisions. Nor did the government properly gauge Canadians' views about such a bill in advance of introducing it. Finally, the Minister of Public Safety's mishandling of the beginnings of the debate in the House on Bill C-30, namely his hyper-partisan reaction to anyone who raised reservations about the controversial and likely unconstitutional aspects of the bill, added oil to the fire and de facto shut down the public conversation, thus foreclosing the possibility that the bill's problems might be remedied through amendment in committee, though many people doubt that the bill could be salvaged even that way, Mr. Speaker. In short, the minister's rhetoric killed the bill in its legislative tracks. One wonders also if the bill's fatal flaw, its inconsistency with charter principles, was tied to the rumor that the government no longer vets legislation against charter requirements in the drafting phase prior to tabling in Parliament. The government's decision to withdraw Bill C-30 begs a series of questions. First, was Bill C-30 needed in the first place? Second, if it really was necessary for public safety, why did the government withdraw the bill, given it has a majority in Parliament? As we've seen with budget legislation, the so-called stable majority Conservative government can and will do what it wants with its majority. To this government, the word majority means never having to say compromise. Third, given its decision to withdraw Bill C-30, does the government have the courage of its convictions, whatever their merits? Fourth, the fourth question, related to the first, is does the current criminal code, provisions, namely Section 184.4, provide law enforcement with the sufficient means to investigate and apprehend those who seek to exploit children on the Internet? By withdrawing Bill C-30, the government's answer to that question seems to be yes. I will come back to Section 184.4 in more detail in a moment, Mr. Speaker. Another related question that comes to mind, in light of the government's new focus on the costs of policing, is whether the Conservative government is in fact investing enough to give the police the resources they need to fight cybercrime. This may be the real crux of the issue, money for policing, Mr. Speaker. By not sitting down with the provinces to discuss extending and replenishing police recruitment funds, is the government undermining the current capacity of the police to fight cybercrime? Is the government abandoning communities and leaving them more vulnerable? For example, the Police Recruitment Fund was used in Quebec to beef up the cybercrime division of the Montreal Police Department. What will happen when federal funds dry up, Mr. Speaker? Is the RCMP spending enough on cybercrime? Or are fiscal constraints being imposed on it by this Conservative government, hurting its valuable work patrolling cyberspace, not to mention fighting the ever-complex problem of white-collar crime? These are the tough questions that the government needs to honestly ask itself. The safety of our communities and families depend on the answers to those questions. Bill C-55, which Liberals support, is a response to the Supreme Court's decision in Regina versus Tse, rendered by the court last April. The Supreme Court's decision on the constitutionality of Section 184.4 of the Criminal Code came shortly after the government's controversial tabling of Bill C-30 in the House. In other words, the court was deliberating on some of the issues at the core of Bill C-30 at the time the government introduced the bill. This begs the question, why didn't the government wait for the Supreme Court's decision before rushing to table Bill C-30? The government could have benefited from the wisdom of the court in its final drafting of the bill. Furthermore, given that the Supreme Court in April 2012 gave the government a full 12 months to rectify problems with Section 184.4 that made the section unconstitutional, why did the government wait till the very last minute, namely 2 weeks ago, to deal with this matter? As mentioned, Mr. Speaker, the Tse case was a test of the constitutionality of Section 184.4 in its existing form. Section 184 of the Criminal Code deals with emergency wiretapping or wiretapping in emergency situations. Section 184.4 is about the interception, without the normally required warrant, of private communications, including computer communications, in exigent circumstances. That is, in circumstances where interception is immediately necessary to prevent serious harm to a person or property, and a warrant cannot be obtained quickly enough to prevent the imminent harm. In other words, in situations where every minute counts. In the Tse case, the police in BC used Section 184.4 to carry out unauthorized interceptions of private communications when the daughter of an alleged kidnapping victim began receiving calls from her father stating that he was being held for ransom. The case brought before the Supreme Court was an appeal by the Crown of a trial judge's finding that Section 184.4 in its current form violates the Charter. The question the Supreme Court was asked to address was whether Section 184.4, as currently written, contravenes the right to be free from unreasonable search and seizure pursuant to Section 8 of the Charter relating to privacy rights, and if so, whether this section's constitutionality is salvaged by Section 1 of the Charter, that section which allows a charter right to be circumscribed if it is deemed reasonable to do so in a free and democratic society. In the earlier landmark decision, Hunter v. Southam, Inc., the Supreme Court determined that a warrantless search is presumptively unreasonable. In other words, the presumed constitutional standard for searches or seizures in the criminal sphere is judicial pre-authorization, that is, obtaining a warrant. In Regina versus Duarte, the Supreme Court found that, as a general proposition, surreptitious electronic surveillance of the individual by an agency of the state constitutes an unreasonable search or seizure under Section 8 of the Charter. However, as the Court said in its decision in Say, exigent circumstances are factors that inform the reasonableness of the search or authorizing law and may justify the absence of prior judicial authorization. In principle, it would seem that Parliament may craft a narrow emergency wiretap authority for exigent circumstances to prevent serious harm if judicial authorization is not available through the exercise of reasonable diligence. Thus, Section 184.4 is based on the accepted principle that, to quote the Court, the privacy interests of some may have to yield temporarily for the greater good of society. Here, the protection of lives and property from harm that is both serious and imminent. To further quote the Court in the Say decision, Section 184.4 contains a number of legislative conditions. Properly construed, these conditions are designed to ensure that the power to intercept private communications without judicial authorization is available only in exigent circumstances to prevent serious harm. To that extent, the section strikes an appropriate balance between an individual's Section 8 charter rights and society's interests in preventing serious harm. This reasoning is consistent with Justice Lemaire's observation in Godoy, quote, dignity, integrity, and autonomy are values underlying the privacy interest. However, the interests of persons in need of police assistance are closer to the core of the values of dignity, integrity, and autonomy than the interest of the person who seeks to deny entry to police who arrive in response to a call for help. The Court's main finding in Say is that Section 184.4 is unconstitutional because of the absence of a requirement to notify the person whose communications have been intercepted of the fact of that interception. This is in contrast to judicial authorizations obtained under Sections 186 and 188, where the subject of the interception must be notified within 90 days. While the Court refused to rule on the need to tighten the definition of peace officer under Section 184.4, arguing it lacked a proper evidentiary foundation to determine the matter, it did express reservations about the wide range of people who, by virtue of the broad definition of peace officer, can invoke the extraordinary measures under Section 184.4. The term peace officer currently includes mayors, bailiffs, prison guards, etc. Liberals nonetheless support the government's initiative in Bill C-55 to narrow the class of individuals who can make an interception under Section 184.4 to mean police officers only, meaning an officer, constable, or other person employed for the preservation and maintenance of the public peace. Although we wish to know if this narrowed class also includes private security guards of the type contracted more and more by municipalities to fill the reduction in their regular police coverage when regional municipalities, for example, cut police budgets or reassign police to other geographic areas. Similarly, while the Court ruled that there is no constitutional imperative for the government to report to Parliament on the use of Section 184.4, we believe the requirement in Bill C-55 that this be done is a positive step, obviously, as it provides an important safeguard needed to balance the interests of the state in preventing harm and prosecuting crime with the obligation to protect Section 8 charter rights. Finally, we are a bit puzzled, however, as to why Bill C-55 limits Section 184.4 interceptions to the large number of offences listed in Section 183 of the Criminal Code. True, it was the opinion of Justice Davies, the trial judge, in Say, that indeed Section 184.4 should be limited to offences enumerated in Section 183. However, the Supreme Court, in the appeal, disagreed. Quote, there may be situations that would justify interceptions under Section 184.4 for unlawful acts not enumerated in Section 183. We prefer the conclusion of Justice Dambrot and Riley that the scope of the unlawful act requirement is sufficiently, if not more, circumscribed for constitutional purposes by the requirement that the unlawful act must be one that would cause serious harm to persons or property. No meaningful additional protection of privacy would be gained by listing the unlawful acts that could give rise to serious harm. The list of offenses in Section 183 is itself very broad. However, Parliament chose to focus upon an unlawful act that would cause serious harm. We see no reason to interfere with that choice. The serious harm threshold is a meaningful and significant legal restriction on Section 184.4 and is part of this Court's jurisprudence in a number of different contexts. This threshold is also consistent with the police practice surrounding Section 184.4. In conclusion, Mr. Speaker, it appears that Bill C-55 is an admission by the government that police forces already dispose of the necessary legal powers to act to intercept incidents of cybercrime involving children or terrorism for that matter. We are thus a bit puzzled as to why the government went ahead and introduced Bill C-30 only to withdraw it. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires?
Questions and comments?
For Burnaby, New Westminster.
Merci beaucoup, Monsieur le Président.
Thank you, Mr. Speaker. And it's very clear that we had earlier the presentation by the member for Gatineau that the problem that we see here today is in fact something that is tabled at the last minute. I said 20 days earlier, and in fact I have to correct myself, Mr. Speaker. It's 19 days because I had forgotten Good Friday, so that 19 days where this Parliament will sit, and the government wants it to get through all the stages, and in fact that it will be tabled in due form. We know that there will be flaws, as the member for Gatineau indicated. We will do our best, but it's really not professional to see the way the government is approaching this. I'd like to ask my colleague from Lac Saint-Louis two questions. First, what does he think about this last-minute tabling with 19 days only ahead of us on our parliamentary calendar for this bill? And second, given that this is a problem that goes back to a former Liberal government, why did the Liberals not address this issue when they were in power? Even the member for Montreal had expressed concern about that period. That is why they didn't make adjustments. The honourable member for Lac Saint-Louis. In fact, Mr. Speaker, I'm very disappointed with the behaviour of the government in this file. It's a government that seems to repeat its mistakes and takes its time picking up the pieces. And we are stunned that with regard to why the government has taken so long to introduce this bill, I think it's because it really wanted to distance itself as much as possible from the controversy surrounding C-30. And with regard now to the Liberal government 7 years ago, I was not in cabinet, so I do not know what debates were held about a similar legislation that might have been debated around the cabinet at that time, so I am unable, unfortunately, to comment on the reasons for that. Thank you, Mr. Speaker.
Questions and comments. The honourable member for Ottawa South.
Thank you, Mr. Speaker. My question for my colleague builds on some of his early comments about the government's pattern of behaviour in bringing forward legislation which it knows to be unconstitutional. I'd like him to address this and take into account three things. First, the government's already been found in contempt by the Speaker of the House of Commons for the first time, not just in Canadian history, but Commonwealth history, for not bringing forward costs on crime bills. The second thing I'd like him to take into account is there's a legal duty on the Minister of Justice to, in fact, bring forward legislation that is deemed to be constitutional. And I would argue, Mr. Speaker, it goes further because, as a lawyer, that Minister of Justice is bound as an officer of the court to do so. And thirdly, the third factor, David Dobney, a former Conservative member of Parliament, who used to head up the Criminal Law Policy Unit for the Department of Justice, the day after he retired, assaulted the government for basically forcing that unit to not be able to deliver up options which they told the government would be constitutional with their crime bills. Why this pattern, Mr. Speaker, to my colleague, of this kind of deceptive and unacceptable behaviour?
Honourable member for Lac Saint Louis.
Well, I wonder, Mr. Speaker, I thank the honourable member for that series of questions, and I recognize his expertise in the law. He has a tremendous and lengthy experience in the legal profession. I, on the other hand, am not a lawyer, but I will attempt to answer his questions the best I can. I think it's because the government's in a permanent campaign, and therefore it thinks that it can simplify and spin with a view to scoring political points. And I think, when you're dealing with important legislation after the campaign is over, you should put that attitude on the shelf. I think it's time to get down to serious business. On the other matter of whether the minister is properly vetting legislation or instructing his ministry to vet legislation against charter principles, if I were the Minister of Justice, I won't be because I'm not a lawyer, I know that, but if I were the Minister of Justice and my Prime Minister said, look, let's not worry about charter concerns, we'll adopt the sue me later attitude, I would say to the Prime Minister, respectfully, sir, I can't do that. My professional ethic makes other demands on me. Thank you, Mr. Speaker.
Questions and comments?
The honourable member for Pierrefonds-Dollard. Thank you, Mr. Speaker. And I want to thank my colleague for that question. I'd like to know, he's just told us what he would do if he were Minister of Justice, and we're not yet there. I'd like to ask him a question as a member working on the justice file, however, because we know that there was Bill C-30, which appeared and was almost scandalous, if you will. The NDP wants to make sure that the bill before us, Bill C-55, respects the Charter and the new parameters to protect privacy that were established by the court. According to my colleague, what should be done with regard to the study of C-55 to make sure that, yes, the Charter is being respected and the bill also respects privacy rights? What processes, what should be done before we pass the bill? The honourable member for Lac Saint Louis. I want to thank my colleague for that question. I have read the Supreme Court decision carefully with regard to the R versus HoC, and based on the reading of the decision, with Bill C-55 in hand as well, I understood that C-55 does respect the directives given by the court with regard to respecting privacy. There are some sentences in the bill that concern me, and the member for Gatineau raised one of them. When we talk about peace officer, does this include private security agents? Is it a very broad definition? So I expect the government will agree to have experts come and testify before the committee, and I would invite the government to give the latitude that these experts will need in order to really address this issue. Thank you, Mr. Speaker.
Comments? The honourable member for Charlottetown.
Thank you, Mr. Speaker. First of all, I'd like to thank my colleague from Lac Saint Louis for his speech. He indicated that he would be and we would be supporting this bill to send it to committee. Two specific questions. One, any advice that he can provide to the committee that will be studying the bill in terms of specific amendments or areas for improvement to the bill. And secondly, a comment, if he would, on the extent to which the drafters of the bill have heeded the advice of the Supreme Court of Canada. So is all of the advice contained in the SAY decision incorporated into the bill, or is there potential room for improvement there? Thank you, Mr. Speaker.
Member for Lac Saint Louis.
Thank you, Mr. Speaker, and thank you to my colleague, who is also another fine member of the bar. Based on my reading of the decision, yes, the bill responds to the concerns expressed in the decision, to the directives in the decision. However, as I mentioned in my speech, I'm a little curious as to why the government went further in some way than the court requested when it comes to the applicability of Section 184.4 to offences. And by that I mean the court said, look, you don't have to say that 184.4 applies exclusively to the offences in Section 183. The court was quite clear on that in the decision. Yet the government seemed to narrow the scope of 184.4 to only those offences. And I'm wondering if the government really wants to prevent harm to persons or property, why isn't it taking the broader perspective that the court recommended?
Resuming debate, the honourable member for Burnaby, New Westminster.
Thank you very much, Mr. Speaker. From the outset, I'd like to say that I would like to share my time with the outstanding MP for Halifax, who will take up the second half of my time, so we'll all have the opportunity to hear from the member. I would like to thank the member for Gatineau, who gave an excellent presentation on this matter, which, in fact, we will support. We'll support it at second reading. But we find it quite extraordinary, Mr. Speaker, that here we have a government which tables a bill, even though it's known for a year that changes had to be made. So they didn't do anything for a year. Then they tabled Bill C-30, which had been rejected by Canadians, even though the Conservatives attacked people who were against that legislation. But eventually, thankfully, the pressure by Canadians forced the government to withdraw that bill. So now we have Bill C-55, which is being tabled 19 days before the deadline imposed by the Supreme Court. The deadline is April 13th, 2013. So we have 19 days to have the debate on second reading, 19 days in total to also study the bill in committee, 19 days to hear witnesses, and to study the bill clause by clause. Now, will this lead to the Supreme Court being seized by the bill another time? 19 days for third reading as well. Half an hour's worth of discussion. Will that be enough? 19 days. This is absolutely ridiculous, when in fact we've known for 1 year that the government had to do its homework. Yet again, the government did not do its work well. And this is not the first time, Mr. Speaker, and that's our problem. As the member for Gatineau said so well, we're getting all kinds of bills which have been cobbled together, which have not been drafted well. And when the House doesn't have time to do its work, when witnesses don't have time to testify in committee, when MPs don't have time to study a bill clause by clause and to make any necessary changes based on what witnesses have said, well, as a result, this government, as it has done systematically in the past, it imposes closure, and even though the bill has been cobbled together, forces its adoption, and then taxpayers have to pay the courts to see whether the bill stands up or not. When the government shows disrespect to opposition MPs, well, Mr. Speaker, all of Canada pays, because the Supreme Court has had to review several bills which had been cobbled together. And it seems there's another one coming down the pipe. The Conservatives are not changing their behavior. They're still acting this way. They will introduce any kind of bill in the House, cobbled together any which way. And when they do that, what happens is that taxpayers end up paying more money to make sure that these cobbled together bills are fixed and made right. And this would all be unnecessary if the Conservatives had done their homework right from the start. I think Canadians are sick of this, Mr. Speaker, and I think that's why more and more Canadians are looking forward to 2015, when they will be able to vote the Conservatives out of power and vote in a government which will introduce well-thought-out bills, a government which will listen to witnesses, a government which will adjust its legislation, because in a democracy it takes time to listen to the points of view from across the country. It takes time to improve on a bill. So the government, through its irresponsible attitude today, is in fact presenting legislation under a very tight deadline, namely 19 days. If the government is not cooperative, if the government tries to impose its point of view, we again are going to end up with a Conservative bill which will be carried before the courts. And we've heard this morning, and this has been the case in the past. And this is not what Canadians want. They want Parliament to do its job well. They want Parliament not to rush through its business.
So, Mr. Speaker, we now have 19 days to put forward this piece of legislation. 19 days to get through every single level of speaking, to get through hearing from witnesses, to get through all of this work, Mr. Speaker. And all of it would have been avoided if the government had simply done its work a year ago. After the judgment that came forward from the Supreme Court, they could have moved forward in a responsible way. They chose not to, Mr. Speaker. And yet again, you got Conservatives basically asking the NDP to fix the mistakes that they've made, Mr. Speaker. I think so many Canadians looking forward to the day when we won't have to have Conservative mistakes fixed, that we'll have an NDP government that can bring forward legislation that actually meets that test, Mr. Speaker, and receives the consent of the population. And I want to say, Mr. Speaker, because I want to talk on the broader justice agenda as well. This is part of this C-55, and this is symptomatic of just how bad the Conservatives are on justice issues, Mr. Speaker. Now, we had crime prevention programs in this country. They were doing a remarkable job. And, Mr. Speaker, crime prevention programs are good investment for Canadians. You put $1 into crime prevention, you're saving $6 later on in policing costs, and court costs, and prison costs. So every buck you put in to crime prevention, you see a $6 return. And more importantly, Mr. Speaker, you don't see victims because the crime is never committed in the first place. And that has always been the foundation of how the NDP have approach justice issues. Well, what did the Conservatives do, Mr. Speaker? They've gutted crime prevention programs. They've destroyed them across the country. In my area and elsewhere, they have gutted the funding that allowed crime prevention programs to stop the crime before it's even committed, to stop having a victim because the crime is not committed. And in addition, Mr. Speaker, saving $6 for every dollar we've spent into crime prevention later on in those policing costs, in those court costs, and those prison costs. Well, Mr. Speaker, they've done far more. I mean, in a negative way for Canada. I mean, in terms of the whole issue of putting more frontline police officers into place, certainly our former leader, Jack Layton, made that commitment before the last election. So did the Conservatives. What have they done? Nothing, Mr. Speaker. They've failed in that frontline policing duty. And I think most egregious, Mr. Speaker, and I'm going to conclude with this, is the Conservative, there's only one way to put it, complete lack of respect to our nation's police officers and firefighters on the Public Safety Officer Compensation Fund, Mr. Speaker. You'll recall 6 years ago, before the Conservatives were elected, they voted and they committed to putting in place a Public Safety Officer Compensation Program so that when our nation's police officers or firefighters are killed in the line of duty, killed protecting the Canadian public, that their families would be taken care of. Mr. Speaker, since that time, I've talked with families that have lost their homes, kids who've had to quit university, spouses that have had to try to put something together to keep the family together, because these Conservatives, Mr. Speaker, broke their promise to the nation's police officers and firefighters for 6 long years now. Firefighters and police officers have been coming to Parliament Hill for 6 long years. Conservatives have given them nothing more
than the back of their hand. And I think that's deplorable, Mr. Speaker. I can tell you right now, in 2015, there's an NDP government elected. What you're going to see is respect for the nation's police officers and firefighters. You're going to see in place a public safety officer compensation fund. You will never see again, Mr. Speaker, the families of our nation's police officers and firefighters left to fend for themselves because the federal government doesn't respect them and doesn't care about them, Mr. Speaker. So we take a different approach on these issues. We actually believe that bills should be brought forward in the House of Commons in a respectful way, that we should hear from witnesses, improve the legislation, and make sure that it's not the type of legislation that then is subject to court challenges just to fix the mistakes this government has made, Mr. Speaker. We would take a lot more mature and a lot more professional approach to justice issues, Mr. Speaker. Like so many other Canadians, I can hardly wait for 2015. Thank you very much, Mr. Speaker.
Questions and comments? Questions et commentaires? Honourable député de La Salle-Aymar.
The honourable member for La Salle-Aymar. Thank you, Mr. Speaker. I'd like to thank my colleague, who, as always, shows his passion for the legislative process and who, in fact, points to the government's failings with regard to making legislation and with regard to giving Parliament enough time to study legislation, and which introduces huge bills. Once again, time is being limited for debate because the government has taken its time to introduce legislation. This reminds us of all the times where debate was cut off on other bills. This is the same tactic but used in a different way.
Merci beaucoup.
Thank you very much. I would like to thank my colleague for La Salle-Aymar. She is a very strong performer in the House. She defends her fellow citizens and she defends her fellow Canadians. And I greatly appreciate her work in the House and the question she just asked. And that precisely is the question, Mr. Speaker. I know that fewer constituents in my riding are voting Conservative, and even fewer intend to vote Conservative during the next election. Why? It's because of this type of legislation. These bills introduced by Conservatives are thumbing their nose at parliamentarians because these bills are the object of legal action before the courts, and when that happens, taxpayers are the ones who have to pay. They're the ones who have to pay for fixing problems. Even though we might agree with the principles of certain bills, some of these bills are so badly written, so badly cobbled together that taxpayers have to see more of their money spent to fix the mistakes of the Conservatives. And, Mr. Speaker, Canadians deserve better. Questions and comments?
The honourable member for Nickel-Belt.
Thank you, Mr. Speaker, and I certainly would like to congratulate my colleague from British Columbia. It was an awesome speech, and he talked about the police officers and firefighters and all of the promises that the Conservatives made 6 years ago. And you could hear them yip-yapping in the background. You can still hear them now. And now they have a chance to get up and ask you questions, but they're not. What do you think is happening over there on the other side? Are they maybe ashamed of having promised these firefighters and police officers to do something to help their families out, but now it's time to do it and they're not doing anything? Can you give me your opinion on that, please?
The honourable member for Burnaby New Westminster.
Well, I thank the member from Nickel-Belt. He's a terrific member to work with. I worked with him on the Natural Resources Committee, and he's been a very strong representative for Nickel-Belt in the House of Commons, very eloquent, very knowledgeable. And so I appreciate his question, and it is absolutely shameful treatment, Mr. Speaker. Absolutely shameful treatment for the Conservatives to have voted for the NDP bill, to bring it in, to promise in the election campaign that they would bring it in, and then for 6 years to say to police officers and firefighters who are just saying, can you take care of the families when we pass on? When I die in the line of duty, can you take care of my family? Is that too much to ask, Mr. Speaker? That they don't have to sell their homes, that the kids don't have to quit school, that they're actually taken care of by a grateful nation, Mr. Speaker. That's what New Democrats stand for. That's what Canadians stand for. Respect for our nation's police officers and firefighters. And I have no doubt that Conservatives should be ashamed of the type of behaviour they've exhibited over the last 6 years in giving the back of their hand to firefighters and police officers in our country.
Resuming debate, the honourable member for Halifax.
Thank you, Mr. Speaker. And I'd ask that you could give me a heads up when I only have a couple minutes left between the bill and the case and all this paperwork in front of me. I might be a bit buried. Before I really get started on this bill, I just want to note the heckling from the other side about hug a thug and all that kind of nonsense. And I got to say, it's pretty depressing to be here and hear that kind of talk when it's very clear that the hecklers on the other side haven't actually even read this legislation and don't even really know what it's about. This is a pretty serious thing in front of us. This is a decision from the Supreme Court of Canada that's come down that has instructed Parliament to change the Criminal Code of Canada. So let's do an actual legal analysis of this bill. And we'll start with the Charter of Rights and Freedoms. Specifically, let's start with Section 8, which provides that everyone has the right to be secure against unreasonable search and seizure. Very few words, but there's a lot packed in that section. So the courts have held that a search without a warrant is unreasonable. And the standard for determining whether a search is reasonable, you actually have to bring it before a judge. You have to have a neutral and impartial party, like a judge, who can determine if a search is unreasonable. But the courts have noted, in particular Justice Dixon and Hunter v. Southam, that, quote, it may not be unreasonable in every instance to insist on prior authorization in order to validate governmental intrusions upon individuals' expectations of privacy. Nevertheless, where it is feasible to obtain prior authorization, I would hold that such authorization is a precondition for a valid search and seizure, end quote. But there is also a long line of case law that states that judicial authorization can actually be waived if there's potential for serious and immediate harm or exigent circumstances. And I use those words purposefully, serious and immediate harm. So, for example, you call 911 and the police are actually permitted to enter your home without a warrant. Why? Because it's been held that the police duty to protect life warrants and justifies a forced entry into your home in order to figure out if you're safe, in order to figure out if you're okay. So what we have here is Section 184 of the Code says that violations of privacy are against the law, but then we say that this can be violated or waived in a way with judicial authority, but judicial authority can be waived if there's potential for serious and immediate harm. That's sort of the chain of thinking. Bill C-55 that we have before us is an attempt to update the wiretapping provisions in the Criminal Code, Section 184.4. Why? Well, the government is making an attempt to update the code after the Supreme Court of Canada, in their decision RVT, they struck down the wiretapping provisions in the Criminal Code because they violated Section 8 of the Charter that I described, the right to be secure against unreasonable search and seizure. It is worth noting, I think, that the court gave us the deadline of April 13th, 2013 to correct the decision, but here we are in February 2013 debating this legislation. But I move on to the analysis. Before we can analyze C-55 and the government's proposal, we need to take a quick, not a quick look, we need to take a close look at what the Supreme Court said about Section 184.4. We need to understand the problems with 184.4 and why it was struck down if we're going to be able to understand if this attempt by the government actually fixes those problems or if we're going to have the same constitutional problems. The court did state that, in principle, it seems that Parliament may craft a narrow emergency wiretap authority for exigent circumstances to prevent serious harm if judicial authorization is not available through the exercise of reasonable diligence. Lots of words, but let's unpack it. When Section 184.4 made its way through Parliament in 1993, we heard testimony at committee. I wasn't there. But there was testimony at committee about the need for this kind of emergency power for situations like hostage takings, bomb threats, and armed standoffs. So pretty serious situations. There was also testimony that this was necessary for very short periods of time, during which it might be possible to actually stop that threat and prevent harm from occurring. So if we go back to the wording of 184.4, peace officers, and I'll return to the phrase peace officers later, peace officers may only use the power to wiretap without judicial authority if they believe on reasonable grounds that the urgency of the situation is such that authorization could not, with reasonable diligence, be obtained under any other provision in the part. So there's 4 key concepts there, Mr. Speaker. What happened? Supreme Court of Canada actually did find that Section 184.4 does not meet accountability standards because it doesn't provide any accountability measures. Because if we think about it, wiretapping is not at all like a 911 emergency call. And I actually want to quote something from the decision here that's important. The Supreme Court of Canada quoted Justice Davies, who I believe is wrote the Court of Appeal decision. Quote, "The interception of private communications in exigent circumstances is not like situations of hot pursuit, entry into a dwelling place to respond to a 911 call, or searches incidental to arrest when public safety is engaged. In those circumstances, the person who has been the subject of a search will immediately be aware of both the circumstances and the consequences of police action. The invasion of privacy by interception of private communications will, however, be undetectable, unknown, and undiscoverable by those targeted unless the state seeks to rely on the results of its intentionally secretive activities in a subsequent prosecution." So if it actually comes out in court. But end quote in there somewhere. You could actually have a wiretap against you and never know it. There's no accountability here. Another piece that the Supreme Court quoted, actually, was the intervener of the Criminal Lawyers Association. I think this is really interesting. "Notice is neither irrelevant to Section 8 protection, nor is it a weak way of protecting Section 8 rights, simply because it occurs after the invasion of privacy. A requirement of after-the-fact notice casts a constitutionally important light back on the statutorily authorized intrusion. The right to privacy implies not just freedom from unreasonable search and seizure, but also the ability to identify and challenge such invasions and to seek a meaningful remedy. Notice would enhance all these interests. In the case of a secret, warrantless wiretap, notice to intercepted persons stands almost alone as an external safeguard." So as you can see, Mr. Speaker, it's not at all like a 911 call, and you need to have notice. And as was pointed out, notice after the fact is still notice. There needs to be an accountability provision, and the Supreme Court of Canada found that Parliament actually failed to provide adequate safeguards to address the issue of accountability in relation to unwarranted wiretaps. And then they went on to outline why this charter breach was not saved by Section 1 of the Charter. Thank you, Mr. Speaker. So we were tasked with drafting a constitutionally compliant provision. When I say we, I mean Parliament. So how has the government attempted to deal with these accountability provisions? Well, they did introduce a new provision that the authorizations should be reported back to Parliament via the Minister of Public Safety. Mr. Speaker, like any law student, I took criminal law, but I'm far from a criminal law expert. However, it strikes me that this might actually be a creative way of addressing this issue, the issue of accountability. Offhand, I can't think of any similar accountability provisions like this, where the accountability problem is actually solved through annual reports to Parliament. It, in a way, reminds me a bit of a sunset clause where legislation is actually debated. It's brought back to the House for debate again. But at the same time, it's really quite different. And this way of dealing with the report, there are quite a number of details in Section 195 that would be introduced in Section 195 of the Criminal Code. It's interesting. It's potentially very creative. And I'm curious how this is going to work. my first instinct is to think that it just might work, but then I remember where I am in the House of Commons in the 41st Parliament with a Conservative government, a government that refuses to accept amendments to legislation, that invokes closure or time allocation to stifle debate, that buries important legislative policies and changes in omnibus legislation. I would like to see this bill go to committee not just to find out if this is a creative and interesting accountability solution that might work, but also would it work in the context of a government that has such disdain for parliamentary oversight? I can't say I have the answer to those questions right now, but I really do think that Canadians have good reason to be concerned about this legislation. The record on privacy is not very encouraging, and I do really very much look forward to the testimony at committee. Thank you, Mr. Speaker.
Questions and comments? Questions and comments? The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. And I want to highlight one of what we believe is a big issue with this government, and that is that of negligence in terms of procedures and the way in which it brings things into the House. And this is what the member was making reference to just as she started to wind up her speech. I think it is important that we recognize that the government now is expecting us to pass this through the House committee and back into the House and so forth between now and April the 13th. Now, that is not a reasonable time frame, but because the government was so negligent in not bringing this bill in a more timely fashion, that the type of due diligence that this House should be given to legislation of this nature is going to be put into question. Having said that, we see the benefits in terms of having it go to committee, but I wonder if she might want to provide comments in terms of just the time frame that this thing has to be passed by April 13th, and would agree that this is highly irresponsible of the government to have done it in such a poor fashion.
Halifax.
Thank you, Mr. Speaker. I really appreciate the opportunity to answer that question because I didn't have time to address it in my speech. As I stated, I don't have answers to the questions I raised here today, and I'm not sure we're going to be able to get to them in about 19 days. I think this is negligent attention to parliamentary duty here. I don't think that the government has acted. They did bring forward Bill C-30. We see a lot of the provisions of C-30 now in C-55, but C-30 was a total, utter, abject failure. And Canadians cried out against it, and rightfully, finally, government did withdraw that piece of legislation. But here we are. I mean, the clock is ticking. It's been practically a year, and now we have this legislation in front of us, and we're just supposed to say, oh, yeah, I guess so, and vote for it. That is not responsible decision-making. That is not responsible legislative making.
Questions and comments? The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable colleague from Halifax for her presentation. This obviously, compared to Bill C-30, this bill is focused. It's looking at the specific issues of how do we balance appropriately warrantless access to anything. And I stress warrantless. It's not as though our police forces, even prior to the criminal code sections that were found offensive by the Supreme Court of Canada in the recent court case, the idea of warrantless access is inimical to a democracy. It's a worrying thing to say you don't have time to go to a judge and get a warrant before intruding in somebody's affairs that you otherwise have no lawful access to that information. Clearly, in emergency situations, kidnapping and so on, we want police to be able to get everything they can to save lives. Does the honourable member for Halifax have any sense at this point whether the public report that will be required at the end of each year will be sufficient to meet the Supreme Court's concerns?
For Halifax.
Thank you, Mr. Speaker. I agree with my honourable colleague that warrantless searches like this are a worrying thing. But the courts have determined that, in principle, Parliament may, and that is a key word, craft a narrow, another key word, emergency wiretap authority for these kinds of circumstances. Will this report be the balance that we need for that extreme violation of our charter rights? Will it be the balance that we need? I can't answer that question. This is yet another reason why we have to get this to committee. We have to have the proper legal analysis, and we also have to have more than 19 days to get this done. I don't think that the government has allowed us to do our duty as legislators and properly review this legislation, looking at the time constraints that the Supreme Court of Canada has given to us. It is worrying. I absolutely agree with her on that point.
Nous avons le temps pour un bref.
We have time for a brief question and answer. Questions and comments. The Honourable Member for Gatineau. Thank you, Mr. Speaker, and I thank my colleague for her excellent speech. The Supreme Court examined this but did not look at the definition of peace officer. In her extraordinary analysis of the bill, did my colleague have any comments for us who will have to, or we who will have to look at it at the Justice Committee?
Being able to answer this question as well, because I didn't have a chance to get to it in my speech. But the Supreme Court of Canada did have a problem with the fact that this wiretap power could be granted to peace officers, non-police police officers. Government has, it seems, upon reading this bill, they have actually addressed that problem and narrowed it to police officers. So it potentially looks like a good step. Again, I look forward to the testimony at committee.
Resuming debate. The Honourable Member for Dartmouth, Cole Harbour.
Thank you, Mr. Speaker, and I'm pleased to have an opportunity to rise. I indicate that I'll be sharing my time with my colleague, the member from Portneuf-Jacques-Cartier. I want to, as I begin, I want to say how much I appreciated and enjoyed the presentation from the member from Halifax, who has the constituency adjacent to mine. And I know that she and her constituents enjoy looking across at the wonderful constituency of Dartmouth-Cole Harbour. But we were all certainly provided some wonderful information about the Supreme Court decision, which has led to Bill C-55. I want to because. I certainly do not have the capacity to engage in the type of legal analysis my colleague did, but I do have a bit to say on the whole question of legislative procedure and the need for all members of this House to understand what their responsibilities are and to be determined to ensure that they follow through on those responsibilities, so that each and every piece of legislation that is tabled in this House does not leave this House unless it has been fully examined, has been fully vetted, and that we've ensured that it is the best possible piece of legislation that it can be. Because these are the laws of our country. These are the laws that affect all of our constituents. These are the laws that will continue to exist long after we've left here, Mr. Speaker. And so it's incumbent upon us to ensure that we make sure that we dot the I's and we cross the T's and we understand that a piece of legislation is not going to leave here and immediately get struck down by the Supreme Court of Canada, for example. Because we did not show that kind of due diligence. And I got to tell you that understanding that this bill, which is a direct response to a decision by the Supreme Court of Canada, is being introduced in this House with a time limit which affords us 19 sitting days to deal with it. I mean, it's absurd, frankly, Mr. Speaker, that this government, in all seriousness, would be asking that of members of this House. That a piece of legislation that is as important as it is, that is as detailed and specific as it is, and that has such serious ramifications in terms of issues of privacy, in terms of issues relative to the jurisdiction of the Supreme Court of Canada, that they would expect us to deal with an issue of this magnitude in 19 sitting days. That works out to, I understand, in the area of 2 days of the Justice Committee to be able to examine this important piece of legislation. And let's not forget that this government does not have a very good record when it comes to issues of privacy. When it comes to introducing legislation and trying to ram it through this House, and then later we've already seen some of their justice legislation that has been struck down, provisions of it, seriously questioned by some of the courts in this land, Mr. Speaker. We know what happened to the bill that was supposed to take care of this. The bill that preceded this, Bill number C-30, that was tabled a little more, approximately a year ago, in this House, that was torqued up by the minister who tabled it in such a partisan and frankly a mean and ugly manner that Canadians from one end of this country to the other responded with such outrage at the manner in which this government and that minister would deal with such a sensitive and such an important issue to all Canadians that they spoke with one voice, and they said that this is simply unacceptable. That this is simply unacceptable that a government of Canada would deal with such an important issue in such a partisan and irresponsible manner, and it was later determined, of course, as people sifted through the details of that legislation, that it didn't do what the government said it would do, that it was flawed in so many ways that finally the minister and the government kind of stuck it in their briefcases or they tried to kick it under the carpet and pretend that they had never tabled it, that they didn't even know what people were talking about when they talked about the infamous Bill C-30. But I'll tell you what, I remember it, and I would suggest that many members here on this side remember it, and that many Canadians remember it. And that's why that this second attempt, in part, to deal with something that Bill C-30 was supposedly going to deal with, when the government says that, okay, now don't worry, we got it dealt with, we responded to what the Supreme Court of Canada has said, we've been very specific, we've limited it to this particular provision as it relates to 184.4, and we got it covered. So there's no need for members to be concerned or for members to engage in a great deal of debate, and so we don't need a lot of time. And again, and the member from our critic who gave such an eloquent and informative speech at the beginning of this debate said that suggested that the government opposite introduced legislation often with such a sense of arrogance. That they know what's best, that regardless of the members opposite and all of their constituents that they represent, that they're the ones that have all the answers, and when they bring in a piece of legislation they say is good to go, and we should say, oh well, that's fine then, we'll let it go. But that's not what we were sent here to do. And what this government has shown is that we have to be on our toes. We have to be on our toes because they don't do their jobs, and it's been raised in this House by members on this side on a number of occasions, wondering, whether or why it is this government does not get legislation properly vetted to ensure. We understand that the demands of the Supreme Court of Canada are such that you can't with complete certainty be able to say that a piece of legislation that's drafted is going to pass muster by the Supreme Court of Canada. But surely this government takes the time, and we've not gotten that answer, takes the time to ensure that there's been some examination and some major sense of proportionality that any particular piece of legislation will pass muster of the Supreme Court of Canada. But they've not given us that assurance, and certainly in terms of the legislation that they've presented to this House already since May of 2011, Mr. Speaker, much of it has been flawed. Much of it has been flawed in detail and in substance. And while it almost seems sometimes like the government produces legislation, they're more concerned with the title. They're more concerned with the politics of the particular legislation than they are with the details, than they are with the substance, than they are with the implication and the impact that legislation, that those laws, the changing of laws of this country, the impact that those changes will have on Canadians. And that very much is a case of thumbing their nose of members of this chamber, Mr. Speaker. Now, you've indicated that my time is almost up. I would say that on initial review of this bill, we're hoping that it does what the government says it does in relation to the Supreme Court decision. There will be an examination of this at the Justice Committee, and let's hope that we get the opportunity to examine this to make sure that when this bill does head out of this House, that we've made sure that it is in fact the best piece of legislation it can be. Thank you.
The honourable member for Dartmouth Cole Harbour will have 5 minutes remaining for questions and comments when the House next returns to debate on this particular question. I expect that will happen sometime later this afternoon. Statements by members. Déclaration de député.
Statements by members.
Scarborough Centre.
Mr. Speaker, on Sunday, February the 17th, I had the privilege to present the Queen's Diamond Jubilee Medal to 17 outstanding individuals from within the Scarborough community. Among the recipients were 2 Metro Toronto Auxiliary Police, 2 World War II veterans, and 5 others who have served or currently serving in our military. Today, I wish to honour Master Corporal Alan Watson and Master Corporal Calvin Liu. Master Corporal Watson is a chief trainer with the Toronto Scottish Regiment and has provided over 10 years of honourable service to our nation. Master Corporal Liu has been a member of the Armed Forces for 7 years and has stood in defence of Canada at home and abroad. Both men have served in Afghanistan. In fact, Master Corporal Liu has served 2 terms, and during the ceremony I learned that later that evening he was returning overseas. Mr. Speaker, it was truly an honour as the Member of Parliament to present medals to such deserving individuals, and I invite all members of this House to join me in recognizing these brave young men. Thank you.
Honourable member for Windsor-Tecumseh.
As Black History Month draws to a close, I rise to recognize Windsor-Essex's role as the gateway to freedom for untold thousands of men, women, and children fleeing the insidious evil of slavery, and to commend those fearless Canadians of conscience who, even in the face of grave personal risk, assisted their flight. Over 40,000 would seek and find in Canada the liberty that was their birthright by way of that great conspiracy of conscience, the Underground Railroad. The impact of these newly liberated and their descendants is felt to this day on both sides of the Detroit River. Even in the face of persistent systemic discrimination, they have made invaluable contributions to Canadian society in the field of politics, arts, education, commerce, and the law, to name just a few. I urge all Canadians to explore this proud legacy of redemption, which vindicated an oppressed but irrepressible people belief that somewhere beneath that unwavering star lay the true north, indeed strong, but most importantly, above all, free.
Honourable member for Kootenay, Columbia.
Mr. Speaker, over the past few weeks, I've had the pleasure to announce several funding announcements in the riding of Kootenay, Columbia. In Area A of the Regional District of East Kootenay, $5.4 million was provided through the Gas Tax Fund for upgrades to an aging sewer system in West Fernie. This will remove septic systems and provide for safe disposal of effluent. In Fernie, BC, over $600,000 was provided to upgrade an outflow system for effluent that flows to the Elk River. In Sparwood, BC, over $750,000 was provided to upgrade the heating system in the recreational facility. By trapping excess steam from the boiler system, they will be able to heat the entire facility with better efficiency. These, along with a number of SIF grants throughout the Kootenay-Columbia riding, continue to create jobs, growth, and prosperity, making the Rocky Mountains one of the most sought-after places in Canada to live and recreate.
Honourable member for Halifax West.
Yeah.
Halifax West.
Yeah. Thank you very much, Mr. Speaker. Mr. Speaker, I know all members of the House are aware of the terrible tragedy that happened on Sunday, February 17th, when the fishing boat, the Miss Alley, went down off Nova Scotia with the loss of 5 lives. I know that all of us, including my honourable colleague for South Shore St. Margaret's, and who's riding the community of Woods Harbour is, and all those members across this country who have, either through direct experience living in near fishing communities or having visited the coasts of this country and other parts of the country where there are fishing communities, all recognize what a dangerous lifestyle it is to go out on the sea and fish, and particularly in a month like February. And so I know that all my colleagues, as I see, like my honourable colleague from South Shore St. Margaret's, join me, as does the Liberal Party, Mr. Speaker, in expressing our condolences, our heartfelt sympathies to the people of Woods Harbour, and especially the families affected by this terrible tragedy.
The honourable member for Sarnia-Lambton.
Mr. Speaker, 1 month ago today I had the honour of attending the change of command ceremony for the Royal Canadian Sea Cadet Corps Repulse. The ceremony represented the transfer of command from Commanding Officer Lieutenant Commander David Anderson to the new CO and first female CO of Repulse, Lieutenant Carol Weston. During Lieutenant Commander Anderson's 6 years in command, he oversaw many triumphs in the face of adversity for Sarnia's Sea Cadet Corps. From negotiating serious tax issues to overcoming the near closure of the Cadet Sales Centre, David Anderson gave countless hours of dedicated service to address extreme challenges. His leadership was a major factor in Repulse procuring the Libro ship simulator, making them the only corps in Canada with a DNV-qualified full-bridge simulator. Other accomplishments are too numerous to list. I thank Lieutenant Commander Anderson for his dedicated service and wish him well in future endeavours. I also wish his successor the best as she guides the Repulse for many more years of success.
The honourable member for Sackville Eastern Shore.
Thank you very much, Mr. Speaker. Well, Mr. Speaker, it's not every day that you get to meet a 100-year-old citizen of Canada, but also a 100-year-old World War II veteran who helped liberate my parents in the liberation of the Netherlands. And not only that, Mr. Speaker, Mr. Jim Broomfield of Galt, Ontario, spent 8 months as a prisoner of war, sacrificing his time and his youth for the liberation of the Netherlands and the free world by serving Canada in his country. And not only that, Mr. Speaker, he'll be honoured later on this year in the Cambridge Sports Hall of Fame for being an 80-year member of the Curling Thing of Canada, Mr. Speaker. He is an outstanding human being. At 100 years old, Mr. Speaker, he gets around a lot better than all of us. And I have to say, on behalf of my late father, my mother, and to all the Dutch people of Canada and of the world that he and the veterans have liberated, Mr. Broomfield, it is an honour once again to see you here, sir, and we greatly appreciate your tremendous efforts. You are a fantastic veteran, but most of all, sir, you are a great Canadian. And he says, Mr. Speaker, the secret to longevity is his Dr. Jim Bowering and good Scotch. God bless you, sir.
Member for Mississauga-Arundel.
Thank you, Mr. Speaker. I rise today to applaud our government regarding the announcement made last week to establish an Office of Religious Freedom within the Department of Foreign Affairs. The new office will have the responsibility to enshrine and promote the freedom of religion or belief as a Canadian foreign policy priority. Mr. Speaker, many of my constituents in Mississauga are excited to see the launch of this new office as it shows our government's continued dedication to promoting this fundamental freedom and addressing the concerns of its citizens. The office will be an important vehicle through which Canada can advance fundamental Canadian values, including freedom, democracy, human rights, and the rule of law worldwide. Mr. Speaker, at the same event, the Prime Minister announced that Dr. Andrew Bennett will be heading up this new office. I had the pleasure to sit down with Dr. Bennett last week, and it was apparent to me that he is a man of principle and deep conviction. Mr. Speaker, I would encourage all members of this House to support the work of Dr. Bennett as he heads up Canada's new Office of Religious Freedoms. Thank you.
The honourable member for London West. London West. Selkirk Interlake. The honourable member for Selkirk Interlake.
Thank you, Mr. Speaker. My wife is a melanoma skin cancer survivor. Her and I were both customers of tanning salons. In 2009, the World Health Organization designated tanning beds as Category 1, carcinogenic to humans. This is at the same danger level as tobacco, asbestos, mustard gas, and plutonium. Since 2010, I've pushed for tougher action on indoor tanning and tabled Bills C-497 and C-386. Yesterday, the Minister of Health and I announced that new warning labels will be introduced that strengthen the warnings about the dangers of using tanning beds. I want to thank the Minister for taking this bold initiative. The new warning states that tanning equipment can cause cancer and that they are not recommended for the use by those under 18. Skin cancer is one of the most common, yet most preventable cancers, especially for our youth. We have come a long way. 8 provinces have already implemented or indicated their intention to enforce age restrictions on tanning beds. I call on all provinces to follow the lead of BC, Quebec, and Nova Scotia and ban our youth from using tanning beds.
The honourable member for Dartmouth Cole Harbour.
Mr. Speaker, today I rise on behalf of the official opposition to express our deepest sympathies to the families and friends of Caitlin Nickerson, Stephen Cole Nickerson, Joel Hopkins, Billy Hatfield, and Tyson Townsend. These young men lost their lives last week when their boat, the Miss Alley of Woods Harbour, Nova Scotia, capsized during a storm. The sea can be an unforgiving master. Those who work by it are by no means faint of heart. The men who lost their lives leave behind loved ones who will remember their courage, their faith, their love of life, and their determination to make a living in one of the most dangerous industries. Mr. Speaker, we are a seafaring country that has seen many such tragedies, but it does not make them any easier. Our prayers go out to the families of these lost ones.
The honourable member for Peterborough.
Thank you, Mr. Speaker. Mr. Speaker, Adam Noble is a young, award-winning scientist from Peterborough. His research won gold at International Science and Engineering Fair at the Intel Science and Engineering Fair in Pittsburgh last May. Adam is one of Canada's brightest minds. He spoke to journalists after meeting with the Prime Minister last week and said Canada is one of the only countries right now increasing the amount of funding going into primary research. I've really changed my view on research in Canada. Adam is now in the early stages of starting his own company. After meeting with the Prime Minister, he has chosen to do so right here in Canada, Mr. Speaker. Our government has made science and technology a priority, and we're getting results. We're creating jobs, strengthening the economy, and attracting the world's brightest to study and research here in Canada. We've invested an unprecedented $8 billion in new funding since 2006, and we'll continue to support science and technology, even if others vote against it. On behalf of all parliamentarians, congratulations, Adam Noble. Congratulations to the Minister of Science and Technology, Mr. Speaker.
The honourable member for Timmins, James Bay.
Mr. Speaker, last month a young woman committed suicide in the back of a police car at Casablanca First Nation. The police have been using the vehicle as a temporary holding cell because the jail was so run down that she would have frozen if they had kept her inside. These unbelievable conditions are the day-to-day reality faced by the brave men and women of Anishinaabe Police as they attempt to service the communities across Northern Ontario. Working out without backup, cars without central radio, third-world housing conditions, increasingly high levels of post-traumatic stress disorder. This government promised to provide safe streets, but it has left NAP so underfunded that lives are being put at risk. Worse still, this government is set to cut the poor funding, which will mean more layoffs to an already badly overstretched force. Why the double standard, Mr. Speaker? It's time we had safe communities all across Anishinaabe territory and all across Northern Canada for that matter as well.
The honourable member for Calgary Centre.
Mr. Speaker, our government understands that Canadians work very hard for their money, which is why the last thing that Canadians' families want is to pay more for gas, food and electricity. Unfortunately, Mr. Speaker, the NDP's proposed $20 billion carbon tax would be economically devastating for families and would raise the price of everything. Families need to know about the NDP's dangerous economic policies. Thankfully, our government understands what Canadians want, and that is a government that's focused on growing the economy. And that's why, thanks to our government, Canada has the lowest debt burden in the G7 by far and the best job creation record with over 900,000 net new jobs since July 2009. That's why Canada's a leader in a troubled global economy, and our government will continue to fight the NDP's $20 billion job-killing carbon tax to protect Canadian families.
Hear, hear. The honourable member for Toronto Centre.
Mr. Speaker, Canada lost one of its most remarkable political citizens with the passing last week of the Honourable Eugene Whalen. A distinguished and hard-working member of this House is the member for Essex. Gene Whalen was an outstanding Minister of Agriculture for many years. His sense of dedication and his sense of humour were equally legendary. With his trademark Stetson hat, Gene could be seen in meetings not only around Canada but around the world. He cared deeply about the success and the prosperity of individual farmers and the industry as a whole. Mr. Speaker, quite rightly last month the House paid tribute to John Wise of nearby Elgin County, another Minister of Agriculture who deeply respected Gene Whalen's work and his dedication. The respect was mutual. We should all pause to reflect on these two men, what they did, what they gave, and what they stood for. Our hearts go out to their families and to their friends. For our part, we remember what they gave, and while we grieve, we also celebrate lives well lived. Thank you, Mr. Speaker.
The honourable member for Thunder Bay, Rainy River.
Mr. Speaker, since Conservatives have come to office, there have been over 27,000 jobs lost in Ontario's forestry sector. And across the land, we are witnessing a slow erosion of seasonal industries. But instead of respect or sympathy for those thrown out of work, Conservatives have tact. They give quotas to Service Canada staff while sending out EI inspectors to the homes of out-of-work Canadians. They should stop treating EI recipients like criminals and start catching Conservatives who break the rules. And, Mr. Speaker, they don't even need inspectors. All they need to do is ask at the next Conservative caucus meeting, will all those who have collected $40,000 in housing allowances they weren't entitled to please raise their hand? Mr. Speaker, it'll be like everybody has to go to the bathroom at the same time. Or who actually lives in the province they represent. Thankfully, Canadians have the NDP. So while Conservatives stand to defend Senate entitlements, the NDP will continue to proudly stand up day after day to defend Canadian taxpayers.
The honourable member for South Shore, St. Margaret's.
Mr. Speaker, the seas of the North Atlantic have always been inherently dangerous for those who work upon them. Every South Shore fishing community knows this firsthand, and all have experienced the sorrow and the heartache of losing loved ones. This, however, did not make the burden of grief any lighter when on Sunday, February the 17th, the halibut boat Miss Alley was lost with all hands. Mr. Speaker, these were young men with young families, and all were experienced and able fishermen. Captain Catlin Nickerson, Tyson Townsend, Billy Jack Hatfield, Cole Nickerson, and Joel Hopkins. Mr. Speaker, I would take a moment to recognize the tremendous effort of the local volunteers who assisted in the recovery attempt and the men and women of the Joint Rescue Coordination Centre in Halifax, Canadian Armed Forces, Coast Guard, Search and Rescue, and RCMP, all who have been moved by this tragic loss. To the immediate and extended families of the lost fishermen and their communities, on behalf of all members of this House, we extend our prayers and our deepest condolences.
Questions orales. L'honorable chef de l'opposition.
The Honourable Leader of the Opposition.
Senator Mike Duffy has now admitted he mistakenly collected maybe about $100,000 in Senate housing allowances. How does one accidentally claim $100,000 in living expenses? He says the form was too complicated. We also have Senator Pamela Wallin, who has an Ontario health card while claiming to be a resident of Saskatchewan. She told the federal government that she lived in one province, while telling a provincial government that she lived in another. This would be unacceptable for any other Canadian. Why does the Prime Minister seem to think it's acceptable for his Conservative senators?
The Honourable Government House Leader.
Mr. Speaker, we've committed to ensuring that all expenses are appropriate, that the rules governing expenses are appropriate, and to report back to the public on these matters. Senators Patterson, Wallin, and Duffy all own property in the provinces and territory they represent. They maintain deep, continuing ties to those regions, and in fact, all three senators spend considerable time in their home provinces and territory. In the case of Senator Wallin, who was mentioned 168 days last year. The reality is, if you want to see real change in the Senate, you want to see real change towards an accountable Senate, you need to embrace the Conservative proposal to actually let Canadians have a say who represents them in the Senate. The NDP simply won't do that.
The Honourable Leader of the Opposition.
Mr. Speaker, the Prime Minister rejected allegations against Senator Wallin even before her travel claims were audited. The Prime Minister rejected allegations against Senator Duffy even before his housing expenses claims were investigated. Conservatives don't shy away from gratuitously accusing EI claimants of fraud, but they don't prevent their own senators from committing fraud. It's a double standard. Why won't Conservatives really investigate fraud in the Senate? The Honourable Leader of the Government of the House. Mr. Speaker, we are committed to ensure that all expenses be appropriate, that rules regarding expenses be appropriate, and that all expenses be revealed publicly. Senators live in the province they represent, and they have a meaningful relationship with those areas, whether it be a province or a territory. The Honourable Leader of the Opposition. That's right, Mr. Speaker. Conservative senators are presumed innocent, whereas the unemployed are presumed guilty. 3 weeks ago, the Human Resources Minister said in the House that there were no EI quotas to exclude Canadians from the EI program. But Le Devoir revealed that this is completely false and that there are indeed such quotas. The minister called the victims of these quotas bad guys. In her eyes, they are all fraudsters and tricksters. Will the government ask for forgiveness of the thousands of Canadians workers they are treating like criminals? The Honourable Minister for Human Resources. Mr. Speaker, if a worker cannot find a job in his or her field, EI will be available as always. But, Mr. Speaker, Service Canada has indicated that it does not impose quotas, which would lead to negative consequences on workers who cannot reach these objectives or quotas. However, we do have performance objectives for people who intend to commit fraud.
C'est faux.
That is false. In this House, she admitted to the existence, she denied the existence of quotas, but Le Devoir has revealed that they do indeed exist. She can say what she wants, but the truth has come out. And when she was caught red-handed, she misled this House. Now the Conservatives are sending inspectors into the houses of honest EI claimants. Will Conservatives stop sending their reform maquots, their agents, into the houses of the unemployed? The Honourable Minister for Human Resources.
Insurance program lost hundreds of millions of dollars due to fraud and ineligible payments. And that despite nearly $500 million in eligible payments that were detected and stopped by Service Canada. Mr. Speaker, the only people who lose if the opposition stops us from rooting out employment insurance fraud are Canadians who follow the rules. But, Mr. Speaker, EI will be there for those who are eligible for it if they can't find a job in their area, just as it always has been.
The Honourable Leader of the Opposition.
Telling investigators that they're each required to find $500,000 in fraud presumes that there's widespread fraud and that they're all a bunch of cheaters and criminals. That is false. She's sending investigators, Mr. Speaker, into the homes of randomly selected seasonal workers in Atlantic Canada. They can't send them to inspect senators, of course, because we don't know where they actually live. We know what the Prime Minister thinks about workers in Atlantic Canada. He calls them losers, that they have a, quote, culture of defeat. Does that explain the reaction and the attitude of the minister? She thinks that they're a bunch of losers as well?
The Honourable Minister of Human Resources.
Speaker, that's a load of nonsense. Absolutely. We're supporting Canadians in their efforts to get back to work. That's why we've expanded the Job Alerts program. We've expanded the Job Bank so that they get the information about the jobs that are available for them. EI is there as a temporary income support to help Canadians while they're transitioning to another job. But if the jobs aren't available, Mr. Speaker, then EI will be there for Canadians as it always has been.
The Honourable Member for Toronto Centre.
Mr. Speaker, the new Minister of Aboriginal Affairs said on the weekend that, in fact, there was no issue of resources with respect to the Aboriginal issue in Canada. It was all a matter of accountability. I'd like to ask the government, does this then mean that the cost per student are going to continue to be, the payments per student are going to continue to be lower on reserve than they are off reserve? Does this continue to mean that police forces are going to be forced to live hand to mouth from day to day in comparison to what's going on in the provinces around them? Does this mean, in fact, that those who are on welfare are going to receive substantially less and that children, in fact, are going to receive substantially less because of the discrimination?
The Honourable Government House Leader.
Mr. Speaker, simply put, we do not accept the premise of the Leader of the Third Party's question. Indeed, it's certainly the case that the education funding provided by the government is comparable to that is provided for off-reserve Canadians by most of the provinces. We actually believe that the best way to ensure First Nations children and families get the support they need is by working together with First Nations, provinces and territories. We're doing that to ensure, most of all, that we benefit First Nations Canadians by having a strong economy and by creating the educational and economic opportunities for them to succeed and advance, as all Canadians hope to do quite legitimately. That's our priority, and that's what we're looking to deliver.
The Honourable Member for Toronto Centre.
Mr. Speaker, the facts are clear. Payments made by the federal government are less. They're lower and they're discriminatory in the area of education, welfare, and family well-being, and in the way police is being managed throughout the entire north of Canada. That is clear. Policing costs, policing services, prisons, on reserve, in any circumstance, don't receive as much funding or support by the federal government. So, why is there a lack of resources when normally there are resources for policing? The leader of the Liberal Party is wrong. Support given by the federal government is the same for education on reserves as for other young natives going to school off reserve. Our priority is to create opportunities for young native people throughout the country in order that they have a greater future as compared to their past.
Speaker, I wonder if the government can tell us, in light of the increasing evidence with respect to the activities of the government of Sri Lanka, its failure to reconcile with the minority Tamil population in Sri Lanka, its failure to deal with the human rights crisis, which is seen as one increasingly deep. There are groups and observers across the board, including the UN Human Rights Council, which are challenging what the government of Sri Lanka is saying. I wonder if the government of Canada can state what it is doing to make sure that the next meeting of the Commonwealth Head of States will not in fact take place in Colombo, but will be located elsewhere, and that the Government of Canada has a clear position with respect to which meetings it will attend and which it won't.
The Honourable Parliament Secretary to the Minister of Foreign Affairs.
Mr. Speaker, the Prime Minister has spoken out loudly and clearly on this very important issue of human rights. He said our concerns on the lack of accountability for the serious allegations of war crimes, the lack of reconciliation with the Tamil community, and the events that have taken place since the end of the Civil War are unacceptable. We have relayed the Government of Canada's position to both the High Commissioner and directly to the Minister of Foreign Affairs of Sri Lanka. Canada will continue to speak loudly and clearly on behalf of human rights around the world, especially in Sri Lanka.
The Honourable Member for Squamish-Wondafuka.
Mr. Speaker, Conservatives are clearly not listening when it comes to First Nations public safety. They refuse to commit to maintaining the funding for 18 First Nations police services serving more than 40 communities. This funding runs out in March, but the government has yet to respond to a 3-year-old request from the chiefs just for a meeting. Will the Minister of Public Safety finally commit to this meeting, and will he agree to negotiate a new agreement to provide stable, long-term funding to help keep these First Nations communities safe?
Hear, 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 hear. The Honourable Minister of Public Safety.
Mr. Speaker, I don't know where the member is getting his information from. I've been meeting with First Nations communities on this very point, and if the member wants some update on the meetings that I have been having and with who, I'm prepared to share that with him.
The Honourable Member for Nanaimo, Cowichan.
Mr. Speaker, the Conservatives promised in 2008 to move towards reconciliation. Instead, they are fighting at the Canadian Human Rights Tribunal over funding discrimination of child welfare on reserves and to keep the Truth and Reconciliation Commission from accessing documents from the Library and Archives. Will the new minister stop these litigations by making documents available immediately to the TRC, provide equal funding for child welfare on reserves, and commit to real reconciliation?
The Honourable Minister of Aboriginal Affairs.
Mr. Speaker, let me say that, first of all, we believe that the best way to ensure First Nations children and families get the support and services they need is to work together with First Nations, provinces, and territories. I want to remind the honourable member that it is our government that introduced a culturally sensitive enhanced protection approach to protect thousands of children on reserve. Exactly. And we will continue to work with First Nations to ensure that children and families have the supports they need to have safe lives.
The Honourable Member. Mr. Speaker, thank you very much. And I hope that was clapping out of relief on the other side. Now, in order to rebuild a respectful relationship nation to nation with Native people, we need concrete gestures. And it's not by wasting taxpayers' money on legal battles, by trying to withhold documents from the Truth and Reconciliation Commission, that we are going to reach that goal. So can the new minister tell us what he's going to do to rebuild the relationship by beginning with bringing about financial support to improve the lives of Native people? The Honourable Minister for Aboriginal Affairs. Mr. Speaker, we believe that the best way to help First Nations families and children to receive the services they need is to work together with the provinces and the territories and First Nations to improve the situation. These are not easy challenges. We will continue to work in collaboration with our Native partners throughout Canada, with the province and the territories, in order to improve the situation of all Native people, regardless of where they live in Canada. On February 1st last, the Minister of Human Resources said, and I quote, "Department employees have no individual quotas. However, documents obtained by Le Devoir prove exactly the opposite. The truth is that an employee's performance rating is based on their ability to cut $485,000 in EI benefits. these are expected performance indicators of employees. That is the truth, and therefore it is clear that the minister misled the House. So what we want to know is why the minister will not simply end the Honourable Minister for Human Resources. Mr. Speaker, Service Canada has indicated that it does not impose any quotas which would lead to negative consequences for employees who cannot reach those objectives. However, there are performance objectives to help protect benefits for the unemployed, all with a view to detecting fraud. Only the opposition is against fighting fraud, and the only ones who would lose out under the NDP's proposal are Canadians themselves.
Be going after their unaccountable senators. Mr. Speaker, on February 1st, the minister stood in this House and claimed, quote, departmental employees do not have individual quotas. Yet today, media are reporting that she cancelled those quotas. Can she explain to the House how she can cancel something that didn't exist?
The Honourable Minister of Human Resources.
Mr. Speaker, as I said before, that there were no quotas for individuals. There are objectives, targets, to be sure. Mr. Speaker, there's a big difference between the two when it comes to motivating and managing staff. What I can assure you, Mr. Speaker, that if the opposition prevents us from rooting out the hundreds of millions of dollars in fraud and ineligible claims that exist within the EI system, it's Canadians who play by the rules that will lose. That being said, Mr. Speaker, if jobs are not available for individuals in their area, EI will continue to be there for them as long as we maintain its integrity.
The Honourable Member for Rosemont-La Petite Patrie. Mr. Speaker, thank God that intellectual dishonesty does not really hurt. A while ago, the Leader of the Government in House what is the criteria for defending Senator Wallin, who does not know where she lives? She claims it's in Saskatchewan, when in fact her OHIP card is from Ontario. What criteria is used to get this card? Residency, of course. Did the Conservatives know this when Ms. Wallin was appointed to the Senate? The Honourable Leader of the Government in the House.
In 68 days last year in the province of Saskatchewan. Her roots in Saskatchewan are deep and well known. She has a residence in Saskatchewan. All Conservative senators are qualified to represent the province and territories they represent.
The Honourable Member. Well, Senator Wallin has the ability to clone herself, it seems, but if only the case of Senator Wallin was an isolated event or a simple error in judgment. But no, Senator Duffy layered on another answer last Friday. After 3 months of evasive responses, he finally decided that he doesn't really live on PEI. He studies legislation but does not even know how to fill out a form. Really? Seriously? Will the Prime Minister admit that it showed a lack of judgment when it appointed Senator Duffy to the Senate? The Honourable Leader of the Government in the House.
Party that purports to want to see meaningful change to the Senate yet opposes it every step of the way. Our government has put forward a plan that will allow Canadians for the first time to actually have a say in who represents them in the Senate. In every case where Canadians have been asked, in those provinces that have held elections, our Prime Minister has appointed the individual selected to the Senate. The difficulty is the NDP opposes our legislation going forward. If they want to show they're serious about real Senate reform and real accountability in the Senate, they would support that legislation and support real democracy in the Senate.
The Honourable Member for Timmins, James Bay.
Thank you. Well, real accountability in the Senate is stop defending entitlements and start defending the taxpayer like the Democrats. Because when Mike Dudley became senator, he signed a form that said his primary residence was not in Ottawa, but was a cottage in Prince Edward Island. And now that he's being forced to pay back $40,000 or $100,000 because he got caught out, he says the story's over. Now, this is what Conservatives tell unemployed Canadians. Quote, if you misrepresent the facts to make a false claim, you are committing fraud and may be prosecuted. So will the government hold senators who break the rules to the same standards that they're holding unemployed Canadians to?
The Honourable Government House Leader.
Mr. Speaker, as I've said several times, we have committed to ensuring that all expenses are appropriate and that the rules governing those expenses are appropriate. In the case of Senator Duffy, he clearly maintains a residence in the province and has deep roots in that province. The difficulty, though, with the NDP is they come here talking about changing the Senate in meaningful ways. We have a proposal to do it. They have none. They continue to have none. In fact, the member for Timmins, James Bay, said when asked what the NDP would do about the Senate last week, he says, I can't say what the NDP leader will do after the next election. They have no plan, and they won't tell Canadians what they will do.
The honourable member for Timmins, James Bay.
Oh, poor Canada. They promised Canadians one thing, that they would bring accountability to the Senate. What did we get? We got Mike Duffy and Patrick Brazo. Thanks, Mr. Prime Minister. You know, Article 23 of the BNA Act states a senator shall be a resident in the province for which they are appointed. It doesn't say they'll have a cottage there. Now, clearly Mr. Duffy doesn't meet this requirement, but apparently neither does Senator Pam Wallen of Palmerston Boulevard. We're talking about the Constitution Act here. If these senators falsified their residency claims, what steps will this government take to hold them to account and to get taxpayers their money back? That is real accountability. That's real Senate reform.
The Honourable Government House Leader.
Mr. Speaker, clearly we are committed to ensuring all expenses are appropriate. But when you want to talk about real accountability goes farther. Real accountability means you believe in our democracy. Real accountability means you're going to allow Canadians...
Order. 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 The Honourable Government House Leader has the floor.
Real accountability means you're going to allow Canadians to choose who represents them in the Senate. That is the proposal from this government. That is the proposal opposed by the NDP. The NDP who, their own ethics commissioner who asked that question just said, can't say what they would do about the Senate after the next election. They have no plan. We have a plan for real accountability and real democracy in the Senate. Let's all get behind it.
The Honourable Member for Saint-Maurice-Champlain. Mr. Speaker, the media revealed that Service Canada employees had to find savings to the EI program, and this makes us question whether the minister was responsible for imposing quotas. Can she explain how investigators can remain objective when conducting investigations if they have to meet mandatory quotas? Does she harbor a presumption of guilt on the part of a specific number of EI claimants? The Honourable Minister for Human Resources. Mr. Speaker, the department has withheld $2 million in fraudulent claims, and millions more have been lost due to fraud. Mr. Speaker, the only people who will lose out will be Canadians if the opposition persists in maintaining its position.
Mr. Speaker, at last night's Academy Awards, the Oscar for Best Supporting Actor went to Christoph Waltz for his portrayal as a ruthless bounty hunter. Of course, if the Hollywood gig doesn't work out for Mr. Waltz, I'm sure the Minister for Human Resources would love to hire him. He could bust down doors, hunt down those people the minister thinks are shiftless, lazy, dishonest seasonal workers whose culture of defeat has become such a scourge on this country. Mr. Speaker, very simple question pertaining to today's issues. What is the difference between a target and a quota? What's the difference?
The Honourable Minister of Human Resources.
Well, Mr. Speaker, let's be clear. The department was able to stop $500 million in ineligible payments last year. But the employment insurance system still lost hundreds of millions of dollars due to fraud. Mr. Speaker, if the opposition stops us from rooting out EI fraudsters, the only people who lose are Canadians who follow the rules. That being said, Mr. Speaker, if the unemployed who are on EI can't find a job in their area, in their realm of competence, then EI will continue to be there for those who qualify.
The Honourable Member for St. Paul's.
Mr. Speaker, today the Canadian Human Rights Tribunal resumes its hearings on the unacceptable gaps in funding for child and family services on reserve versus off reserve. Rather than fixing the appalling discrimination, the Conservative government has spent more than $3 million dragging the case through the legal system. Will the new minister do the right thing settle this matter, and redirect the millions being wasted on lawyers to the First Nations children who need the help.
The Honourable Minister of Aboriginal Affairs.
Let me repeat, Mr. Speaker, what I said earlier. I think that the way and the best way to ensure that First Nation children and families get the support and services they need is by working together. First Nations, provinces and territories, and that is what we are doing. We have introduced a new enhanced prevention approach to dealing with the right of these First Nation children, and this is ongoing, and we will continue to work with our partners to improve the situation.
Honourable Member for Hull-Aylmer. Mr. Speaker, the Conservatives have contempt for job seekers, implying that they are bad guys. In addition, they send inspectors to their homes to spy on them in order to better fulfill their individual quotas for benefits to be cut off. After that, they try to have us believe that this reform is being done for the workers. The workers will not let this happen, and we won't let them down. Rather than saving $485,000 on the backs of these poor sods, why don't they start sending inspectors to their own senators' homes? Honourable Minister of Human Resources. Well, Mr. Speaker, last year the EI program lost millions of dollars because of fraud and ineligible claims. This is not acceptable. The only losers when the opposition prevents us from eradicating EI fraud are the Canadians who do follow the rules. For the unemployed who are eligible and who cannot find another job in their region, in their skill set, EI will be there for them as always. The Honourable Member for Gaspésie-de-la-Madeleine. Quotas are quotas, Mr. Speaker. She has to stop running around in circles here. People have had enough with threats and intimidation and the minister's reluctance to tell the truth. She's saying that her reform is good for the workers, but the people in the regions feel abandoned. Why are they been protesting for months to save their lifestyle and regional economies? The productivity of seasonal companies is in danger because they're going to lose their workers. Will the minister put an end to this reform and to the quotas? The Honourable Minister of Human Resources. Well, Mr. Speaker, the opposition should stop scaremongering. It's not just for seasonal workers. Employment insurance will be there to help them find another job, perhaps during the winter, which will make them better off than they used to be. It's very important that when somebody works, we realize they're better off than if they don't work. If there is no work in their region, in their area of skills, EI will be there for the unemployed, as it always has been. The Honourable Member for Longueuil-Pierre-Boucher. Mr. Speaker, we can talk about the cities, too. Cultural artisans often don't have a job between two contracts and must use EI. The cultural industry is the livelihood of 35,000 people in Quebec, 132,000 in Canada. That was the example of Michael Dana in Toronto, who got an Oscar for his music for Life of Pi, and Jim Erickson of Salt Spring Islands for his decoration for Lincoln. With EI reform, the Conservatives will force these workers to change jobs. Why is this reform affecting our cinema industry? The Honourable Minister. We have looked at this with the Minister of Canadian Heritage, and we support artists. The EI reform supports them.
Let's be clear, these workers are now, if they're self-employed, available for special benefits through the EI system, compassionate care, sickness leave, parental leave. Mr. Speaker, that has never been available to the self-employed before, and unfortunately the NDP opposed those new programs.
Honourable Member for Hull-Aylmer. Mr. Speaker, people are fed up to there listening to the minister say everything but the truth. This reform is a scandalous scandal. Saturday in Quebec and the Atlantic provinces, everybody took to the streets to say no to the pillaging of EI. to denounce attacks against workers in seasonal industries, to denounce the abandonment of the regions. Quotas and investigators don't exist for the unemployed. We need those for senators. When will the minister stop attacking workers? The Honourable Minister of Human Resources. Mr. Speaker, it's completely the contrary. Our government supports the unemployed by giving them greater access to special benefits and giving them a job bank system that is broader than it used to be to inform them of available jobs in their area of expertise in their region. So we want to help them find a job and make sure that when they do work, they are better off than otherwise. If there are no jobs available, if they can't find a job, employment insurance will be there, as it always has been.
Mr. Speaker, when it comes to the environment, our Conservative government has a track record to be proud of. The failed policy pronouncements of the former Liberal government saw an actual increase in greenhouse gas emissions by over 30%. The proposed policy of the NDP, a $20 billion job-killing carbon tax, would stand to cripple the Canadian economy and not reduce a single ton of carbon. Can the Parliamentary Secretary to the Minister of Environment update this House on our government's latest announcement to regulate heavy-duty vehicle emissions?
The Honourable Parliamentary Secretary to the Minister of the Environment.
Well, Mr. Speaker, with the tough new measures that we've announced today, greenhouse gas emissions from heavy-duty vehicles will be reduced by up to 23%. The regulations will also improve fuel efficiency and save truck drivers up to $8,000 a year. And, Mr. Speaker, it's under this government's leadership that we've seen a real reduction in greenhouse gas emissions. It's been under this government that we've seen this while our economies continue to grow. And, Mr. Speaker, it's been under this government that we're using this policy to help save Canadians money, like up to $8,000 for truck drivers through these regulations. It's our Conservative government that's reducing greenhouse gas emissions.
Honourable member for Parkdale High Park.
The last Conservative budget axed public service jobs, health care, old age pensions, and the environment. The next budget should be dedicated to building an economy that is fairer, greener, more prosperous for all Canadians, and not just those who can take advantage of special interest tax credits. Will the Minister of Finance get out of his bubble and consult Canadians rather than friends of the Conservative Party when preparing his budget?
Merci, Monsieur le Président.
Thank you, Mr. Speaker. We don't know what will be in the budget, but let's look at the NDP track record when it comes to the 2012 budget and the measures that the NDP voted against, measures that existed to help Canadian families. Things like the youth employment strategy that would have provided jobs to our young people. Good thing our government voted for it. Economic prospects for Aboriginals who are young. The NDP voted against that. The disabled and funds for those people in the labour force. They voted against it.
High Park.
Well, the Conservatives' last budget failed to tackle the serious economic challenges facing us, failed to create jobs, failed to bring in long-term skills training strategy. Instead, Conservatives rewarded their well-connected friends and attacked essential services like health care and old-age security. And there'll always be millions for their unaccountable senators. When will this government change direction and stop pretending that giving away billions to profitable corporations is somehow a real job creation program?
The Honourable Parliamentary Secretary.
Thank you, Mr. Speaker. And, as I listen to the NDP member talk about the plans that we put forward for well-connected colleagues, we're talking about Aboriginal youth who were benefiting from the programs that we put forward in Budget 2012 that they voted against. We're talking about handicapped people who needed a hand up to get into the workforce, and they could not count on that NDP party to vote in favour. And so it took this Conservative government to put it forward and make sure it got through to them. We also put forward funds for families to succeed. We're going to continue on that vein to create jobs for them and secure our long-term prosperity.
The Honourable Member for Trinity Spadina.
Mr. Speaker, across the country,
Roads are full of potholes and bridges are crumbling. Commuters are stuck in gridlock and transit riders are packed like sardines. And yet the Conservatives have no plan. Municipalities are responsible for over half of all the infrastructure, but only receive 8 cents per tax dollars. Will the minister work with us together with municipalities and businesses groups and say yes tomorrow to our motion for a long-term infrastructure plan?
The Honourable Minister of Transport.
Mr. Speaker, our government has made unprecedented investment in infrastructure since forming government in 2006. We continue to work to balance the budget, but we don't have control over the fragile global economy like in Europe and US. No decision has been made, but any decision will be made in context of the current fiscal situation and the capacity of taxpayers, Mr. Speaker.
Honourable Member for Trois-Rivières. Mr. Speaker, we've confirmed this morning that Conservatives want the people on the south shore of Montreal to finance the construction of the new Champlain Bridge. Tolls could be installed on all bridges and tunnels going to the south shore. The problem with the minister's plan is that it leads to the disengagement of the federal government and its responsibility for infrastructure. Before imposing a transportation tax in the Montreal region, why not work with the municipalities to put in place a stable, predictable and recurring funding strategy for infrastructure? The Honourable Minister, Transport. As I said before, never before in the history of this country has a government invested as much in infrastructure. It's interesting to hear the member talk about what we should do. We've invested $700 million on Highway 30 at the request of the Quebec government. Many choices were made throughout the region. We'll have a new bridge on the St. Lawrence River. We will deliver a bridge and continue to do our job. They voted against the break on the excise tax on gas. They have no lesson to teach us.
Canadians watched with pride as Life of Pi won 4 Oscars with its Canadian crew. But Canadians' pride turned to disgust as they had to sit through extravagant Conservative ads paid for by Canadian taxpayers. So the Oscar for actors in a leading role in wasting Canadian tax dollars goes to the Conservatives. Now, during their acceptance speech, could the Conservatives please tell us when will they stop wasting tax dollars to pay for Conservative ads, and when will they finally show some respect for Canadian taxpayers?
The Honourable President of the Treasury Board.
Well, Mr. Speaker, the Honourable Member gets a Razzie for that kind of remark. Mr. Speaker, of course, it is our obligation to inform Canadians, taxpayers on important government programs. We do so not at the clip of the former Liberal government, I might add, certainly well below that by the tens of millions of dollars, but we will continue to inform Canadians on important programs because it is necessary that we continue that dialogue on issues that will create jobs, opportunity, and growth in our economy. Thank you.
The Honourable Member for Winnipeg North.
Yes, Mr. Speaker, today the Canadian Doctors for Refugee Care and the Canadian Association of Refugee Lawyers went to federal court to challenge the Minister of Immigration's reckless health cuts to the most marginalized and vulnerable in people in Canada. They are arguing that the cuts are unconstitutional, illegal, and a breach to obligations under international law. The cuts announced last June without consultation, Mr. Speaker, will the minister listen to the frontline healthcare workers and fix his mess?
The Honourable Minister of Citizenship and Immigration.
In fact, we have listened to Canadians, Mr. Speaker. Canadian taxpayers have no obligation to provide gold-plated health insurance to illegal immigrants who have been deemed by our fair and generous legal system not to be refugees. It's interesting. We brought in the initial part of this change on July the 1st, Mr. Speaker. We immediately saw a 90% reduction in the number of asylum claims being filed by nationals of the democracies of the European Union.
The Honourable Member for Dartmouth, Cole Harbour.
Thank you, Mr. Speaker. Atlantic Canadians are grieving over the loss of 5 fishermen when the Miss Alley went over last week. Our thoughts are with their families and their communities in this difficult time. and questions are continuing to be raised about the coordination between the Coast Guard, D&D, and the RCMP. For example, why did the search end so soon, and why wasn't the Miss Alley searched the first time that was located on Tuesday? So I want to ask the government, Mr. Speaker, if they will provide Nova Scotians, provide Canadians with the answer to those questions, and do it soon.
The Honourable Minister of National Defence.
Mr. Speaker, as was indicated earlier by the member from South Shore St. Margaret's and this member, of course, our thoughts here, thoughts and prayers remain with the families of those who lost loved ones on the Miss Alley. The entire community of Woods Harbour, Nova Scotia, continues to grieve. National Defence and the Canadian Coast Guard and the American Coast Guard and private assets were all involved in the search and rescue mission. Mr. Speaker, after the mission turned to a recovery operation under the RCMP, I immediately responded positively to a request from my colleague, the Minister of Public Safety, that Canadian Forces assets also support the recovery mission, Mr. Speaker.
The honourable member for New Westminster and Coquitlam.
Conservatives should make saving lives on both coasts a priority. Unfortunately, last week, Conservatives quietly shut down BC's Kitsilano Coast Guard Station in Canada's busiest port. This station costs less than $1 million a year to operate. In fact, it costs less than the travel expenses of just 3 Conservative senators. This is a reckless decision that will put lives at risk. So why are Conservatives defending their senators instead of British Columbians?
The Honourable Minister of Fisheries and Oceans.
Well, thank you, Mr. Speaker, and thank you to the member opposite. Of course, the government's paramount concern is to allocate its resources in a way that is based on, obviously, Mr. Speaker, advice from the Coast Guard is best for public safety. With respect to the timing, the Coast Guard has said that they held exercises prior to the closure last week of the base and felt that the transition could proceed without any additional risk. Thank you, Mr. Speaker.
The honourable member for Burlington.
Thank you, Mr. Speaker. Tomorrow marks the one-year anniversary of a tragic train derailment in Burlington, Ontario. Our thoughts remain with the families of the victims of this accident. Our government continues to take strong action to ensure that the travelling public is safe, and Canada has one of the safest transportation systems in the world. In fact, since 2007, train accidents have decreased by 23%. Can the Minister of Transport, Infrastructure and Communities update this House on action taken following this accident? Thank you.
And the Honourable Minister of Transport.
I thank my colleague from Burlington for the question. Our thoughts and prayers remain with the families of those who lost their lives in this tragic accident 1 year ago tomorrow. Our government takes the safety of the travelling public very seriously, and we will continue to make decisions based on the safety interest of all Canadians. I'm pleased to confirm today that VIA is installing locomotive voice recorders in its entire fleet, and we await the Transportation Safety Board's final report into the accident. Thank you, Mr. Speaker.
The honourable member for Avalon.
Mr. Speaker, I have a question for the Minister of Intergovernmental Affairs about his ministerial budget, his staff. Media reports confirm that the minister gave Chris Crawford a huge promotion, effectively doubling his salary. This is the same Chris Crawford who ran the SIMS database on Election Day, the very data that was used to defraud voters. Will the minister confirm that it was his decision to give Mr. Crawford this promotion, or was it someone else in government or the Conservative Party that instructed him to do so, and does he take full responsibility for his employees?
The Honourable Parliamentary Secretary to the Minister of Transport.
Mr. Speaker, another day, another hysterical, false allegation from the Liberal member across the way. Normally they're attacking the member for Labrador because he spends too much time in Labrador serving his constituents, and now they're attacking him without evidence with false allegations. The only party in Canada that has been found guilty to have made illegal robocalls is the Liberal Party of Canada, and more particularly its member in Guelph. If that member who just posed the question wants to know more about that, he should just walk over and ask his Liberal colleague.
The honourable member for Beauharnois-Salaberry. Mr. Speaker, many citizens are asking to be consulted regarding energy development projects, especially oil pipelines. It seems that In the framework of some consultations carried out by the industry, not all documents were available in both official languages. The development and operation of resources is a complex issue that requires specific explanations. Can the Minister assure us that the National Energy Board will henceforth guarantee the availability of all documents in both languages when it comes to oil pipelines? The Honourable Parliamentary Secretary to the Minister of Natural Resources.
Speaker, we work with regulators and governments and proponents across this country and opponents actually to these proposals, but the member opposite needs to know that almost 20% of Canadian economic activity comes from the resource sector. The NDP just don't seem to get it, Mr. Speaker. They continue to oppose all job-creating resource developments. They oppose all hydrocarbon development. They oppose all mining projects. They oppose clean energy projects. They oppose nuclear energy projects. They even speak out against the forestry sector. Mr. Speaker, when will the NDP come up with any economic development in this country that they'll actually support?
The honourable member for Chilliwack-Fraser Canyon.
Thank you, Mr. Speaker. In a report commissioned by our government, Mr. Emerson confirmed that the Canadian space industry is well positioned to take advantage of emerging opportunities, succeed commercially, and contribute to the public good. Canadians are immensely proud of our space sector and its well-known achievements that have contributed to its reputation as a world leader in space technology. Canada has earned this reputation by setting the bar high and aiming for the stars. Can the Minister of National Defence update this House on the latest developments in the space sector?
The Honourable Minister of National Defence.
Thank you, Speaker. I thank my BC colleague for the very timely and relevant question. This morning, not one but two satellites were successfully launched as part of an international effort. The Near-Earth Objective Surveillance Satellite, NEOSat, as well as Sapphire, are Canada's first dedicated operational military satellite. These are achievements that every Canadian can be proud of. Proof that Canadian ingenuity and leadership in advanced space technology are indeed out of this world. Canada's highly competitive aerospace and space industries are major contributors to our economy, and these milestones are two more examples of what our world-class Canadian companies can accomplish.
The Honourable Member for Saint-Lambert. Mr. Speaker, the repercussions of the Minister's decision to deprive refugee claimants from access to health care continues to grow. A lawsuit has been filed today to protest these dangerous budget cuts. Mr. Speaker, lives are at stake, and the Minister is defending a policy that will deprive people of vital care, and certainly not a luxury. Doctors are in the best position to know who needs care and what care they need. When will the Minister admit his mistake and decide to cancel these cuts to health care? The Honourable Minister of Citizenship and Immigration. Mr. Speaker, it's quite clear once again that the NDP wants to force Canadian taxpayers to pay for health care for false refugee claimants, people who are not refugees, people whose application has been rejected by our fair legal system. The New Democrats want to force taxpayers to provide additional services to these illegal immigrants, services that are not available to Canadian citizens and taxpayers. This is quite bizarre, Mr. Speaker. The Honourable Member for Haute-Gaspésie, Matane-Matapédia. Mr. Speaker, on February 1st, the Minister of Human Resources stated in the House that departmental employees don't have individual quotas. Nice fib. Now we see that the quotas are 20% higher in Quebec. Since Quebec already suffers the greatest impact with this reform, with 40% seasonal workers, it will be doubly penalized by the reform and the quotas. Will the Minister answer my question? Unless she's fulfilled her quota for the day, why is Quebec more targeted than other provinces of Canada? The Honourable Minister of Human Resources. Well, Mr. Speaker, last year, the EI program lost millions of dollars because of fraud and ineligibility. That is despite the fact that Service Canada stopped $500 million in payments, ineligible or fraudulent payments. The only losers when the opposition tries to prevent us to eradicate EI fraud are Canadians who do respect the rules.
Here for today. I would like to draw the attention of honourable members to the presence in the gallery of the Honourable Jonathan Dennis, Minister of Justice and Solicitor General for the Province of Alberta. Tabling of documents, dépôt de documents. It is my duty, pursuant to Section 21 of the Electoral Boundaries Readjustment Act, to lay upon the table a certified copy of the reports of the Federal Electoral Boundaries Commissions for the provinces of Quebec and Ontario.
These reports are deemed referred to the Standing Committee on Procedure and House Affairs.
Tabling of documents, dépôt de documents. The Honourable President of the Treasury Board.
Speaker, I have with me a message from His Excellency the Governor-General, signed by the Deputy of the Governor-General, Monsieur le Président.
Mr. Speaker, a message from His Excellency the Governor-General with the signature of the substitute.
I can also have a message from His Excellency the Governor-General, signed by his own hand. These represent thank you, Mr. Speaker. I thought I was under some sort of prohibition, but if I could proceed to give not only the report of the Supplementary Estimates C, but also the 2013-2014 estimates by virtue of a message from His Excellency the Governor-General, signed by his own hand. And here are the memory sticks to go with that as well. You get one. You get one.
Dépôt de documents. The I have to read those. Is it right to stand up? His Excellency, the Governor-General, transmits to the House of Commons the main estimates of sums required to defray expenses of the Federal Public Administration for the fiscal year ending on March 31st, 2014, and in accordance with Section 54 of the Constitution Act 1867, recommends those estimates to the House of Commons. His Excellency, the Governor-General, transmits to the House of Commons the Supplementary Estimate C of sums required to defray expenses of the Federal Public Administration for the fiscal year ending on March 31st, 2013, and in accordance with Section 54 of the Constitution Act 1867, recommends those estimates to the House of Commons. Table of documents. Dépôt de documents. The Honourable Parliamentary Secretary to the Minister of Foreign Affairs.
Thank you, Mr. Speaker. Pursuant to Standing Order 32, Sub 2, I have the honour to table in both official languages the following treaties entitled 1. Agreement between the Government of Canada and the Government of the United Arab Emirates for cooperation in the peaceful uses of nuclear energy, done at Ottawa on 18 September 2012. 2. Protocol amending the agreement between the Government of Canada and the Government of the People's Republic of China on air transport, done at Zhuhai on 13th of November 2012. And 3, agreement between the Government of Canada and the Government of the United States of America for the sharing of visa and immigration information, done at Ottawa on the 13th of December 2012. An explanatory memorandum is included with each treaty. Thank you, Mr. Speaker.
The Honourable Parliamentary Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, pursuant to Standing Order 36.8, I have the honour to table in both official languages the government's responses to 22 petitions.
Introduction of government bills. Déclaration de ministre.
Statements by ministers.
Parliamentary delegations. Presenting reports from committee. The Honourable Member for Burlington.
Thank you, Mr. Speaker. I have the honour to present in both official languages the 18th report of the Standing Committee on Justice and Human Rights in relation to Bill S9, an act to amend the Criminal Code. The committee has studied the bill and has decided to report the bill back to the House without amendment. Thank you, Mr. Speaker.
The Honourable Member for Elgin, Middlesex, London.
present in both official languages the 41st report of the Standing Committee on Procedure and House Affairs regarding membership of committees of this House. And if the House gives its consent, I intend to move concurrence in the 41st report later today.
Introduction of private members' bills. Madame Day, appuyée par Madame.
Ms. Day, seconded by Ms. Matheson, moves for leave to table a bill entitled An Act to Amend the Public Finance Management for Fair Representation. This motion is deemed adopted. The Honourable Member for Arleboeuf-Saint-Charles. Mr. Speaker, I'm pleased to rise today in the House to introduce a bill to ensure equal representation of both men and women within public finance management. Currently, only 27% of senior management positions on Crown Corporation boards are held by women. I feel that it is high time for Canada to follow the example of a number of other countries that have already adopted legislation and mechanisms to ensure better representation within the boards of Crown corporations. The bill I'm tabling today then seeks to make Canada a leader in this regard. I wish to continue the exemplary work of my honourable colleague, the member for London Fanshawe, which was begun last year by proposing that the government achieve parity on Crown Corporation boards within a 6-year time period. I hope that all my colleagues in this House will support this initiative enthusiastically. Thank you, Mr. Speaker.
Mrs. Day, seconded by Ms. Matheson, moves that the bill be now read a first time and be printed. This motion is deemed adopted.
Reading of this bill, première lecture de ce projet de loi.
When should the bill be read a second time? At the next sitting of the House. First reading of Senate public bills. Motions. Motion. The Honourable Member for Elgin, Middlesex, London.
Mr. Speaker, if the House gives its consent, I move that the 41st report of the Standing Committee on Procedure and House Affairs presented to the House earlier today be concurred in.
Does the Honourable Member have the unanimous consent of the House to propose this motion? Agreed. The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Agreed. Agreed and so ordered. The Honourable Chief Government Whip.
Mr. Speaker, there have been consultations, and I believe if you seek it, you will find consent for the following motion. That notwithstanding any standing order of usual practice of the House, on Thursday, March 28, 2013, the House shall meet at 10 a.m. and proceed to government orders. Members may make statements pursuant to Standing Order 31 at 11 a.m. Oral questions shall be taken up not later than 11:15, and the House shall proceed to the ordinary daily routine of business at 10 noon, followed by government orders. Private members' business shall be taken up at 1:30 p.m. and that the House shall at 10:30 p.m. stand adjourned until Monday, April 15, 2013.
What time?
He said, say 10:30.
Yeah, Mr. Speaker, I misspoke, and it's 12 noon. For noon. Yeah.
I just want to clarify for the House. I heard the Chief Government Whip propose the German time is 10:30 p.m. on Friday. I just want to verify that it's
2:30.
2:30. Okay.
There we go.
Just want to.
I'm fixated.
Don't want to. Members may have been disappointed if we hadn't clarified that. Does the Honourable Chief Government Whip have the unanimous consent of the House to propose this motion? Yes, with 2:30. The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Agreed? Agreed and so ordered. Presenting petitions. Présentation des pétitions.
Presenting petitions.
Brandon Souris.
Thank you, Mr. Speaker, and I'm pleased to present signatures from within my constituency of Brandon Souris, calling upon the House of Commons in Parliament assembled to condemn discrimination against girls through sex-selective abortion and do all it can to prevent sex-selective abortions from being carried out in Canada.
The Honourable Member for New Westminster, Coquitlam.
Thank you, Mr. Speaker. I rise today to present 3 petitions.
The first petitioner is calling on the Government of Canada to rescind the decision and reinstate full funding to maintain the Kitsilano Coast Guard Station. The second is the petitioners from all across Canada calling the Government of Canada to immediately legislate a ban on the importation of shark fin to Canada. And finally, Mr. Speaker, petitioners call upon the Government of Canada to reverse the decision to close the ELA research station. Thank you, Mr. Speaker.
Presenting petitions, the Honourable Member for Etobicoke North.
Thank you, Mr. Speaker. There are between 6,000 and 8,000 rare diseases that affect 1 in 12 Canadians. The Canadians with rare disorders lack access to clinical trials and new drugs that are available in other countries. It is essential that Canadians have equal and timely access to therapies for debilitating and life-threatening diseases. The petitioners request that a rare disorder be defined as a chronically debilitating condition or disease with a prevalence of fewer than 1 in 2,000 people, and that a national drug policy regarding rare disorders be implemented. Thank you, Mr. Speaker.
The Honourable Member for Kitchener-Conestoga.
Thank you, Mr. Speaker. Mr. Speaker, I have the honour to present a petition signed by a number of people from the riding of Guelph. These people are calling the attention of Parliament that millions of girls have been lost through sex-selective pregnancy termination, creating a global gender imbalance, causing girls to be trafficked into prostitution. And they're calling on Parliament, Mr. Speaker, to condemn discrimination against females occurring through sex-selective pregnancy termination. Thank you, Mr. Speaker.
Honourable Member for Burnaby Douglas.
Four petitions, one regarding hate crimes, one regarding a woman's right to choose, one imploring that we bring in a national housing strategy, and the final one is to stop the expansion of oil supertanker traffic through BC coastal waters. Thank you.
Presenting petitions, Présentation des pétitions.
Presenting petition.
For Dauphin, Swan River, Marquette.
Thank you, Mr. Speaker. I have the honour to present a petition from my constituency, and the petitioners are requesting that the Government of Canada restore four-season status to all three-season national parks within Canada, reinstate grooming of winter trails, and allow local park managers to determine the appropriate level of winter activities in consultation with their adjacent local communities and people.
The Honourable Member for Sudbury.
Thank you, Mr. Speaker, and it's my pleasure to rise today to present these petitions on, based and signed by members of my community and riding of Sudbury, who are asking the Parliament and this government to preserve funding for the Library and Archives Canada. The undersigned are calling for the Minister of Heritage to restore the archival services, to previous levels equal to that of 1980s, so that historians and interested parties have access to the great multitude of documents housed at the archives. Thank you, Mr. Speaker.
The Honourable Member for Saanich Gulf Islands.
Mr. Speaker, I rise today to present two petitions. The first is from residents of Saanich in my riding, as well as Tofino in Vancouver, calling on the Government of Canada to launch a full investigation, a commission of inquiry into the allegations of voter suppression and robocalls to the 2011 election. Also, Mr. Speaker, pleased to present petitions from residents across Canada, from Toronto, from Vancouver, and other locations, in support of my bill, Bill 442, for a national Lyme disease strategy in order to deal with improving and sharing best practices in prevention, diagnosis, and treatment. Thank you, Mr. Speaker.
The Honourable Member for London Fanshawe.
Well, thank you, Mr. Speaker. And I have a petition in regard to the experimental lake area, and it's signed by residents of London, Kitchener, Waterloo, and Kingston. And these petitioners have asked the House to reconsider the closure of the ELA, since ELA has been a global leader in conducting whole ecosystem experiments that are critical in shaping environmental policy and understanding human impact on lakes and fish. They asked the government to recognize the importance of the experimental lake area, reverse the decision to close down the ELA research station, and continue to staff and provide financial resources so that this experimentation can continue.
Presenting petitions, Présentation des pétitions. The Honourable Member for Burnaby, New Westminster.
Thank you very much, Mr. Speaker. I'm pleased to present petitions that are signed by dozens of residents of Eastern Ontario, the Ottawa region, and they're concerned about the overcharging on remittance fees, Mr. Speaker. As you well know, many banks are charging up to 25% on remittance fees that are being sent by new Canadian families to their loved ones and their family members overseas. This is an overcharging that hurts lower-income Canadians, particularly hurts new Canadians Canadians, and the petitioners call upon the Government of Canada to introduce legislation that would put into place caps on the types of remittance penalties and remittance fees that are being paid by new Canadians and lower-income Canadians right now, Mr. Speaker. And I'd like to thank the volunteers for HoC Canada for their work in getting involved in talking to people about this issue and making sure that Canadians can have their voice heard on the floor of the House of Commons. Thank you, Mr. Speaker.
Presenting petitions, présentation des pétitions. Questions on the order paper, the Honourable Parliamentary Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I ask that all questions be allowed to stand.
Is that agreed? Agreed and so ordered. The Chair has notice of a request for an emergency debate from the Honourable Member for Scarborough-Agincourt.
Mr. Speaker, on October the 7th, 2012, Hugo Chavez of Venezuela was elected another term as president. On November the 27th, President Chavez underwent treatment for cancer in Cuba, and on December the 8th, it was announced that the president would have to undergo new cancer surgery. Article 231 of the Venezuelan Constitution states that the new president shall be sworn in before the National Assembly on the 10th of January following the election. If this cannot happen, the president shall be sworn in before the Supreme Tribunal of Justice. Due to his illness, President-elect Chavez was not being sworn in before the National Assembly or the Supreme Tribunal of Justice. On January 9, 2013, Venezuela's Supreme Court was ruled that the postponement of President-elect Hugo Chavez's inauguration for an indefinite time is legal. After hearing the Supreme Court's decision, Vice President Maduro indicated that the swearing in of the president was just a formality. President-elect Chavez returned to Venezuela on February 18th and still has not been sworn in as president. The people of Venezuela deserve a president and a judicial system which not only adheres to the letter of the law, but the spirit of the law. The Venezuelan diaspora in Canada is asking that the Canadian government is doing to help the people of Venezuela to ensure that the integrity of the Venezuelan Constitution is maintained and that democratic rights of Venezuelans are not abolished. Therefore, I'm asking for an emergency debate so that the government can answer this very important question and explain what steps it is taking.
I thank the Honourable Member for raising this issue, but I don't think it meets the test for an emergency debate. The Chair also has notice of a point of privilege. The Honourable Member for Skeena-Boku Valley.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise today on a question of privilege pursuant to Section 48(1) of the standing orders that govern this House. It has been demonstrated that the Minister of Human Resources and Skills Development has deliberately misled this House of Commons. Given the seriousness of the matter, it is my duty as a Member of Parliament to bring this question to the attention of the Chair of the House of Commons. Members of the House are all well aware of the rights and immunities afforded to parliamentarians so that they may carry out their duties as members of Parliament. However, for the sake of clarity, let me remind my colleagues that on page 75 in Erskine May's Treatise on Law, Privileges, Proceedings and Usage of Parliament, parliamentary privilege is defined as, quote, the sum of the particular rights enjoyed by each House collectively and by members of each House individually, without which they could not discharge their functions, end of quote. Mr. Speaker, let me take a moment to provide the House with an account of what has taken place to this point. In hearing my remarks, I will ask you to find that the grounds exist that this is a prima facie case of privilege, and this case may be referred to the appropriate committee. 3 weeks ago, the official opposition learned that Service Canada investigators were being imposed upon to find reduction in EI benefits through the seeking of quotas. Each investigator was being asked by this minister to meet a quota of almost $500,000 per employee per year. On February 1st, 2013, during question period, the member for Hochelaga asked the Minister of Human Resources and Skills Development to explain the existence of these troubling quotas. In response to these questions, the minister flatly denied that quotas even existed. She said, and I will quote, "There are no individual quotas for employees of HRSDC who are looking at EI." End of quote. Quote again, "Departmental employees do not have individual quotas." End of quote. Whether she calls these quotas, objectives, or targets, the truth remains the truth. Pourtant, Monsieur le Président, nous avons...
However, Mr. Speaker, we learned today, thanks to a new document obtained by Le Devoir, a daily Quebec newspaper, that in fact there exists a quota for EI premiums which each investigator for the Department of Human Resources has to recover, quotas of which the existence the minister denied. A quota, an objective, a target, the effect is the same. The document in question is called Agreement on Performance and Training, and it numbers the criteria used to evaluate an investigator's performance. One of these criteria is to find a way to save nearly $500,000 annually per employee. By using the word savings, or rather the word savings refers to benefits not paid out or denied to those who need it the most.
Which states the following on page 63, quote, "It is of paramount importance that ministers give accurate and truthful information to Parliament, correcting any inadvertent error at the earliest opportunity." May further states on page 111, "The Commons may treat the making of a deliberately misleading statement as contempt." I would also like to quote the House of Commons Procedure and Practice, Practice 2nd edition on page 115, which states that misleading a minister or a member has also been considered a form of obstruction and thus a prima facie breach of privilege. For example, on December 6, 1978, in finding that a prima facie contempt of the House existed, Speaker Jerome ruled that a government official, by deliberately misleading a minister, had impeded the member in the performance of his duties and consequently obstructed the House itself. End of quote. Mr. Speaker, more recently on May 7th of 2012, you stated the following regarding a similar question of privilege raised by the member for Toronto Centre, and I will quote, "It has become accepted practice in this House that the following elements have to be established when it is alleged that a member is in contempt for deliberately misleading the House. 1. It must be proven that the statement was misleading. 2. It must be established that the member making the statement knew at the time that the statement was incorrect. And 3. That in making the statement, the member intended to mislead the House." End of quote. Mr. Speaker, I believe that the present situation meets those 3 criteria and represents a clear contempt of the House. La ministre des Ressources Humaines et du Développement.
The Human Resources and Skills Development Minister clearly made false statements in-house in response to questions asked on February 1st, 2013. Further, since she is entirely responsible for her department, the minister would have known about performance criteria to assess investigators of Service Canada. Therefore, she would have known of EI reduction quotas imposed on the employees of the department. Further, in the House of Commons, the minister deliberately misled opposition MPs in error, as well as the House.
Members of the House will agree that this is an important and serious offence to mislead one's colleagues, and in particular that this offence was caused by a minister. Misleading the House is a very serious breach of the rules governing our democracy and this institution. I would urge you, Mr. Speaker, to consider these facts and the issues, and if you find a prima facie case of contempt of Parliament, I'm prepared to move the appropriate motion to have this case referred to the Standing Committee on Procedure and House Affairs. Thank you very much, Mr. Speaker.
On the same point, the Honourable Parliamentary Secretary to the Government House Leader.
Thank you very much, Mr. Speaker. I'll try and be relatively brief. But, Mr. Speaker, I must say that at the outset I totally reject the premise of which the member opposite is raising his point of privilege. Clearly, Mr. Speaker, when the minister has responded to questions from the members of the opposition, she has been quite clear in stating without question that the government and the department in question has not placed quotas on any of the employees. Certainly, I believe it is a laudable goal. I hope all members agree with me that it is a laudable goal for any government to try and save money, and particularly, Mr. Speaker, to try and find ways in which to stop fraud from occurring. Now, Mr. Speaker, the minister has stated on many occasions that the department already has saved not millions, not hundreds of millions, but almost close to $500 million in savings through stopping the fraud that had been occurring previously with EI claimants wrongfully claiming for EI benefits. I also suggest, Mr. Speaker, that it's a laudable goal for this government, as it would be for any government, to try and make sure that in future, as we move forward, that we continue to make sure that all EI claimants who ask the government for EI payments are actually doing so legitimately. Because not to be diligent, Mr. Speaker, would be denying those Canadians who play by the rules, who currently receive EI benefits, would be denying them their ability to receive the money in a straightforward and proper manner. Mr. Speaker, I would suggest to the member opposite that our minister, when responding to the questions from the opposition, was being quite forthright, was not trying to mislead this House whatsoever, and then therefore members opposite cannot claim privilege because, in fact, their duties and their responsibilities as members of Parliament have not been impeded. But, Mr. Speaker, I would just close by saying simply this, that the matter of privilege that the member opposite raises obviously is serious. Anytime any member raises a question of privilege, it's a serious matter. And I would therefore ask you, Mr. Speaker, to allow the minister in question an appropriate opportunity at her earliest opportunity to respond in further detail to the point of privilege just made. Thank you, Mr. Speaker.
Here, here.
I thank both members for their interventions and look forward to further points related to this question. Orders of the day, order du jour.
Government orders. House of Commons resuming debate on second reading of Bill C-55, an act to respond to the Supreme Court of Canada ruling in the R versus C case.
We'll now have 5 minutes for questions and comments for the Honourable Member for Dartmouth-Cole Harbour. Questions and comments, questions et commentaires. Resuming debate, reprise du débat. L'honorable député de Portneuf.
The Honourable Member for Portneuf-Jacques-Cartier.
L'honorable député.
Resuming debate.
Oh, who? Oh, there she is. Okay, sorry. L'honorable député de Portneuf-Jacques-Cartier.
The Honourable Member for Portneuf-Jacques-Cartier. Thank you, Mr. Speaker. I'm pleased to rise in the House today to speak to Bill C-55, an act to amend the Criminal Code in response to the Supreme Court of Canada's decision in R versus C. This bill seeks to amend the Criminal Code to establish safeguards with regard to intercepting private communications without previously obtaining additional authorization under Section 184.4 of the Act. Bill C-55, amongst other things, requires the Minister of Public Safety and Emergency Preparedness and the Attorney General of each province to report on the interceptions of private communications made under Section 184.4, provides that a person who has been the object of such an interception to be notified of the interception within a specified period, and this is only done today if accusations have been made, narrows the class of individuals who can make such an interception. So this bill is an update of some provisions of the Criminal Code on wiretapping, provisions which were adopted back in '93. The update was ordered by the Supreme Court following the R versus C case. The court said that Section 184.4 was unconstitutional and that Parliament should amend the legislation by April 13th of this year at the latest. The Supreme Court determined that the provision violated the rights of people against unreasonable search and seizure, and that it was not a reasonable limit on a person's freedoms. Section 184.4 of the Criminal Code does not contain any safeguards and does not notify people whose private communications would have been intercepted. Bill C-55 is a last-minute, desperate attempt by the Conservatives to abide by the Supreme Court ruling. I say last minute because as of today, there are exactly 19 sitting days left to adopt Bill C-55. at second reading, to study it in committee, to adopt it here, and to send it to the other place and to receive royal assent. That's a lot in a short period of time for such an important bill, which could have negative consequences on the lives of Canadians. We need to study the bill in depth. After the defeat with regard to Bill C-30, it's understandable that Conservatives are a little skittish about addressing wiretapping matters again. But Bill C-55 should have been introduced long before today. Maybe Conservatives were looking to reduce the opportunities for people who oppose the bill to speak out. Regardless, we believe this is a first step in the right direction, which is why we're going to support Bill C-55 at second reading, so it can be studied in committee. As I said earlier, the bill attempts to make important and necessary changes to the criminal code in order to make Section 184(4) constitutional by adding certain safeguards based on the directives issued by the Supreme Court. For a long time, the NDP has asked the government to act in order to respect the ruling, and therefore we believe the bill will go to the next legislative process. Any investigative measures which would be amended need accountability to protect the privacy of all Canadians. I recognize the fact that sometimes it is necessary to put a person's privacy in a second order of priority in order to protect others against imminent harm. However, we cannot ignore the fundamental rights of Canadians protected in the Charter. The Supreme Court of Canada established new parameters to protect Canadians' private lives, and we expect Bill C-55 to abide by these new criteria. However,
when you analyze C-55, it's obvious that the Conservatives have to take a second look at their approach to privacy. It's quite clear that Canadians have good reason to be worried about Conservative bills that involve wiretapping and respect for privacy. My New Democrat colleagues and I are aware of the public's concerns about wiretapping, and we share them. During consideration in committee of C-55, the NDP will work for Canadians in order to make sure that there's compliance with the rule of law and the Canadian Charter of Rights, as we always do. We will make sure that Bill C-55 complies with the Supreme Court decision in R versus C in order to make 184(4) constitutional and achieve the necessary balance between freedom and public safety. I urge my Conservative colleagues on the Justice Committee to work with the NDP to improve Bill C-55 and guarantee to all Canadians that we will respect the fundamental rights guaranteed under the Charter. We know that sometimes it's a little difficult to have opposition ideas accepted, but we all agree on the basics. There are amendments to be made to the criminal code in order to comply with the Supreme Court's directives, and we have people in all parties who have impressive expertise in law, who understand what's at stake, and who have suggestions to make sure that public safety in this country is guaranteed for all citizens and that their fundamental rights are also respected. It's important to be able to accomplish this in cooperation with one another to come up with a result that will really protect us against terrorism and any other criminal offense that can harm every Canadian. But we also have to make sure that our individual rights are also respected. It's not necessary for Conservatives to get into ultra-partisan debates, which was the case when they tabled Bill C-30. It's not necessary to be demagogic about this and treat everyone who raises problems with the bill as child pornographers, as the Minister of Public Safety had done when C-30 was tabled. Nor is it necessary to wait for public and political pressure to become so harsh that the government has to abandon its own bill as it did with C-30. After having experienced the major debacle that I've just described, I hope that the Conservatives have finally learned their lesson and are prepared to work with official opposition MPs as well as third-party MPs in order to solve the problems that endure in the Canadian Criminal Code. At the NDP, we share this government's will to maintain and guarantee public safety, but we are also concerned about respecting the principles in the Charter of Rights in each bill adopted in this chamber. Unfortunately, that doesn't always seem to be the case for this government that prefers to be called to order by the Supreme Court after having presented its bills, rather than legislating in a proactive way and making sure that their bills are constitutional before they table them in the House. I think this government could benefit from the advice of opposition members to guarantee that C-55 is in compliance with the Supreme Court ruling in R versus T, and I hope that they will be more open-minded than they have been since they got a majority. I heard many of my NDP colleagues and Liberal colleagues' speeches that see the bill in the same vein, that is, that it attacks a major problem in our criminal code that has been in there since '93 and was never solved, either by past Liberal governments or by the Conservative government. And here we are today with a bill that has been presented in a rather haphazard way at the last minute because of the court ruling, but it wasn't 100% thought out. They didn't consider all the consequences that could result from it, so there's a lot of work left to do. We come here open-minded. We are supporting the bill in second reading so that it can be improved in committee and make sure that it respects the criteria of protecting privacy as set out by the Supreme Court. That's the objective of all my colleagues, both those who sit on the Standing Committee on Justice and those who sit on other committees. That is also the objective of the third party, if I understood correctly. So I hope we will achieve that objective together in committee, and I'll be eager to see the version of the bill that will come out of committee. Thank you. Questions and comments? The Honourable Member for Rivière-des-Mille-Îles. Thank you, Mr. Speaker. We know that the Supreme Court established new protection parameters for privacy, and we expect that this bill will respect those standards. That is what the NDP will demand. But can my honourable colleague explain once again why we only have 19 days to examine this bill? Why has the government waited so long to do this just before the deadline established by the Supreme Court? And how this is impedes our role in oversight in Parliament. The Honourable Member for Portneuf-Jacques-Cartier. I thank my colleague for her excellent question. Unfortunately, my answer would be summed up in one word: arrogance. Ever since this government became a majority government, it has tabled whatever bills it wants to, consults just about no one except people whose opinions they already know and that are the same as their own. The opposition's concerns, be it those of opposition members or the public, are not taken into account. So months and months went by. We'd heard about C-30. We tried to have a debate. We tried to improve it. The public, various members in the opposition ranks clearly told the government what problems we saw in that bill. But they decided that since they had a majority, they were right. And they didn't need to be concerned with the opinion of the opposition. But here we are today, 19 sitting days before the deadline set by the Supreme Court. And we're still debating this bill, which should have been tabled months ago. C-30 should have been abandoned and shelved long ago, and we should have started from scratch. That wasn't done, and that's why we have this difficult situation now.
Comments?
Questions and comments? The Honourable Member for La Salle-Mar. Thank you, Mr. Speaker. And I'd like to thank my colleague for her speech. I'd like her to comment on the importance of accountability. That is, in this bill, we understand that would be exceptional circumstances, and it's very important to have accountability built into bills, have some mechanism for oversight that are well established. In addition to accountability, if this kind of oversight is used. The Honourable Member for Portneuf-Jacques-Cartier. I thank my colleague for that excellent question. The importance of accountability, especially in a bill like this, is that we are violating in a restricted way, but in a way we are affecting privacy. We're talking about exceptional circumstances to protect lives and property from major damage that could occur, but we're giving permission to the police that has to be watched carefully, and Parliament must be informed of the frequency with which these provisions are used or these methods are used. We have to be informed of the kinds of circumstances that surround the use of wiretapping and private conversations. So we need such mechanisms to protect Canadians and ensure that the measures taken to guarantee public safety do not unduly violate the fundamental rights of Canadians under the Charter. The first article of the Charter allows us to go beyond those rights if it's reasonable to do so, but accountability is necessary to keep an eye on that. Resuming debate. The Honourable Member for Saint-Bruno-Saint-Hubert. Thank you very much, Mr. Speaker. Allow me to begin by stating to what extent I'm relieved. I'm relieved that Bill C-30 died a natural death, and my feeling is shared by many citizens in my riding of Saint-Bruno-Saint-Hubert. A large number of them wrote to me to express their concerns about this ill-advised, flawed, and dangerous bill, which was C-30. I'm glad to see that's behind us now, and that we can finally concentrate on the issues that the House must consider regarding Section 184.4 of the Criminal Code. And I think it's the first time since I've sat in this House that the government has agreed to listen to reason and recognize that its initial strategy was not the right one and did not correspond to the needs and desires of Canadians. I congratulated and invited to do this more often. You'll see it's not that complicated, and everybody feels better afterwards. In fact, I suggest that the government try this again with the EI reform. It feels so much better when things are done right. Now, having said that, let's get back to the issue at hand. Let's be honest here. The bill before us looks more like an appropriate response to what the court asked for than the former bill C-30 was. This new bill is just an update of the provisions regarding wiretapping that the Supreme Court had deemed unconstitutional. This bill is before us following a decision by the Supreme Court of British Columbia, which was confirmed by the Supreme Court of Canada, which ruled that Section 184.4 of the Criminal Code was unconstitutional. This section allows a peace officer to intercept certain private communications without prior legal authorization if there are reasonable grounds to believe that immediate interception is necessary to prevent an unlawful act that would cause serious harm, if a warrant cannot be obtained with reasonable diligence. The courts established that urgent situations did exist, but that we had to strike a balance and find measures to protect citizens against unreasonable search and seizure and the interest society has in preventing serious harm. That's why the courts deem that Section 184.4 of the Criminal Code violates Section 8 of the Charter of Rights because it does not provide for an oversight mechanism, and more particularly does not require that the people whose private communications have been intercepted be notified. It is necessary to adopt an accountability mechanism to protect the important interests related to privacy, which are at stake here, and a provision requiring notification would suffice to meet this need. The obligation to notify people whose communications are intercepted would not impede police action in an emergency. However, it would increase the ability of targeted people to identify and contest any invasion of privacy. I forgot to say at the beginning that I would be sharing my time with my colleague from La Salle-et-Mar. So let me get back to my speech. I was therefore saying that would allow them to contest this invasion of their privacy and obtain actual remedies. That's part of the balance that we must seek to strike. It is that balance that we must ensure. We must make sure that there are safeguards put in place in order to avoid abuse and guarantee that our fellow citizens' rights and freedoms are not violated by any legislation adopted in this House. One of the ways to ensure this and follow the directives that the courts have established, especially with regard to the right to privacy. There are some aspects that were in direct response to the court rulings. For example, this bill imposes on the Minister of Public Safety and an emergency preparation and the Attorney General of each province to report on interceptions under Section 184.4. It provides that any person targeted by such interception be notified within 90 days normally, but this could be extended up to 3 years in cases of terrorism and criminal organizations. The bill also restricts the category of persons who can proceed with such interception and limits these interceptions to offenses under Section 183 of the Criminal Code, and that's quite a long list. In my opinion, these measures are in accordance with the directives of the courts, but we must make sure that they respect the Charter. Like my other NDP colleagues, I hope that this bill will get to committee so that witnesses can be heard and that we can obtain answers to some questions or at least clarification on certain points. The Criminal Code should not be amended this time only to have the courts decide once again that whatever has been done is unconstitutional. It is our duty as parliamentarians to make sure that the rule of law is respected and that Section 184.4 is amended so as to comply with the Constitution and the Charters and Canadian law. The parameters have to be clear. It's obvious that I don't trust this government blindly. Canadians have good reason to be apprehensive about conservative bills when it comes to privacy. Their track record is far from glowing on this issue. We must always work for the public while respecting the rule of law, the Constitution, and the Canadian Charter of Rights and Freedoms. After the attempt through Bill C-30, I'm sure you will agree that that's quite normal. Many Canadians and stakeholders are also concerned. Let me quote Michael Geist. Bill C-30 may be dead, but legal access surely is not. When the government dropped Bill C-30, it introduced Bill C-55 on wiretapping without a warrant. Although this is a response to the Supreme Court decision in R versus C, a large part of the bill is lifted directly from Bill C-30. And I think Mr. Geist is right. That's why we have a duty to be vigilant. The court established new criteria for the protection of privacy, and we expect that this bill respect these standards. That's why it must be considered in committee so that we can make sure that is the case. Thank you very much.
Questions and comments? Questions et commentaires?
The Honourable Member for Pierrefonds-Dollard. Thank you, Mr. Speaker. I thank my colleague for her passionate speech once again. I'd like to ask her about the time we have at our disposal as parliamentarians to seriously consider this bill. As my colleague briefly mentioned, we have 19 days, 19 sitting days where Parliament can respect the deadline set by the court. And that's a problem because the court didn't hand down its ruling just a few days ago. It was months ago, a year, I believe. So why is it that 19 days before the deadline, we suddenly see this bill appear before us? Isn't that a way to prevent rigorous work by parliamentarians? I'd like to hear my colleague about this.
The Honourable Member for San Bruno, St. Hubert. I want to thank my colleague for that relevant question and her very good analysis as usual. As she said so well, unfortunately, there is only 19 working days to try to work and analyze the bill before us. We know full well that this is common practice here in the House since I've been elected. This government uses gag orders for opposition members in order to take advantage of its majority in the House. But unfortunately, as my colleague does, I am critical of the fact that we only have 19 days to work on such an important bill as this that concerns the privacy of Canadians. Questions and comments? The Honourable Member for Marc Aurel Fortin. Thank you, Mr. Speaker. In this bill, it is clearly indicated that with regard to C-30, they're taking out peace officers and replacing that with police officers and other individuals. But the other individuals haven't been defined, that is, those who can conduct wiretapping. Is this the military? Does that mean immigration officials? Are we talking about customs officers? The Coast Guard? Other individuals has not been defined, and the question that I want to ask my colleague is this: would it not be pertinent in Parliament, in the Parliamentary Committee rather, to clarify what those other individuals means? The Honourable Member for San Bruno St. Hubert. Once again, I want to thank my brilliant colleague, as usual, who tries to always find the flaws in the bills being introduced and put to us, and he's always right. This is quite clearly the case. We in the NDP are demonstrating our goodwill to work with the government, and we will support this bill to ensure that it can go to committee And eventually, we can talk about the definitions of who those other individuals are, that is, those who would be able to conduct this kind of activity. And I hope that we'll have clear answers in committee, and we'll see after that. Thank you very much. Questions and comments? The Honourable Member for La Salle-Mard. Thank you, Mr. Speaker, and I want to thank my colleague for her speech. I would like her to talk a little bit more about the difficulties that we sometimes have in committee. It has been noted that often in committee we propose amendments, and I would like her to talk a little bit about these difficulties, and if she has confidence that in this case, with this bill, that the government will listen to us. The Honourable Member for St. Bruno St. Hubert. Thank you once again to my NDP colleague for the work that she does here in the House. She's always here to ask the right questions, and I can tell you that the proof is in the pudding. The questions are in fact only coming from my NDP colleagues. I presume that the other parties, the government included, are not interested in the issue that we're talking about today. Obviously, I, like the rest of my colleagues, have concerns about the bill, and when it gets to committee, I do hope, I really do hope that our colleagues on the government benches will have the decency to talk about this issue as we need to talk about it, because it concerns the privacy of Canadians. Resuming debate. The Honourable Member for La Salle-Mard. Thank you very much, Mr. Speaker. I rise today to talk about Bill C-55, and this is a bill that amends the Criminal Code in order to respond to the Supreme Court ruling in the R versus Shea decision with regard to the interception of private communication without prior judicial consent under Section 184.4 of the Act. I would like to talk about the four main points in the bill. It imposes on the Minister of Public Safety and Emergency Preparedness and the Attorney General in each province the duty to report on the interception of private communication under Section 184.4. Second, it sets out that any individual who is the subject of such an interception must be advised of this within a certain time period. Third point restricts the category of individuals that can conduct such interceptions, and fourth point limits those interceptions to the offenses set out in Section 183 of the Criminal Code. Why am I stressing those 4 points which are in the summary? Well, it's because we expect to find in this bill these points well defined. So my first point, and this in fact has already been raised by our justice critic, and that is the definition that we see of the word police officer. And it will be important in committee for us to be able to have the possibility to better define this. They're restricting the definition, but an officer or police officer or any other individual responsible for maintaining public peace. So I would like to have some precision in this regard. So this bill updates the provisions on electronic wiretapping that the Supreme Court had ruled unconstitutional. So this recalls the entire saga of Bill C-30, and now we're in the House with just a few days to study this bill. And when it goes to the Standing Committee on Justice, the number of days that will be available to that committee to really do a serious study of it is an issue. And really, we should have established a calendar that would have been more respectful of the importance of the bill itself. Nonetheless, and also to properly define the ideas contained in the bill itself. I would also like to mention that it will be also important with regard to this bill to talk about the investigatory measures that include reporting and oversight. As I mentioned with regard to the 4 points that I brought up, it will have to be properly defined and to ensure that there are reporting mechanisms, as we would say, a check and balance system. And also we have mentioned that this bill must maintain a balance between the need for surveillance with specific conditions and exceptional circumstances that are well defined, because we're talking here about measures that need to be used on an exceptional basis, but that there will also be reporting to ensure the frequency of the use of this mechanism is followed, and also to have the power to notify individuals who were affected, if you will, by this type of interception. The other point that needs clarification is the following. Mr. Speaker, you know that I'm the critic for industry, and on the industry committee we studied electronic commerce, e-commerce, if you will, and that's all you need to say to indicate that our world is constantly evolving and technology is becoming increasingly important. New technologies are coming out every day. We're surrounded by electronic means of all kinds. In 184.4, what it says is that a police officer will need to be defined, because here we're also talking about or another person may intercept by means of an electromagnetic, acoustic, mechanical, or other device, a private communication, if the police officer has reasonable grounds to believe that, and it goes on. And here I see or other device. I'd like to know what that other is. What does that include? So I would refer to the public consultations that took place that were sponsored by Industry Canada with regard to the broadband auction for the 700 megahertz broadband auction. These public consultations, in fact, were an opportunity to raise some points, and I'm referring to a document that was provided by a man who very closely follows everything concerned with electronics following the presentation of Bill C-30. And I would mention here, just a moment, let me see, what is his name? Mr. Parsons, I believe. And he mentions in one of the documents that, yes, Mr. Chris Parsons is his name. And he mentioned that during those public consultations, and it's not just him who says it, but this is public information, but that people had been asked, people who wanted to testify during the consultations, to talk about the means by which they could provide information and using other techniques, be it through the internet or whatever. And in fact, I would like to read in English what this was.
Je cite, the consultation has asked participants to provide comments on a variety of issues. What I focus on are the proposals revolving around lawful intercept conditions of licensing Canadian radio spectrum. These conditions are addressed in paragraph. Et ensuite,
and then
operating as a service provider using interconnected radio-based transmission facilities. Et ensuite,
then what occurred was that people who testified, that is, people from different associations such as, the Internet organizations and so forth, and the question was it realistic to ask these agencies to ask for proposals on how they would do this when there is a legislative vacuum in this area? And we hadn't yet studied the bill, which was C-30. And so there is the question, for example, the Canadian Wireless Telecommunications Association said, in fact,
the department is proposing to replace circuit switch voice telephony system with interconnected radio transmission, which opens up several additional services to intercept requirements, including Internet. Et ils allaient plus loin.
And they went even further to say, well, listen, it's not up to us to do it. There has to be legislation in place to ensure that we can know what the situation is. And that is why I wanted to raise these points, because I believe that Bill C-55 is very important because we really have to properly define what is set out in the bill, particularly when we talk about intercepting by means of any electromagnetic, acoustic, mechanical, or other device of private communication, while respecting the need for public safety in exceptional circumstances, but also what is extremely important, as well as for my constituents in La Salle-Marde, is to ensure that privacy is respected. And this is really important. It's important to have in a bill such as the one before us, which is Bill C-55. It's important to ensure that we have oversight mechanism as well as reporting mechanisms. I believe you'll agree with me, Mr. Speaker, that these are fair and justifiable requests, particularly when it comes to defending the good or the common good and the good of our constituents. Thank you, Mr. Speaker.
Questions and comments? Questions and commentaires?
Questions and comments.
For Winnipeg North.
Yes, thank you, Mr. Speaker. I'm wondering if the member might want to provide some comment in regards to the fact that at the end of the day, we pass a considerable amount of legislation through the House of Commons, and many of us would argue that when government ministers bring forward legislation, that there is an obligation for them to ensure that the legislation that they're bringing forward is in fact reviewed with the intention of ensuring that it would meet constitutional and charter potential challenges. And I'm wondering if she might want to provide some comment on the importance of the ministers doing work prior to the introduction of legislation to ensure as much as possible that the legislation that we're being asked to actually vote on is in fact constitutionally correct.
La Salle-Marde.
Member for La Salle-Marde. Thank you very much, Mr. Speaker, and I want to thank my colleague for his question, which is quite fair, because in fact there is a lot of work when a bill is introduced, a lot of work that needs to be done in preparation for the introduction of that bill in order to avoid later having to have recourse to the courts, which ultimately take a lot of time. And instead, it would be quite easy to verify the constitutionality of that legislation. So I think that question is, and his comments as well, are completely appropriate.
Questions and comments? Questions and commentaires?
Questions and comments. The Honourable Member for Pierrefonds-Dollard. Thank you, Mr. Speaker, and I'm pleased to ask my colleague from La Salle-Marde a question. First of all, I want to congratulate her on her very pragmatic speech that concentrated on the potential flaws in the bill and that illustrated the fact that she hopes that the work will be done in committee, not just work like this to talk about it and then come back at third reading with exactly the same bill, but rather, and not because the studies and analysis weren't good and because that's it and we're going to plug our ears no matter what the opposition parties say. And I would like my colleague perhaps to have an opportunity to come back to the fact that, first of all, there are very few days in which to do the work that has to be done and done properly and seriously. And secondly, the hope that we have in supporting this bill at second reading, that in fact it will be studied seriously and with openness on behalf of all the participants of the Standing Committee on Justice. The Honourable Member for LaSalle-Marde. Thank you very much, Mr. Speaker. And I want to thank my colleague for her question because, in fact, this bill is the result of a decision made by the Supreme Court of Canada. And what that means is that this bill is a reaction instead of being proactive, as we must do when there are issues that have been raised and were, in fact, raised a number of years ago, and that will continue to be raised. So I think that there is, in fact, work that needs to be done. What is unfortunate is that because of lack of time, because the government did not introduce this bill earlier, we are now limited in the amount of time that we'll have. And I hope, as my colleague also hopes, that once we get to committee, the government will listen to the improvements that might be proposed, and also to ensure that there will be clarification, as has been mentioned earlier, so that we don't wind up with something that is in violation of the Charter of Rights and Freedoms, and that we'll wind up once again with a bill that will be unconstitutional. So we'll have a lot of experts, a lot of people who would be able to help us to ensure that this bill does meet the needs of Canadians as well as the needs of public safety. Thank you.
Pleasure for me to rise today to say a few words on Bill C-55. There are many thoughts that I would like to be able to share with members, albeit somewhat limited in terms of time. I wanted to pick up on two or three themes. One, which I always take a great deal of exception when the government does things in such a fashion that it really is what I would ultimately argue is disrespectful in terms of the functionality of the House. I think that it is an absolute privilege to be a member of Parliament, and I value it, the role that I get to play, and I thank the constituents of Winnipeg North for allowing me to represent them, and I'm also very grateful in terms of my the Liberal Party in allowing me to respond to the different bills and so forth. Having said that, Mr. Speaker, when I look at what the government is doing here, is once again, I do find that it is somewhat disrespectful. Why do I say that? We need to recognize that there was the Supreme Court of Canada that actually made a decision that has precipitated the legislation that we have today. Now, this wasn't a decision that was made a month ago or 2 months ago, Mr. Speaker. This is a decision that was made back in April of 2012. The government has known for months, Mr. Speaker, that they needed to change the legislation. And there is absolutely no reason whatsoever that they could come up with to justify the delay that they have taken in terms of being able to introduce Bill C-55. And what they have done, Mr. Speaker, is through procrastination, is now put the House of Commons in a position in which that if we want to respect what it is that our Supreme Court has ruled, that there is now pressure on members to ultimately pass this legislation. not only through second reading in committee, and then coming back through third reading and so forth, Mr. Speaker. They want it passed before now April the 13th of this year. And today is the first opportunity to actually debate the bill, Mr. Speaker. And it is a significant issue. So one has to ask the question, well, why is it? And this is something in which this government, former reformers, Mr. Speaker, the now Conservatives, they call themselves Conservatives, have taken a different approach at dealing with legislation. Mr. Speaker, we'll recall that we had the two massive budget bills where the government was through the back door of these two massive budget bills making amendments to dozens of pieces of legislation. I'm somewhat surprised that they didn't incorporate this one in. I guess the minister responsible didn't quite think about it, Mr. Speaker, or maybe didn't get the message from the PMO office that they could have, that this bill was coming forward in terms of the budget bill. But I'm glad, at the very least, that he didn't take advantage of the budget bill. But, Mr. Speaker, we've had this government bring in time allocation, record numbers of time allocation. I would ultimately argue, and I have a list, and it's a fairly lengthy list, Mr. Speaker. I won't go through the entire list, but some of these issues on time allocation were quite significant, whether it's back to work type of legislation, to the gun registry, pool pension plan, the Canadian Wheat Board, Air Canada, there's C-31, C-27, numerous bills, Mr. Speaker. All of this deals with the opportunities that members of Parliament have to provide due diligence and to be able to go through the legislation in a timely fashion in order to ensure that the legislation that comes before the House is, in fact, talked about and debated, and ideas hopefully stem out of these debates, Mr. Speaker, that ultimately see it go to committee and allow committee to do its job and hopefully have a government that's sympathetic to recognizing that their legislation quite often needs to be amended. And you will find that there are amendments that come from many members on a wide variety of pieces of legislation. So now today we have a very short window. Time allocation won't, I suspect, be placed on this particular bill, Mr. Speaker, but there is, a high sense of cooperation from opposition parties. On behalf of the Liberal Party critic was able to address the bill earlier today and has indicated that we're very comfortable in seeing this bill actually go to committee. We recognize the importance of allowing the bill to go to committee. But that doesn't excuse the government, Mr. Speaker, of its irresponsible behavior in terms of not providing the House and providing the respect that's necessary when we have to deal with legislation. The government should be held accountable for taking so long in bringing this legislation before us, Mr. Speaker. But I can tell you that the Liberal Party will behave responsibly in trying to do what it can to get it to committee. And we would hope that the government, in fact, would be sensitive to possible changes or possible amendments to the legislation. Mr. Speaker, we recognize that the bill does deserve attention in committee, and we understand that there will be, hopefully, some changes that will be brought forward. There are four things that Bill C-55 attempts to do, Mr. Speaker. One is require that the Minister of Public Safety and Emergency Preparedness and the Attorney General of each province to report on the inception of private communications made under Section 184.4. Well, Mr. Speaker, I think that that's a positive request. It's something in which the Supreme Court wasn't really requiring. It is a reporting mechanism, and I think that there's great merit for it, Mr. Speaker. They're asking through C-55 that it would provide that a person who has the object of such an interception must be notified of the interception within a specified period of time. when you think about that, Mr. Speaker, one of the things we have to give thought to, and hopefully this will come out in committee, is what is the appropriate amount of time. We're very much aware of the importance of our charter and protecting our privacy, and there has to be a balancing that takes place in terms of the public good, Mr. Speaker, and life-threatening situations and so forth. But there also needs to be a protection for individuals that ultimately might be subjected to this, Mr. Speaker, a warrantless wiretap. And I would suggest to you, Mr. Speaker, that the committee would do well by having some dialogue on that particular issue. Should it be 90 days? Should it be less than that? What are the arguments and the concerns? And it'd be interesting to hear what the stakeholders actually have to say on that particular point, Mr. Speaker. The third thing is that it narrows the class of individuals who can make such an interception of wiretapping, Mr. Speaker. My understanding is that it is more general today, and what they want to be able to do is to narrow it to include police officers. The idea, and again, let's hope we'll maybe get some dialogue at the committee stage in regards to the contracting out. There are many municipalities throughout Canada that actually private out or hire out private services related to security and policing. And how are they going to be incorporated, or will they be incorporated? This is something that hopefully will be talked about, Mr. Speaker. Limits to those interceptions to offences listed in Section 183 of the Criminal Code. And again, I think there's an opportunity. We can appreciate when you have this type of authority being issued out, you want to be very careful in terms of when and for what circumstances it's going to be utilized for. Two things that come to mind is life-saving things or kidnappings, Mr. Speaker. These are the type of things in which timing is of the essence, and there might be a requirement for us to be able to ensure that our law enforcement officer is in fact able to get the information necessary as quickly as possible. Now, I understand, Mr. Speaker, that we've had actually, and the Minister and others have talked a lot about Clause 184.4, Mr. Speaker, and that's really what we're talking about, and this is what the Supreme Court has made its ruling on. In going through some notes, Mr. Speaker, and in particular some comments from our judges, I thought maybe what I would do is share two that I think that are really important in terms of recognizing. The one, Mr. Speaker, and again, this is related to Section 184.4, which does deal with the warrantless wiretapping provisions. And the first quote is, coming from one of our court judges, is, and I quote, "The privacy interests of some may have to yield temporarily for the greater good of society. Here, the protection of lives and property from harm that is both serious and imminent." And, Mr. Speaker, I find that to be a most appropriate statement, and one of the reasons why I raised just a few minutes ago why it's important for us to take a look at what is the most appropriate time frame that when you have someone's wireless or telephone conversation being tapped into and the individual's not aware of it, what is an appropriate amount of time between the law officer wiring or taking a recording of a conversation and that individual's right to know that that recording was in fact taken. The bill here is suggesting, from what I understand, 90 days. Well, Mr. Speaker, I think the judge correctly here has pointed out the importance in terms of the public, and at a time we need to recognize that it does outweigh the private interest. but in the same breath, it's still important that that private interest be protected in some fashion. The second quote, and again, it's a direct quote, Section 184.4 contains a number of legislative conditions. Properly construed, these conditions are designed to ensure that the power to intercept private communications without judicial authorization is available only in exigent circumstances to prevent serious harm. To that extent, the section strikes an appropriate balance between an individual's S8 charter rights and society's interest in preventing serious harm. Mr. Speaker, I wanted to at least in part to quote that is because I, for one, do believe very passionately in the Charter, as I believe a vast majority of Canadians over the years have recognized how important it is to protect the Charter of Rights and to refer to the Charter of Rights, because we have taken ownership of that over the last 30 years, Mr. Speaker, and we need to do what we can to always kind of reflect on that. And that's one of the reasons why earlier today I've had the opportunity to ask a number of members a very important question that many have taken for granted, I believe, Mr. Speaker. And I want to use a couple of examples. I'm the critic for citizenship and immigration. And I've been frustrated by that particular minister and some of the legislation that he has brought forward. The question that I posed to members earlier was all related to the obligation of government ministers to take the changes that they're proposing or in the draft stage, Mr. Speaker, and to find out whether or not, or to get a better sense whether or not that these changes are in fact going to be meeting the Charter of Rights, or would pass a constitutional challenge, Mr. Speaker. And that's been an important issue for me because at the end of the day, I have seen that issue raised in our committee on several occasions. In fact, earlier today, there's a group of lawyers and doctors in Toronto that are now going to a federal court questioning the constitutionality of the Minister of Immigration's decision to cut back health care services to some of the most vulnerable in our society, Mr. Speaker. And this is something in which, at the end of the day, we've challenged the minister on it. Now it's going to a federal court. We're not confident that the minister knew what he was doing when he brought in that change, Mr. Speaker. But it was amazing when the minister, and it was through Bill C-38, made changes that ultimately just deleted hundreds of thousands of skilled workers, Mr. Speaker. And again, we questioned the minister is, not only does it on the surface come across as a very cruel and inhumane policy change, but when he brought in the change to do it, that change is now being challenged by a federal court. And in fact, there was a ruling that was made by one court in Ontario indicating that the minister was wrong. Now, I'm not too sure exactly where it's at within the Department of Immigration, but that was another issue. Then we had the issue of detention. And this is where the committees really do benefit, Mr. Speaker. We had a minister that was going to put individuals in a detention center without any real right of appeal for a year, Mr. Speaker, where they'd be held in detention centers. Now, we were able to make some serious changes to that at the committee stage, but it took a whole lot to do it, Mr. Speaker. And this was legislation. And again, we had presenters come to the legislation saying that this will not meet constitutional challenge. It's important. And when we look at the area of justice, like Bill C-30, and I always thought Bill C-30 was an interesting bill in the sense that when it was introduced in the first place, and now I understand that the government has withdrawn from Bill C-30, and one of the arguments for Bill C-30 was that it didn't go far enough in order to be able to allow police officers to have these warrantless wiretapping provisions, and specifically in regards to Internet services, Mr. Speaker. And now Bill C-30 has come to a standstill. The government has backed off on C-30 for a wide variety of reasons, no doubt, Mr. Speaker. But I do question whether or not the current clause of 184.4 is in fact something that would have been able to deal with many of the measures that were being suggested in Bill C-30. And is that one of the reasons why the government's not moving forward with that legislation? And ultimately, if that is one of the reasons why they're not moving forward with that legislation, then one could question, well, why did they then bring forward Bill C-30 in the first place, Mr. Speaker? You know, what happened in regards to the exploitation of children on the Internet? Does that, in fact, have any place, or does that issue get addressed in 184.4? Personally, I'm interested in knowing that. I do know that there was an attempt in C-30 to be able to deal with that, Mr. Speaker. So, you know, when I look at Bill C-55 as a whole, I do see that there is merit for us to allow this thing to go to committee. I'm interested in hearing what will ultimately take place in committee, and hopefully that there will be some discussion, and that they'll bring in some of the discussion possibly from Bill C-30, because there might have been some issues related in Bill C-30 that amendments or changes to Bill C-55, by accepting some possible changes, it might be able to deal with some of the things in C-30 in which the government might have messed up, Mr. Speaker, because there are concerns in regards that Canadians have in regards to things such as the exploitation of children over the Internet. I don't know, as I say, to what degree this particular Bill C-55 would assist in extreme circumstances in dealing with that sort of an issue. So, Mr. Speaker, we look forward to the bill going into committee. Again, I hope and trust that the government will look at legislation as a whole being brought into the House in a more timely fashion, and allow for members to be able to provide the diligence that's necessary, and ultimately not be rushed to have to pass things through many different stages in order for it to meet a deadline such as a Supreme Court decision. And I thank you, Mr. Speaker, for those opportunity to be able to share my thoughts.
Before we proceed with questions and comments, it is my duty, according to Standing Order 38, to inform the House of the questions to be raised at the adjournment tonight. Charlevoix, Haute-Saint-Charles, Employment Insurance, the Honourable Member for Quebec, Search and Rescue.
Question and commentaire. The Honourable Member for Halifax.
Thank you, Mr. Speaker, and I thank the member for Winnipeg North for his speech. He made a number of good points, and he talked about the value of fulsome debate here in the House, and he also hoped that if there was new evidence coming out at committee that changes would be made to this legislation. And that made me think about the court case that actually has prompted this, this bill, R versus T. And this case actually quotes testimony from committee. It quotes witnesses to try and determine what the intention of Parliament was when this section of the Criminal Code was originally introduced in 1993. And I think that speaks volumes about the value of the work that we're doing here. It is about what happens at committee. It is about what we say in the House about this legislation. It's not just the vote. The discussion and the debate really matters. And so my question to him is he confident that at committee, with a Conservative majority, that this committee would actually adopt any recommendations? Because I haven't seen a good track record on that front, so I'm wondering what he thinks.
The Honourable Member for Winnipeg North.
Yes, Mr. Speaker, the member brings up a good point. First, if I may, you know, I can recall a very heated discussion that I had with many different stakeholders regarding the Air Canada Public Participation Act. and how individuals referred to what took place at the committee level. Because at the committee level, it even went further in terms of explaining what was in the legislation. And the legislation itself, in essence, guaranteed jobs in places like Winnipeg, Mississauga, and Montreal, Mr. Speaker. And when those jobs or those positions were in fact lost, we went to what the legislation said, and then went into the committee stage and started to pull the comments. And it was amazing in terms of how much more clarity it provided to the issue, and it reinforced that from our perspective that Air Canada was in fact in violation of the law. Now, I say that because I do agree with the members' comments. Committees do matter. What takes place in committee and the context in which bills are explained, especially when you get ministers providing or government members providing further detail and consensus is developed, that it assists going forward. At the end of the day, Mr. Speaker, I would like to think that the government would be sympathetic to amendments, but I can understand why members would feel discouraged, for the simple reason is that it's very difficult with the Conservative majority government to get any amendments passed. On one occasion that happened to be in justice, we had to let the Senate ultimately make some changes, even though the government was aware of the changes that were necessary.
Questions and comments? The honourable member for Saanich, Gulf Islands.
Mr. Speaker, I think we all agree that we want to make sure that the criminal code complies to the Charter, and the fact that the Supreme Court of Canada has given the government, the Minister of Justice, a full year to try to make sure it does, puts a great burden on us as parliamentarians to ensure that any legislation we pass will survive a subsequent Charter challenge should it come to that. And I'm concerned because when I read the Supreme Court of Canada decision, at paragraph 90, there's a reference with favour to the view of Mr. Justice Dambrot in the Riley case, in which they point out that, quote, a legislative reporting requirement, which is what's in this bill, such as Section 195, that does not provide for active oversight of wiretapping generally, far less any particular use of wiretap provisions, cannot be a constitutional requirement of a reasonable wiretap power, and so on. I'm wondering if this bill is likely to fail another Charter challenge, and if the opinion of the member for Winnipeg North needs an amendment to provide some sort of active oversight of wiretapping more generally, taking the view from the Supreme Court.
The honourable member for Winnipeg North.
Yes, Mr. Speaker, and I appreciate the question. Having said that, I do believe at the end of the day that the government already has a fairly decent sense from opposition members as to what are the issues that we have some concerns with. And at the end of the day, what we want to be able to see is legislation that will, in fact, pass any sort of a constitutional or charter challenge. It's going to be up to the government to recognize the value of making some changes. I do believe that if you give the committee members or the stakeholders the opportunity to present, that any misgivings that are in the legislation will in fact be overcome. As the Liberal Party critic addressed some of the issues or made reference to the issue that the leader of the Green Party has just referenced, I suspect that it will be discussed at the committee stage, and if the government is prepared to accept that there are some amendments quite possible that are necessary in order for it to, in the future, to withstand any sort of constitutional or charter challenge. Thank you, Mr. Speaker.
Questions and comments? L'honorable député de Macquarie.
The honourable member for Macquarie-Fortin. Thank you, Mr. Speaker. Perhaps the member could comment on one of the flaws in this bill. Essentially, in a private conversation which is violated, there is an expedient of urgency. This can be repeated over a period of 3 years, which seems to me very long to deal with an emergency. It seems to me that in the weeks following the interception of that conversation, the police force could ask a judge to make it legal. Why can this be repeated so often over a period of 3 years.
Yes, Mr. Speaker, there is no doubt that we do need to ensure that there's adequate safeguards to protect an individual's right to privacy. Within the legislation that's being proposed, there is an obligation on the individual, the law officer, or the agency to, in fact, inform the individual that had their phone line, for example, tapped. I believe it's suggesting 90 days in the legislation. I think that we're open to hearing what the stakeholders have to say with regards to that. I think everything depends in terms of the need. There is a need for that 184.4. There's no doubt about that. But there's also a need for safeguards. And I think that that's what we're really asking for. In situations where a court order can be achieved, and that would be the vast majority of situations. This should be rarely used. I suspect that at the end of the day that the normal procedures would take place. But if there's someone's life that's in danger, and it's a matter of minutes or possibly hours, and by having to go through a judge that it could put someone's life in danger, I think at the end of the day, as the one judge ruled, that sometimes we have to forego a bit of the privacy in order to save that life for the public good, as long as there is some check or balance in place to ensure that there is a safeguard, that we don't go overboard. And that's the reason why I think tracking the numbers, how often it is used, year over year going forward, I think there's a great deal of merit for that type of thing. So we'll have to wait and see, Mr. Speaker, ultimately. But I do believe that 184.4 does allow for us to, our police officers, to do what they believe is necessary in order to save a life. If, in fact, by going to a court to get the warrant is required, 184.4 allows them to take that shortcut, which I suspect will be very rarely used.
Questions and comments. Time for a short question and response. The honourable member for Halifax.
Okay, sure. So one thing that the Supreme Court of Canada expressed reservations about was the idea of a peace officer having all these powers. When I read the bill in front of me, it's been changed to police officer. So it's actually narrowed it to police officer versus like a bailiff or a mayor, for example, who would be a peace officer. On first reading, I think that strikes a good note. But I'd be interested in hearing what the member from Winnipeg North thinks about this at first reading.
Honourable member.
Yes, Mr. Speaker, the Liberal Party's critic had the opportunity to address that specific issue also. And at the end of the day, narrowing the scope, I believe, is a good thing. We want to, like, my understanding is the legislation included, for example, in its current state, that a mayor would have that authority. I'm not convinced that a mayor should have that authority. So, at the very least, I suspect that if we're wrong or the government's wrong on that particular point, that someone, one of the stakeholders will make that case at the committee stage. I do believe that it is necessary for us to narrow that gap or to be a little bit more specific. I think that's good, given the authority that this C-55 is going to be giving. I think it's a responsible suggestion.
Reprise de débat.
Debate. The honourable member for Marc-Aurèle-Fortin. Thank you, Mr. Speaker. At the outset, I'd like to indicate that I will be sharing my time with the member for Laurier-Sainte-Marie. So, Mr. Speaker, the NDP is in favour of second reading of this bill so that it is examined in committee and that its flaws be corrected. That's the problem. This is a nice bill, especially if compared to its relative Bill C-30, which fortunately was withdrawn. I think the government didn't have much choice, frankly. And we in the NDP think it is reasonable that Canada have the means to protect its laws, its public, the population, and property. There are urgent situations that require an intelligent application by a police force of a method to solve a crime. We agree with that fully. Unfortunately, though, the devil's in the details, and the details are quite numerous. We need to clarify this and solve certain problems, and in committee, the NDP will do just that. There are many deficiencies. One of the problems is that this government has a lot of trouble applying the Charter of Rights and Freedoms. The number of bills that this government tables that are considered ultra-virus by the Supreme Court is becoming indecent. One of these days, this government has to understand that the Charter of Rights can't be just set aside to suit its whims. The Supreme Court will take pity on them someday and say, look, we'll agree to violate the Charter to accommodate a government that doesn't understand it? No, that's not how it works. In fact, as Einstein said, the definition of insanity is doing the same thing over and over again, but expecting a different result. So obviously, this government suffers from this folly. It systematically repeats the same mistake, systematically violates the Charter, and hopes that someday these violations will be accepted by the Supreme Court. That's not how things work. In the present case, we have to work on this quickly and vote on it urgently. We have very little time to consider it. Essentially, because of a year-old Supreme Court decision, R versus C, which invalidated Section 184.4 of the Criminal Code that authorizes the wiretapping of private conversations without a court warrant or court order. At the outset, the Supreme Court stated that in exceptional, urgent cases where there is serious imminent harm to persons or property, it is normal that a democracy use the means to defend itself. The problem is the Supreme Court indicated that this reasonable violation of the Charter of Rights should not open the door to all forms of repression. And that's where it said, you're going too far with 184.4. We're telling you that you have to cut that. You have to restrict the rights indicated here and clearly explain that the situation is urgent and exceptional. The person targeted must be notified. It has to be approved. If it's to be maintained, it has to be approved by a court. Now, in fact, 184.4 of the Criminal Code indicates the list of events that open the door to the application of 184.4. That's fine. It has to be restricted to 183. You cannot allow a police force to go on a fishing expedition and abrogate the right of wiretapping because it thinks that maybe someday something will happen. That is not authorized by the Supreme Court. Using Canadians' private information is important. What's troubling is that this same government has this tendency to lose confidential information belonging to Canadians. It forgets 500,000 files on people who have student loans. It loses information on Aboriginal communities. It loses a lot of information. It'd be nice if someday this government did things a little more seriously. So, when it comes to restricting rights, we will be strict. We will not allow killing off democracy to preserve democracy. And that's what's at stake here. Here, in a state with the rule of law, a democracy, we are accountable to the justice system, to the law. And clearly, We're debating this bill essentially because Section 184.4 does not meet the criteria set out by the Supreme Court, does not meet the criteria of the Charter of Rights, and Bill C-30 certainly didn't meet those criteria. It's unfortunate that there's a relationship between C-30 and C-55, and that is the relation that the NDP seeks to restrict in committee. So the question that arises, are we to sacrifice democracy to save it? The NDP answer is quite clear and intelligent. It's no. The Supreme Court has opened a door and is saying to it's inviting us, urging us to review Section 184.4 and make sure that rights and freedoms are respected. There are some aspects that are problematic. We're removing peace officers and replacing that by police officers. That's fine. And other persons. Well, I'm sorry, but other persons is anybody. At least before it was restricted to peace officers, but now other persons can involve people who aren't even peace officers, and that's a problem. That's unacceptable. One has to understand that CSIS officers are not police officers under the law. Members of the armed forces who work at the Telecommunications Security Agency are not peace officers under the law. People at Echelon, same thing, exchanges of information with Interpol. So reviewing 184.4 is important, but it has to be overseen by organizations that oversee these organizations. Now, that's the problem. We have the case of Dr. Porter. This individual was being sought out for fraud and corruption, even though he oversaw CERC. His only qualification for running this agency was that he was a friend of the Conservative Party. I think that this criterion of friendship with the Conservatives is not a serious one. So we have to make sure that CSIS, the RCMP, the communications organization are all supervised by people who will tell their members, this is the law, you are obligated to respect it. Now, we indicated the problem of other persons, the need for oversight by serious structures that have qualified people, not just cronies of the Conservatives because they're bagmen during a campaign. There's the whole problem of other means. Other means is a lot. We're talking about wiretapping as well as interception of private communications. The notes we write to prepare speech, is that a problem? A sermon? So in closing, I'd like to point out that in democracies, we've had wiretap scandals, wiretapping by newspapers. In France, security services were used by President Sarkozy to get rid of certain adversaries. In the U.S., unfortunately, we remember that intelligence services were perverted to solve problems. So that's the problem with C-55. This is what the NDP wants to do to protect citizens. Thank you.
Comments? Questions et commentaires? La députée de La Salle-et-Mar.
The Honourable Member for La Salle-et-Mar. Thank you, Mr. Speaker. I would like to thank my colleague for his speech and also for the important points that he has raised. Normally when we present a bill, we seek to strike a balance between the objectives that respond to the Supreme Court case with regard to oversight and public safety, but also a balance with regard to human rights, basic rights, our Constitution, and the Charter of Rights and Freedoms. So I would like to know from my honourable colleague whether he considers that this bill achieves this balance, and also, if this balance has not been achieved, what he thinks should be done to ensure this balance. The honourable member for Marc-Aurèle-Fortin. I would like to thank my colleague who has the same idea about this bill as I do. It is important to protect our citizens, but in the current case, there are things that open the door to so many possibilities of abuse that it is unacceptable. If we define other technical means, well, I'm sorry, that concept is too broad. It means that someone's office could be opened and documents stolen. That's too broad. Now, police forces can have this authority, but when we talk about other persons, well, that's just too broad. Before, at least this concept was limited, but now other persons can be anyone, so we need to tackle this problem in this bill. Also, to whom are they accountable? And that's where the problem lies as well. Can we trust organizations who look after the protection of citizens? Well, that's not the case right now, unfortunately.
The honourable member for Winnipeg North.
Speaker, the issue really is the warrantless access, and the 184.4 allows today for that to take place. I think from an opposition point of view, whether it's been from the Liberal Party, and I believe in most part from the Democratic Party, the idea of safeguards is something that we've talked a lot about. And I'm wondering if the member might provide some thought, precise thoughts in terms of what he would think would be a good safeguard for 184.4. Does he have a personal feeling as to what could protect the privacy rights of an individual that he could see potentially in the form of an amendment or something of that nature?
Deputy de Marc-Aurèle.
Honourable member for Marc-Aurèle-Fortin. That's an excellent question, Mr. Speaker. And I would say that it is based on people's accountability. Unfortunately, over the past 2 years, we've seen through omnibus bills and administrative restructuring, further to cuts, we've seen that the police oversight organizations have been cut. Ombudsman, for example, and that's where the problem lies. When we talk about the Arar case, we saw the Justice produce a major report that talked about security forces in Canada and that indicated to whom they were accountable. The problem with the RCMP is that they sent an individual to be tortured in Syria, and they were not accountable to anyone. It was before a parliamentary committee a few years later that people finally realized that this could not go on. And that's the problem. Who is going to supervise the enforcement of this bill by the police forces and other people? Thank you. Resuming debate, the honourable member for Laurier-Sainte-Marie. Thank you very much, Mr. Speaker. I am very pleased today to rise in this House to speak to Bill C-55, an act to amend the criminal code with regard to R versus C. Mr. Speaker, it has been some time now that we have known that we must amend certain provisions of the criminal code. In fact, the Supreme Court decision in R versus C dates from about a year ago. In fact, over 10 months ago. And the decision was clear. It stated that the provisions of Section 184.4 of the Criminal Code must be amended. These provisions, Mr. Speaker, as we know well, allow for the interception of private communications without pre-authorization. I would just like to clarify something at the outset. We have no problem, we in the NDP, with the fact that, yes, in some cases, in order to save lives, for questions of public safety, that there are occasions when it is important to intercept private communications without obtaining a prior authorization. However, when this is done, because this is really an extreme, but there have to be safeguards. And what the Supreme Court said in R versus Say is that the existing safeguards are insufficient. Safeguards to ensure that there are no abuses and that there is no undue interference in the private affairs of Canadian citizens. Also, safeguards that ensure that at all times the basic principles of privacy are respected. And as some of my colleagues have said, when we see what is happening in organizations such as CSIS, oversight organizations where there are serious problems, where there were very dubious appointments, for example, it is all the more important that we have a legal framework that is strict and also very clear. In short, the court asked this Parliament, this government, to remedy the situation, something that is very important to do. But what did the government do in the meantime? Well, the government introduced Bill C-30, a very bad bill, Mr. Speaker, a bill that mixed up all kinds of things, a very hastily cobbled together bill that did not provide for any more safeguards, but on the contrary increased the powers of the police forces to intercept private communications. You might remember, Mr. Speaker, we on this side of the House, we opposed Bill C-30, and we were not alone. Many Canadians across the country spoke out strongly against this bill. I know that in my office I received hundreds and hundreds of emails and letters from people who were opposed to C-30. And when we voiced our opposition, we were called all kinds of names. We said that the government said that we stood with pedophiles and with child pornographers, and the government treated us with its usual arrogance, but we saw that, as has happened all too often, this government, its arrogance, it had to swallow its arrogance, and that's what happened in Bill C-30. In the case of C-55, we can very graciously admit that this is a bill that is somewhat better. Now, that being said, there remains a problem. This bill has been presented for very hasty adoption. Mr. Speaker, the decision R versus Say was handed down on April 13th, 2012, and at that time the court gave us 1 year to remedy the situation. So that's been almost a year, and finally, this bill has been introduced, a bill that is a step in the right direction to rectify this situation. In fact, that allows us only 19 sitting days to debate this bill at second reading, to send it to committee, and to come back to the House at third reading, and then all the subsequent process. Now, that is a very short time, Mr. Speaker, and that is so typical of this government. They always do this kind of short-sighted work. I work on international files, and I'm always fascinated. I can't believe the short-sighted vision this government has. We're talking about a year here. Couldn't they have gotten things going earlier? Couldn't they have started planning so that we had more than 19 days of debate? It's somewhat distressing. Or perhaps the government hopes that the bill will just go through very, very quickly.
Faut assurer la sécurité, mais aussi.
Mr. Speaker, we need to strike a balance between the protection of privacy and the protection of public safety. So that's not a problem, but we need to do so properly. And a great many people are worried about this bill in its current form as it has been drafted. So here are a few examples. In the bill, it is referred to, peace officers are referred to, who have the authority to intercept communications, but a peace officer, this concept is not defined. Could it be a private security guard? Could that be someone who is considered a peace officer? There is also the issue of how much time it takes before a person must be notified that their conversations have been intercepted. Should it be 30 days? Should it be 90 days? In some cases, even a time period of up to 3 years has been proposed. So what is the right balance to strike here? Another even more fundamental problem, Mr. Speaker. What has been done to ensure that the legislation truly complies with the Supreme Court decision? What type of assessment mechanism has been put in place to ensure that in 6 months or 1 year or 2 years, we won't have to go before the Supreme Court again? You know, this government seems to think that the executive branch does not have to be accountable to anyone and is above the law. But that's not true, Mr. Speaker. The Charter and the Constitution are more important than the Conservatives' political agenda or that of any other party. So in committee, we will have to study these concerns very attentively because Canadians have good reasons for being concerned about Conservative bills with regard to their right to privacy, because we know that they do not have a stellar record in this regard, on the contrary. And in any case, it is not very good to study bills too rapidly. We need to act, yes, but we need to do things properly. We only have 19 sitting days to get through, to do this job, Mr. Speaker. Obviously, we're going to roll up our sleeves. We're going to work diligently. But this haste on the part of the government, I think, unfortunately, shows its lack of professionalism and its lack of respect for Parliament, which is, at the end of the day, a lack of respect for Canadian citizens who have the right to expect that the Parliament should work diligently on such important matters. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Saanich Gulf Islands.
Merci, Monsieur le Président.
Thank you, Mr. Speaker, and I would like to thank my colleague. I have a question for her because perhaps I don't understand the point concerning the definition of police officers, because in this bill, C-55, since the Supreme Court required that the Parliament must come up with a clear definition of a police officer. It is not a peace officer, but I think perhaps there is a problem with the words any other person who is tasked with maintaining public order. Perhaps it is that point, and I would like to ask my colleague what she thinks of this. The Honourable Member for Laurier-Sainte-Marie. Thank you very much, Mr. Speaker, and I would like to thank my colleague because, yes, she is right. It is any other person who is tasked with maintaining public peace and order, and until such time as we get a clear definition of that. Listen, we're talking about a potential of violating a very fundamental human rights, so we have to be very stringent, very accurate, and we do need a clear definition of that term, like all other terms. Thank you, Mr. Speaker.
The honourable member for Burnaby, New Westminster.
Thank you very much, Mr. Speaker. I would like to thank my colleague from Laurier-Sainte-Marie, who is very experienced. She has experience here in the House, and we saw that with her speech here today, that she brings forth a great many facts and very clear examples of C-55. She noted that starting this morning, we had 19 sitting days left to adopt this bill, which has only just been introduced. And now, I'm looking at the time, well, the first day has already elapsed, and we have heard no response to any of the questions that were asked. As of this morning, even though we asked questions of the government, the member from Gatineau, the member from Halifax, and the member from Laurier-Sainte-Marie, and many others, but the government has given absolutely no response. So they've wasted an entire day, even though they have introduced this with a great delay, and they knew that they had only a year. So I would like to ask my colleague, why does she think that the Conservatives treat these files with such a lack of respect? Why are they not organized in their approach to something that deals with a Supreme Court decision that dates from a year ago? The honourable member from Laurier-Sainte-Marie. Thank you very much, Mr. Speaker. Listen, I think that there are two problems here. The first problem, and it is probably the major problem, is that we are dealing, we're in Parliament here, and as a Francophone, I understand that this is a place to dialogue and to reach fair and good solutions. But unfortunately, in my short career as a parliamentarian, I have seen that we are dealing with a government that has no interest in dialogue. So there is no interest they have no interest in debating subjects that we're supposed to debate. We've seen it in Parliament, we've seen it in the country, and we can see it across the planet. It's as if this is a government that is totally ignorant of this notion of what working together is. And obviously there's the other question that has raised concerns among many citizens. I've heard of my constituents have contacted me about this. It is the respect for the various institutions that compose the Canadian democracy, including the respect for the Constitution, for the courts, and for the Charter of Rights and of Human Rights and Freedoms. Obviously, this is something that is so much more fundamental than any kind of political gains in the near term.
Honourable member for Burnaby, Douglas.
Mr. Speaker. Very kind, thank you. Mr. Speaker, I'm pleased to stand today to address Bill C-55, an act to amend the Criminal Code. What I want to do is speak a bit about the specifics of the bill and our thoughts about this bill, and then move to what I think is a bigger question, and that's the balance between protecting the privacy of citizens and then collecting the information we need to make proper policy decisions. So again, we'll go through the specifics and then move to this bigger question. And although I support this bill, and we support this bill in general, and think it should go through to the committee for more scrutiny, I think the government has perhaps an unbalanced or perhaps even inconsistent approach to these issues, and this is worth discussing. So in terms of the details of Bill C-55, this bill concerns safeguards in relation to authorization to intercepting private communications without prior judicial authorization. Quite a mouthful there. But basically, we're looking at wiretapping or intercepting private communications, or the state intercepting private communications. This bill requires the federal government and provincial attorney generals to report on interceptions of private communications. Secondly, that the person who has had their private communications intercepted has to be notified. And then, again, this bill narrows the class of people who can make such an interception. So again, seem to be reasonable measures, and all these measures, of course, will be considered by any other country around the world and any other government that has to undertake these kind of measures. So again, these measures seem to be reasonable to us. We'll be supporting this bill, at least in the second reading. We'll see what kind of shenanigans the committee members get up to, but we'll make sure that the committee has enough time to go through this. I also want to say, Mr. Speaker, that I'll be splitting my time with the member from Pienfont-Dolac. So wiretapping is really what this bill is all about. Although we're calling intercepted communications, we're really talking about wiretapping. And wiretapping has quite a long and sometimes dark history in Canada, and its proper use deserves our full and careful attention. In fact, Mr. Speaker, the creation of our current Security and Intelligence Service, that's CSIS, has its origins in this whole issue as agents of the state, police, RCMP, in this case, illegally collected information on citizens during the 1970s. And there was such an outcry of this, mainly from Quebec, that there were a number of task forces that were looked into this, and then they said, well, the RCMP has too much power centralized, so we need a separate security service, and that's where we got CSIS eventually. Really, and the problem in this case was the RCMP overstepped its bounds and collected hundreds of hours of illegal wiretaps from Quebec citizens. Some were worthy, but others were just, again, to collect information about people because mainly at the whim of state agents, in this case the police. So records also show, Mr. Speaker, that this practice had been going on for quite some time and outside the boundaries of Quebec. So again, after quite an uproar here across the country, as CSIS was created, and again, we've been wrestling with these issues, and we'll always wrestle with these issues as to where do the boundaries lie between privacy and collecting necessary information. So we need to take care that these really past injustices and misuse, maladministration of justice don't happen again, and that wiretapping only be used in legitimate circumstances, and that the practice be as transparent as possible. So if I'm going to return to the text of C-55, let's be clear first that this bill is simply an updated version of previous conservative-initiated wiretapping laws that the Supreme Court deemed unconstitutional. This isn't a new initiative, and in fact, we're just cleaning up a bit of a mess here. And due to this mess, the courts have established new parameters for the protection of privacy, and we really need to ensure that this legislation meets these new requirements. So we need to make sure the committee takes the time to get this right, and we give them ample time to make sure they get it right this time. Now, we want to make sure that the committee takes the time because, especially when the government is crafting the post-committee version of this bill, because the conservative record in this area shows, again, that conservatives are prone to mistakes in this area. And I really want to talk about this a little bit. It's this whole idea of balancing the need to collect information from citizens to make policy, whether it's security, whether it's economic assessments, or whether it's making other policy decisions in other areas, and of course the citizens' need for privacy and really right to protect private communications. The government really needs to make sure they get this balance right. And we saw before that C-30 was judged as too intrusive. It went too far in terms of prying into the private lives of citizens. However, I want to talk about the other side, too, where the Conservatives have erred in terms of perhaps not being clear on what information is important to collect or what they're willing to do in terms of making proper policy decisions. Now, there is a certain wing of the Conservative Party, the Libertarian wing, such as the member from the P and Carleton, who would say, well, the state has no business at all in the lives of citizens. And of course, we know that in its pure form, that can't be true. Otherwise, that would be anarchy. So what we need to do is make sure we strike the right balance. And I'm afraid the Conservatives do get it wrong on a number of occasions. For example, Mr. Speaker, the Conservatives have used the excuse of privacy to abolish the long-form census. And the effects of this action will be felt throughout Canada for years to come. So using the kind of smokescreen of protecting citizens' privacy, we've abolished a tool that's been not just in use in Canada, but all developed countries and almost all countries around the world now, in order to inform their policy decisions. So, for example, without the long-form census, we still have the short-form census, which is still mandatory, but it contains very little information. The long-form census, which goes to a smaller proportion of the population, collects very valuable information that, for example, being somebody who used to work in city planning, cities need these things to plan properly. So where do you know where you're going to put a new school, or maybe what languages should be highlighted in that school? You get that information from the long-form census. If you're a business that's looking to target a particular neighborhoods, wondering if your business will do well there or not, businesses will not be able to determine target markets with any accuracy. And in fact, without long-form census, the policymakers will have to fly blind in many areas without these valuable statistics. So we're going to be feeling the ripple effects of not having a long-form census for many years to come. And the community, many community members felt very, very strongly about this. And in fact, the head of Statistics Canada felt so strongly that he resigned when the long-form census was abolished. So this is what I mean by the balance between privacy. The Conservatives are keen to wiretap people and to really open that up and not have it be transparent. But on the other side, they're not willing to allow the state to collect the information that it needs to make proper planning decisions. So some of my colleagues in this House have raised the specter of the Conservatives abolishing other surveys with mandatory requirements. So we've had the long-form census abolished because, again, the reasons given on the other side was because it had a mandatory reporting requirement. But, for example, Mr. Speaker, we have the labor force survey, which is mandatory. We have business surveys and other agricultural surveys, which are also mandatory. So my question for the Conservatives would be, where do they fall on these issues? Will the government use the name of privacy in vain in order to abolish these critical surveys, or will they cave into their radical libertarian wing? So again, it's not just an imbalance between protecting privacy and the state gaining policy, information that needs to make policy. It's also that it's a very inconsistent application. There's no single rule that the government's using in terms of judging or making its policy decisions. So, Mr. Speaker, for example, if we abolish the labor force survey, we would probably be kicked out of the OECD. This would not allow us to calculate our unemployment rate, and we wouldn't be able to accurately report to international organizations with any accuracy. So maybe when the Conservatives are asking questions on that side during this, after we finish my speech, this is very soon, perhaps we can have a bit of a debate about where they see the balance sitting between protecting privacy and collecting proper information. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires? L'honorable député de La Salle-et-Marne.
The Honourable Member for La Salle-et-Marne. Well, thank you very much, Mr. Speaker. And I'd like to thank my colleague for his remarks, and especially for having spoken from a very interesting angle. Now, he is our critic for technology and has followed the matter very carefully. Mr. Speaker, when we talk about science, we're talking about data, facts, that enable us here in Parliament to make informed decisions. I'd like to ask him, because in his conclusion, he mused about whether this bill or bills in the House are balanced in that way. Balanced between the aspect revolving around public safety, security. Government bills are often, in many cases, based on sensationalist headlines. But do we have a balance between public safety and privacy and the protection of private information? I'd like my colleague to comment on that.
Member for Burnaby Douglas.
Thank you, Mr. Speaker, and I thank my colleague from the Salle-et-Marne for her good question and, of course, her very, very good work on the Industry Committee and as our industry critic. She's doing fine work, and it's a pleasure to work with her. In terms of a balance, I don't think the Conservatives have this right, and in fact I worry about the premise of how they design policy in this area at all, or the base premise that they use. For example, I think that many members on that side of the House find the Charter of Rights and Freedoms an inconvenience. I think that they, if they had their way, they would probably abolish it if they had a chance. And I think that way they'd be able to, again, pursue these lines of inquiry. They would intrude into people's privacy in the name of crime and punishment. And I think that's a mistake, Mr. Speaker. And we have to be vigilant to make sure that they're not allowed to do that. Thank you.
Questions and comments? Question et commentaire. The honourable member for Hamilton Mountain.
Thank you very much, Mr. Speaker, and I've been following the debate all day and certainly know that the courts have established new parameters for the protection of privacy, and we, and I think all Canadians, would expect that this House follows those parameters. But I think most Canadians who were here for the debate on Bill C-30 have good reason to be concerned about the Conservatives' privacy legislation, and their record in this regard is far less than encouraging. I know the member talked about that, or he started to talk about that in some detail, but I think for folks in my community of Hamilton Mountain, that is probably the #1 concern. How can we be assured that our privacy is protected, even though we understand that there may be times when law enforcement officials need to be able to access some of that information? There has to be accountability. There has to be oversight. How can we make sure that we're actually living within the spirit of what the courts are demanding of us? And I just wonder whether the member might want to take a couple of more minutes, because I know that his time here was brief, to just talk about those issues in a little more detail. Thank you.
The honourable member for Burnaby Douglas.
Thank you, Mr. Speaker. And I thank my colleague for her great question. I mean, really, in all these matters, the key word is reasonableness. Is that the state has to be reasonable. It's a democracy. We're elected here to make laws for Canada under guidance of the Charter and our Constitution, as well as, of course, Supreme Court rulings, treaties, and other things. But I really think it's for us, as we sit here, is to think, how would an average Canadian think about these particular laws? Is this intrusive? Is this too intrusive? Is this getting the information we need? And I feel that on that side of the House, they haven't been reasonable in many cases. Is that they've been pursuing a line, an ideological line that, again, is inconsistent. The two sides of their party are battling. You've got you have the social conservatives who would like to intrude in all aspects of life, and then you have the libertarians who would like the state to be non-existent. And I think this causes them a lot of trouble on the other side of the House. And again, it's up to us to be vigilant to make sure we are reasonable in the laws we propose in this place. Thank you, Mr. Speaker.
Reprise de débat, resuming debate. L'honorable député de Pierrefonds-Dollard.
Member for Pierrefonds-Dollard. Well, thank you, Mr. Speaker, and I rise today to participate in the debate on Bill C-55, an act to amend the Criminal Code, following on the heels of the R versus Say decision by the Supreme Court. Before I delve into Bill C-55 more specifically, Mr. Speaker, allow me to provide some context that led to the tabling of this bill. In R versus Say, the Supreme Court said that Section 184.4 of the Criminal Code, which is talking about wiretapping under exceptional circumstances, which was adopted in 1993, was unconstitutional because it did not contain measures for accountability. The Supreme Court gave the Parliament until April 13th, 2013 to amend that part of the Criminal Code in order to make it consistent with the Constitution. So the Parliament has until April 13th, in other words, 19 days, during which Parliament will be sitting to work on this bill before the expiry of the deadline set by the Supreme Court of Canada. And I'll go back to that a bit later, Mr. Speaker, but it's an important part of today's debate. Now, what is Section 184.4 of the Criminal Code? What does it deal with precisely? What does this whole situation revolve around? This section of the Criminal Code talks about a peace officer intercepting using an electromagnetic, mechanical, or acoustic tool communications of a private nature if the following conditions are met. A, reasonable means to assume that the urgency of the situation is such that without due diligence, it's important to B. It is likely to believe that the immediate interception, is responsible for intercepting something that will cause serious damage. And I'll come back to this issue as well. And C, either the originator of the private communication or the person intended by the originator to receive it is the person who would perform the act that is likely to cause the harm, or is the victim or intended victim of the harm. So in Section 184.4, interception in exceptional circumstances, the peace officer may intercept certain private communications without pre-authorization if there is reason to believe that there is a serious danger present. If there is a possibility of preventing an unlawful act that would cause serious harm, and when in fact the necessary authorization cannot be obtained quickly enough. So this is an important aspect here, Mr. Speaker. It's an important part because if a peace officer has serious reasons to believe that there can be serious harm caused and that waiting for an authorization to listen to the conversation could prevent him from preventing, or waiting for that would prevent him from dealing with the serious harm, this is an issue. Certain peace officers have to have that kind of flexibility under certain circumstances. Now, where we bring in the relevancy of Bill C-55 is because we need to establish a balance between providing this opportunity for peace officers to do their job and to protect the community, which is very important, but at the same time, to strike this balance I referred to guarantee individuals' privacy is respected. So they might not be in fact under a warrant without even knowing it. Someone may say that there is reason to listen or intercept a communication. So this is the dilemma we're facing. Where are the limits between allowing a peace officer to do his or her job while at the same time protecting privacy rights for individuals? Now, the first proposal by the Conservatives on this issue came out in Bill C-30, and we all heard talk about that because it gave rise to an outcry, a public outcry in the media, entrepreneurs as well, and many groups. There was a huge demonstration against Bill C-30, and as a result, the Conservatives abandoned it because clearly it was very worrisome, and there were reasons, in fact, for being concerned with that bill. So the problem remained. Section 184.4 violated a part of the Canadian Charter of Rights and Freedoms, and they needed to deal with that. Now, I'd like to take a step back here. However, why is Section 184.4 considered to violate the Charter of Rights and Freedoms? Because it doesn't include any kind of oversight mechanism, nor does it require any notice to be given to the person whose private communications have been intercepted. This violation can only be validated by Section 1 of the Charter. So that goes back to what I was saying earlier. We're trying to strike a balance here. If a part of the Charter is being violated, a section of the Charter, which is this Charter that is so important to all Canadians, it can't be contravened by a section in the criminal code. Now, that is what led to this debate on C-55. This bill, first and foremost, imposes on the Minister of Public Safety and Civil Protection and on the Attorney General for each province an obligation to report on the interceptions of private communications made under Section 184.4. So these are regulations that require oversight and reporting. It also provides that a person who has been the object of such an interception must be notified of the interception within a specified period, not months later. But this will once again regulate the oversight by reporting on it and also notifying a person whose communications are being intercepted. Thirdly, it narrows the class of individuals who can make such an interception. That too is important. And we need to clearly define who is authorized to conduct this kind of interception, and to finally limit those interceptions to offenses listed in Section 183 of the Criminal Code, which also covers interceptions.
Mr. Speaker, we support this bill at second reading so that it can be referred to committee for all the reasons I gave. Yes, there's a shortcoming here. The Supreme Court of Canada is calling on the Parliament of Canada to fix things. So let's go ahead with this. Let's study Bill C-55 seriously. I talked a bit earlier about C-30, which created quite a controversy among the public. But C-55 is not at all what C-30 was. It's different, and so that's encouraging. We should look at it. It gives us a better starting point for our work in trying to make sure that we fix what the Supreme Court of Canada has required us to fix. However, it must be said that it's essential for investigations to include this type of communications and wiretapping and so on. That's what the court said. We agree, but you have to respect the rule of law, the Constitution, and the Canadian Charter of Rights and Freedoms. That's why we think this needs serious review in committee. We need to make sure that this bill, C-55, is not another C-30. We have to make sure that this is done right. In the minister's speech a bit earlier, he said, yes, don't worry. We've made sure that the Charter and the Constitution are complied with in this bill. But we'd like to know how the minister made sure. We hope he didn't do the same thing that he did with C-30, because that would hardly be reassuring. Who was consulted? What process was followed to make sure that C-55 would indeed be Charter and Constitution proof? This is important. It's not just important. We're not just saying that. There are a number of cases where the Conservatives have put forward legislation without listening to the experts, without following democratic process, and then afterwards, bills had to be changed, withdrawn, reworked. It was a waste of time for members, and it's not efficient. But that's what happens when the government puts forward bills with huge holes in them that don't respond to the expectations of the public. So yes, let's give this bill some serious consideration at committee. It's in the interests of all Canadians. Thank you, Mr. Speaker.
Questions et commentaires, questions and comments. L'honorable député de La Salle-et-Mar.
The honourable member for La Salle-et-Mar. Thank you, Mr. Speaker. And I'd like to thank my colleague for her speech. She mentioned the fact that there was Bill C-30 and that this one's different. That may be, but this bill will have to be studied in committee too. We're going to have to make sure that the amendments are made and that this bill is perfected. So I'd like to know from my colleague whether she thinks this bill we have before us, would benefit from any recommendations that could be made at committee. The honourable member for Pierrefonds-Dollard. Thanks to my colleague for her question. Unfortunately, I didn't have time to deal with this in my speech, so I was hoping to have the opportunity later. So yes, indeed, there are some words, there are some aspects of this bill which lead us to think that there is room for some teamwork at committee. For example, Section 2 of the bill states currently the definition of police officer, and in 184.4 they talk about without restricting the scope of So we need to be careful that the terminology is very specific and precise. We have to look at how the wording could be interpreted. That's just one example of things in the bill that we'd like to work on together at committee to make sure that this bill does indeed meet the Supreme Court's concerns. Questions and comments?
Member for Winnipeg North.
Yes, thank you, Mr. Speaker. And I appreciate the comments made from the minister. There was one other aspect that we had talked about a little bit earlier in the day, and I was just interested in her thoughts on it. And that was in regards to the whole timing of the introduction of Bill C-55. We have felt that the government did have plenty of time in order to bring the bill forward, and question why it is that they waited so long before we ultimately had the opportunity to be able to debate the bill. The government has sat on it for almost a year, and now today we're being asked to not only pass the bill through into committee, but committee stage, third reading, and so forth before April the 12th. And I'm wondering if she might want to provide some comment on that aspect in terms of how we're expected to expedite the passage of the bill.
The honourable member for Pierrefonds-Dollard. Thank you, Mr. Speaker. Yes, indeed, all opposition members are disappointed at the sight of a bill like C-55. Given its importance, this should have been brought forward and tabled in the House a long time ago. Now we have only 19 days to give this bill serious consideration and to make sure that it meets expectations. 19 days. Why did they wait until 19 days before the deadline set by the Supreme Court of Canada? Mr. Speaker, perhaps if the Conservatives hadn't done something as crazy as C-30, we wouldn't be in the situation we are today with only 19 days to work on the bill. If we work properly, if they were to work seriously, listen to the experts and put aside partisanship, then perhaps they could bring forward promising legislation, good bills that would meet the needs and wouldn't have to be changed and fixed and withdrawn and worked over again. So when the work is done right, it benefits all members and all Canadians. Thank you. Questions and comments? The honourable member for Saint-Bruno-Saint-Hubert. Quick question, please. Yes, thank you, Mr. Speaker. I listened closely to my colleague's speech, and she did say that this bill was the successor to C-30, which we know was a dismal failure for the Conservatives. As she just said, this merely proves that the Conservative government is a bad pupil. And yet the Supreme Court of Canada asked the government a year ago to take Section 184.4 and to amend it to make it constitutional. And unfortunately, we only have 19 days to do that. I'd like to hear my colleague on that. The honourable member for Pierrefonds-Dollard. A quick answer, please. I'll give you a quick answer and a clear answer, Mr. Speaker. The work, as I said a bit earlier, when you do the job right, when you do it seriously, when you respect the institution of Parliament, that work can be done in a win-win way and would maximize our chances of a good result. I hope the Conservative government has learned from its mistakes and in future will proceed in a much more sensible, intelligent, and responsible fashion. And I could go on, Mr. Speaker.
Resuming debate, reprise de débat, the honourable member for Sudbury.
Thank you, Mr. Speaker, and I'd like to thank my colleagues for that great round of applause as I start my speech on C-55. And of course, Mr. Speaker, I'm very pleased to rise today to stand up and talk about our points relating to an act to amend the criminal code in response to the Supreme Court of Canada decision. And of course, Mr. Speaker, I know we're coming to this now with 19 days to go before we're seeing this supposed to be taken care of, Mr. Speaker. So, of course, we recognize the importance of this as New Democrats, and we will be supporting this at second reading, Mr. Speaker. We're in favour of sending this legislation to committee for its review. This enactment, Mr. Speaker, amends the Criminal Code to provide, in response to the Supreme Court's decision, safeguards related to authorization to intercept private communications without prior judicial authorization under Section 184.4 of the Act. Notably, the enactment, A, Mr. Speaker, requires the Minister of Public Safety and Emergency Preparedness and the Attorney General of each province to report on the interceptions of private communications made under Section 184.4. B, provides that a person who has been the object of such an interception must be notified of this interception within a specified period, Mr. Speaker. C, it narrows the class of individuals who make such an interception, and D, it limits those interceptions to offences listed in Section 183 of this criminal code, Mr. Speaker. Now, we know we were talking earlier about, or I was talking earlier about how this really has come down to 19 days. But if you were looking at what the Conservatives have been doing over the last year, and I believe my colleague from Winnipeg North asks this question repeatedly today, because they've had a year, Mr. Speaker, to act on this. And why now, in the 11th hour, are we having to deal with this so quickly? If you're really truly looking at what can make great legislation, is the debate and the involvement of all members of Parliament from all sides. But once again, Mr. Speaker, we see the Conservatives bringing forward legislation at the 11th hour where we all have to come together very quickly and try and pass something where we, of course, want to give it its due diligence and want to, of course, give it a good once-over. But unfortunately, what we've seen time and time again from the Conservatives, Mr. Speaker, is the lack of the opportunity for debate. How many times is it now that the Conservatives have used time allocation to shut down debate when it comes to important bills, Mr. Speaker? I believe we're up into the 20s, if not 30s, where we're looking at budget bills, other legislation affecting the services that Canadians rely on, shut down at every opportunity. And so, Mr. Speaker, it's unfortunate that we once again have to come to an 11th hour compromise, or an 11th hour conversation rather than compromise, to ensure that we can get legislation to committee. I think, Mr. Speaker, this new legislation is simply an updated version of the wiretapping provisions that the Supreme Court had deemed to be unconstitutional, and the Court has established new parameters for the protection of privacy, and we expect this legislation to be in compliance with those standards, Mr. Speaker. Canadians have a good reason to be concerned about Conservatives' privacy legislation, Mr. Speaker. The record in this area is not very encouraging. We need to continue working for the public to uphold the rule of law, Mr. Speaker, the Constitution and the Canadian Charter of Rights and Freedoms. If we just go back, Mr. Speaker, not too long ago, we had the inception of Bill C-30. And so back in February of 2012, the Conservative government tabled Bill C-30, which would give authorities the power to access the personal information of Canadians without a warrant. And that bill, Mr. Speaker, raised serious concerns about personal privacy and the fundamental rights and freedoms. C-30 was a compilation of 3 bills that made up lawful access in the last parliamentary session. So that was even going back further, Mr. Speaker, C-50, C-51, and C-52. And the Conservatives were then building on legislation that was first spearheaded to propose providing public safety authorities with surveillance powers over their digital information in 1999. And this, Mr. Speaker, led to a huge uproar from people from coast to coast to coast, concerned about this legislation and how it was going to enable law enforcement to access citizens' personal information without a warrant, Mr. Speaker. So right now, Mr. Speaker, we've seen the Conservatives quickly have to change their tune when we've seen this new bill being brought forward. So with the government trying desperately to comply with the Supreme Court ruling, within the prescribed time frame, which is April 13th of 2013, the Supreme Court of Canada ruled, and I'll give you this authorization, or what they were saying, that the authorization of the emergency power to intercept without authorization by the court in situations of imminent harm could be justified under the Canadian Charter of Rights and Freedoms, Mr. Speaker. The Supreme Court held that Section 184.4 of the Criminal Code, interception in exceptional circumstances, enacted in 1993, was unconstitutional because it did not include any accountability measures. The court gave Parliament until April 13, 2013, to amend the provision and make it constitutional. They proposed amendments, Mr. Speaker, that appeared to be a direct response to that decision in that they add safeguards to constitute notification and reporting under Section 184.4 of the Criminal Code. Mr. Speaker, the legislation would require giving a person 90 days' notice, subject to an extension granted by a judge after his or her private communications have been intercepted in situations of imminent harm. These amendments, Mr. Speaker, would limit the authority of the police to use this provision. All peace officers can avail themselves of it at present, Mr. Speaker, and would restrict its use to offences listed in Section 183 of the Criminal Code. And the proposed amendments appear to be a direct response to the court's instruction, Mr. Speaker. If we're looking at those in a little more detail, Mr. Speaker, 184.4 outlines a peace officer may intercept by means of any electromagnetic, acoustic, mechanical, or other device a private communication where A, the peace officer believes that on a reasonable grounds, Mr. Speaker, reasonable grounds, I think that's very important, that the urgency of the situation is such that our authorization could not, within reasonable diligence, be obtained under any other provision of this part, Mr. Speaker. The peace officer, this is B, Mr. Speaker, B, the peace officer believes on reasonable grounds that such an interception is immediately necessary to prevent an unlawful act that would cause serious harm to any person or to property, and C, Mr. Speaker, either the originator of the private communication or the person intended by the originator to receive it as the person who would perform the act that is likely to cause the harm or is the victim or intended victim of the harm, Mr. Speaker. So more details if you're looking at Queen versus C, Mr. Speaker. This appeal concerned the constitutionality of the emergency wiretap provision in Section 184.4 of the Criminal Code. So in this case, Mr. Speaker, in this case, the police used S-184.4 to carry out unauthorized, warrantless interceptions of private communications when the daughter of an alleged kidnapping victim began receiving calls from her father stating that he was being held for ransom. Approximately 24 hours later, Mr. Speaker, the police obtained a judicial authorization for continued interceptions pursuant to Standing Order 186 of the Code. And the trial judge found that 184.4 contravened the right to be free from unreasonable search or seizure under Section 8 of the Charter, and that it was not a reasonable limit under Section 1. The Crown appealed the declaration of unconstitutionality directly to this court, Mr. Speaker. The Supreme Court dismissed the appeal. Excuse me, Mr. Speaker. Section 184.4 permits a peace officer to intercept certain private communications without prior judicial authorization.